I'm getting... Right. Thank you very much. So, good morning, members, officers, and any members of the public who are viewing the live stream. Welcome to this meeting of South Cambridgeshire District Council Planning Committee on the 15th of January 2025. My name is Councillor Anna Bradnam and I'm chair of this committee. Firstly, we'll introduce the members. So firstly, Councillor Peter Fane.
Thank you, Chair. Peter Fane, Vice Chair, Councillor for Shelford. One of the councillors for Shelford.
Thank you. Councillor Hawkins.
Morning everyone, Timmy Hawkins, Caldecott Ward.
Thank you. Councillor Khan.
Morning everybody, Martin Khan, Councillor for Histon and Impington.
Councillor Ariel Khan.
Good morning everyone, I'm Ariel Khan, Councillor for Horston and Cumberton.
Thank you very much. Councillor Garvey. Your microphone is not on. Do you want to say that again?
Corinne Garvey from Councillor for Girton, Drydrayton, Madingley.
Thank you very much. Councillor Redrup.
Thank you, Chair. Good morning, everyone. I'm Lisa Redrup. I'm one of the councillors for Horston and Cumberton Ward.
Thank you very much. And Councillor Jackson-Wood.
Hello, good morning. Councillor Jackson-Wood. I'm one of the members for the Shelford.
Thank you very much. And Councillor Sandford.
Good morning, everyone. Councillor Peter Sandford, one of the members for Caxton and Papworth Ward.
Thank you. Councillor Dr. Richard Williams.
Richard Williams, Whittlesford Ward.
Thank you. And Councillor Heather Williams.
Morning all, Heather Williams, I represent the Mordens Ward.
Thank you very much. And we have with us the officers. Firstly, Jane Rodens.
Jane Rodens, Area Development Manager.
Thank you. And Rebecca Smith.
Morning, I'm Rebecca Smith. I'm one of the delivery managers.
Thank you. And our legal officer.
Apologies, I'm Richard Pitt. I'm the legal officer for the committee.
I don't know if you can hear that through my microphone.
Sorry, Chair, I will need to do this back.
I'll do it through your sure, if I just speak into that.
Yes.
So morning members, I'm Richard Pitt, the legal advisor working for 3C Shared Services.
Thank you very much. And Simon Hill.
Yes, I'm Simon Hill, I'm the committee officer.
And our producer today is Aaron Clark.
Yes, sorry, Chair.
No, he's busy. And thank you very much. Okay, so we know who everybody is, and welcome very much. Welcome to the people who've attended in the public gallery. Thank you very much for attending. So, those in the chamber are reminded that the meeting is being live streamed. By your presence here in the chamber and via video conference, you're deemed to have consented to being filmed and to the use of images and sound recordings for a webcast and archived recording. May I ask those who are joining us remotely to ensure that their camera and microphone remain off unless you're addressing the committee. And before we start the meeting, I've agreed with officers that the item 7 at Branch Road, Comberton, will start after 11:30 to allow members of the public interested in that item to be present. That was the earliest some of them could attend. Could I also point out that we've been issued a supplement on the 14th of January, which is on our tables, which has updates relating to items 5, 7 and 9. So that's the scheme of delegation, the Comberton site and the site at Willingham. Can I remind members that after the start of an application, once the application has started, if a member leaves the chamber, that member will not be able to take part in discussion or enter into debate or questions of clarification or vote. So once an application has started, we must stay. If we need a break, then we'll take a formal break, but we must stay to the end if you want to be able to take part in that and to vote. Thank you very much. So, number 2 is apologies. Simon, are there any apologies for absence today, please?
Yes, Chair, we have apologies from Councillor Jeff Harvey and Councillor Bill Handley, and we have substitutes of Will Jackson Wood and Corinne Garvey.
Thank you very much. Right, and declarations of interest. If members have any interest to declare in relation to an item of business on this agenda, please let me know. And so, yes, Councillor Redrop?
Thank you, Chair. I'm one of the ward members for Harston and Comberton, and before I was on planning committee back in 2022, I attended a Teams meeting with the developer to learn more about what they were thinking at that point. So a long time ago, I also attended 2 of their consultation events for the village residents, and I went to a village meeting to hear people's views. I didn't express strong opinions on any of the proposals, and having taken advice, I'm intending to participate as I come to it with an open mind.
Thank you very much. And Councillor Heather Williams?
Thank you, Chair. So a series of declarations. First of all, on the scheme delegation that is being referred to Civic Affairs, of which I'm a member. Then on Coat and Orchard, the TPO application, I'm the applicant. At that point, I will withdraw as a planning committee member and sit as the applicant. And in relation to item 8, Land West in Guildham Morden, I'm the local member. I have been present and heard things about the application, but I have not taken part in any debate and will be sitting as a full planning member today.
Fine, thank you. Lovely, thank you very much indeed. And Councillor Dr. Toomey Hawkins?
Thank you, Chair. Regarding item 7, I attended a meeting at the village hall. Must be about 2 years ago now, at the start of the application coming forward, and as an observer, and I have not taken part in anything else since then. And of course, I'm coming to this with an open mind.
Thank you very much indeed. If as the meeting proceeds, something occurs to you, do please raise it at that time. Councillor Ariel Khan.
As with
Could you
Councillor
bring your microphone closer to you, Ariel?
as with Councillor Redrup, I'm also a member of Harston and Comberton Ward for number 7, but I have not taken part in any discussions or debates, and I come to the matter completely afresh as well.
Great, thank you very much indeed. So, moving on to the... Oh, sorry, Councillor Martin Khan.
Just briefly, I did make one visit when to the site at Comberton before about 2 years ago, and I have seen it, but I've not taken any discussions on it, and I come to it with an open mind.
Lovely, thank you very much indeed. I'm sure we'll take those all into account, and the people who will remain here will be taking the matter afresh. Okay, so moving on to minutes. There were 2 meetings in November. Sorry, actually, one's in December. On page 5 of the agenda. This was a largely substituted committee, but I don't know if any... Am I still allowed to sign these off as a true record? Yes. Okay. On behalf of the committee, but yes. Fine. Okay. So, would anybody like to indicate that they are a true record? Thank you, Councillor Heather Williams.
There's myself and Councillor Hawkins that were present, and I'm happy with the record of minutes.
Okay,
If Councillor Hawkins is.
Councillor Dr. Hawkins. Great. Lovely. So we can sign those off. I'll sign them at the end, Simon. And no matters of accuracy. That's great. Thank you. And then Wednesday, the 11th of December, starting at page 9. I'm happy that these are a true record, but would anybody like to second that?
Happy to second that, yeah.
Thank you, Councillor Fain. And no matters of accuracy. Thank you. Okay, so we can sign those off. Lovely. Thank you very much indeed. Councillor Martin Khan.
Just regarding the meeting on the 11th of December, I wasn't present, so
You
I
weren't
abstained.
present. Are you listed as having been present?
Saying that I'm
You-
not,
you're
I'm abstaining rather
You're
than.
abstaining from the approval. No, that's fine. They can be affirmed by the remainder of us. Thank you. Right, so we come to the first substantive item, which is the Planning Committee review, consideration of the matter of the scheme of delegation, which starts on page 15 of our agenda. And this is a report on proposed changes to delegation arrangements for planning matters. We're being asked for our reviews prior to consideration of the changes by Civic Affairs Committee and the Council. And I would remind members this was subsequent to an extensive review through both committees, all three committees, of the various aspects of planning issues that we were seeking to harmonise. So Stephen Kelly, the Joint Director of Planning and Economic Development, and Jane Rodens, the Area Development Manager East, are here to present the report for members. And just for clarity, the recommendations of officers are on page 16 and 17 of our agendas. So Stephen and Jane, would you like to take that forward?
Thank you, Chair. This presentation is to accompany the Greater Cambridge Shared Planning Service Planning Committee Review Scheme of Delegation report and will give an overview of the changes that are being made and the context that they are being made in. As an overview, in 2020, PAS carried out a review of all three planning committees as part of a commitment by the Council and the Shared Planning Service to improve their effectiveness and consistency. A committee review steering group was set up with officers and councillors from both the City and South Cambs to inform the process and align all three planning committees. A report was brought to the three planning committees in August 2024, detailing the next stages of the review and how to implement the 49 recommendations. The Government has also published a working paper on planning committee reforms in December 2024, which is aiming to increase the efficiency of planning committees and ensure that they operate as effectively as possible, focusing on those applications which require member input and not revisiting the same decisions. So recommendations for this are, so some of the recommendations in the review are part of these changes before you today. So recommendations are reviewing the types of applications that can be brought to committee, allowing members to focus on the more complex, significant and controversial applications, removing the detail from the planning out of the Cambridge City Constitution and South Cambridgeshire District Council Constitution and place it in one document. This is to ensure that the constitutions will simply delegate decision-making on the most controversial and significant planning matters to the Planning Committee. Having one document will mean that as legislation changes or new changes emerge, we can update officer delegations working with the Planning Committee rather than require changes to the constitution which are more complicated and cumbersome to achieve. This helps make the committee more agile in its response to change, where they can update the scheme of delegation if needed in the future. Aligning the triggers for committee referral to help the communities and participants in the planning process to participate and to see decision making following a consistent process, as opposed to three different processes at present. Then the creation of the One Greater Cambridge Shared Planning Service scheme of delegation, introducing a delegation panel for Cambridge City Committee and Joint Development Control Committee, review and align the triggers for the existing delegation panel, and a name change for the Joint Development Control Committee to the Joint Development Management Committee. It's the same recommendations of input to the City Planning Committee, and this is to go to the Joint Development Control Committee next week for their recommendation on the proposals as well. The purpose of these changes is to ensure that we use precious resources of the committee effectively and on the right things. This is a significant investment in time and resources for members and officers, to ensure that applicants that don't justify committee scrutiny can be dealt with efficiently and promptly, to ensure that the process for making decisions across the Greater Cambridge Shared Planning Service is clear, consistent and transparent, to enable improved and clearer understanding amongst all communities on the process. The proposed scheme of delegation for City and South Cambs, it will be changed to align the two. These are the headline details that are also in paragraph 5.7 of the report. So there'll be a delegation panel created for both City and South Cambs. The triggers for the delegation panel will be where there's a ward or parish call-in, or where there are 5 or more third-party representations on material planning grounds that cannot be resolved by way of a condition. The application will then be taken to delegation panel and be decided whether to go to planning committee or to be delegated. So the triggers for committee determination are where there are 5 or more third-party representations on material grounds to a tree protection order, the significant departure from the local plan, and it's recommended for approval. An elected member or an officer of the relevant council has submitted the application, a substantial demolition of a listed building or building of local interest, or a Regulation 3 application, whereas an application has been made by the local authority or the officer's recommendation. So, for example, a full planning application for 10 dwellings. Bear with me. A full planning application for 10 dwellings, if we're shown, we go through this process. So an application for 10 dwellings, if it's either called in by a ward member or 5 or more representations that cannot be overcome by condition, within the 21 days, if this hasn't happened, it would become a delegated decision. If this has happened, it will go via the delegation panel and considered a call-in request to either be delegated or come up to committee. Otherwise, if it's considered a significant departure from the plan or is an officer recommendation or Regulation 3, and then it will be coming to planning committee. Whereas the journey for a householder planning application, if it comes in, it'll either be delegated, or if it's considered to be a significant departure from the plan, considered by, if the applicant is a member of the council or a ward member, demolition of listed building or Regulation 3, then it will come forward to planning committee. Or if it's an officer's opinion that it should go to planning committee, as there are 5 or more representations to the application that cannot be overcome by condition, then it will be called into the delegation panel and either be delegated or a planning committee recommendation. So here are the changes in the context for South Cambridgeshire District Council. So currently, application is either called in by a parish council or ward member, and then the application is deferred to the delegation panel.
So is this current or proposed?
Current. This is the current scheme of delegation. So the application is deferred to the delegation panel where it's called in by a parish or ward member. Then the applicant is an officer or member of the member of the council. Departure from the local plan, a major or minor Regulation 3 application, demolition of a listed building of local interest, officer's opinion that should go to committee. So currently, going on the 2024 application numbers, on the left-hand side, there was 38 applications brought to planning committee in 2024. 12 of them were taken through the delegation process, which is the area in green, and the rest were brought to committee, which is the area in blue. On the right-hand side shows the proposed scheme of delegation. So the green are the areas that would now be covered by the delegation panel, and blue are straight to planning committee again. So one of these changes would be applications according to planning committee, as there are 5 or more representations that cannot be overcome by condition. So under 10 part 2 of the proposed scheme of delegation. Therefore, if an application is called in delegation panel for South Cambs and had 5 more objections, there could be an additional 54 applications that would come to planning committee, if not recommended delegated by the delegation panel. So this increased the potential applications to 91. Out of those applications that would have been called, the 54 of them, 2 of them would have been Section 73s, 1 of them would be a planning in principle, 1 of reserve matters, 2 listed building applications, 2 outlines, and 37 of them would be full applications. However, they may not come as they may be overcome with a condition or not taken to committee as they could be delegated. And as you can see, the rest of the numbers would not change under this proposed scheme of delegation. So the recommendation is to endorse for approval at Cambridge City Council Civic Affairs and South Cambridgeshire Civic Affairs before full council for the Greater Cambridge Shared Planning Service Scheme of Delegation December 2024, the amended public speaking rights at Planning Committee, the amended Members Planning Good Practice Guide, with delegated authority for minor amendments to officers in consultation with the relevant Executive Councillor, The committee delegates authority for minor amendments to the drafting to assist in providing clarity only to officers in consultation with the relevant executive councillor, and that a review of the revised scheme of delegation be undertaken in 12 months and a report prepared to each committee for consideration and action. Thank you.
Thank you. Could I just ask a matter of clarification? Could you just go back to the table that you showed us, Jane?
Yeah.
Ms. Roden, sorry.
That's fine. Do bear with me. It's being a bit slow this morning. We're getting there.
Thank you.
There we go.
I'm just a bit concerned that under the proposed scheme, there's an implication that an extra 53 applications would come for consideration to delegation panel.
So,
in other words, 54 minus the one before.
so it wouldn't be 53. So these are, so I looked at the numbers that came into South Cambs Council for planning under 2024, and there was 53 applications that had 5 or more representations on them. So some of these may be overcome by condition or not reach delegation in the first instance. That's just the worst case scenario, 53 being the number.
Okay, so that means, if that's the worst case scenario, then that would mean more decisions coming to the delegation panel for consideration.
Yeah, also
So
that they
more
may...
work for myself and the Vice Chair and Rebecca and the officers.
So also they may not have been objections, they might have been recommendations for approval where the application's been approved. They were just 5 or more representations on our planning application.
Okay, and of course we can't predict the number that would actually come to committee because we don't know the nature of what that number might be.
Just the worst case for that number. Thank you.
Right. Do members have any questions? Councillor Heather-Williams and Councillor Redrup.
Thank you. It's just on a couple of, and I'm looking at the supplement. I want to look at the application for householder permission, and then we've got the 10. So it's just clarity of what happens in between that. But this does suggest that this flow chart, that the parish and ward member have no room for call-in at all, because it doesn't even seem to be a consideration of the flow chart. So just wondering if that's a sort of oversight, or whether the proposal is that members can only call in things if there are 10 or more houses in a major application. And say that, so that's the first thing on that flow chart. The second thing, which probably...
Deal with the flow chart first.
Okay, Chair.
Okay, because my observation is that the summary of recommended changes on page 21 covers the fact that there might be a request from a ward member or a parish council.
If I can jump in and clarify,
Yes.
If members wanted to turn to page 39 of the printed agenda, sorry, Councillor Lynch, I know you've got electronic. Schedule A sets out the applications that are delegated to the director, and so that is the list of applications that application types that wouldn't be available for call-in, generally because of the timeliness within which we need to determine those applications. So, for example, telecoms applications, prior approvals, we have a deadline, and implications if we don't determine them within the relevant time period. And householder developments are actually on the list of applications that wouldn't be subject to parish or member call-in.
Thank you for that clarification. So the chart is correct. We would not be able, under this scheme delegation, to call in those applications. Then we have the jump to 10. So just for a scenario, say there was a application for 2 houses. I had an issue with 2 houses in one of my villages, and that's a minor application. It's not quite clear to me in this scheme delegation, would I or the parish be able to call that in if it was an application for 2 houses?
I can come back on that one. What I should have added, apologies, to the end of my last bit, was that there's always opportunity for officers to refer any application to the delegation panel. So if there were a significant number of objections, for example, or a request from the parish or ward members, then officers could review that. So a householder application could come under that element of the call-in to delegation panel. In terms of full planning applications, the example is for 10 or more. But it's just as an example. We could have given an example of 2, 5, 7. It's just an example.
So anything other than your own household is calling a ball,
Yes.
for want of a better word.
If you have a look, I understand what you mean.
A local member can call in an application that is for one or two houses, as far as I'm aware.
Yeah, if you have a look, Schedule
Where does
A.
it say that?
Schedule A on page 39.
Yeah, but where? Because all of these are the things. Sorry. This is a fire alarm test. Please stay in your seats. Thank you. The lights carry on flashing, but it does not mean we've got a fire. Sorry, we were saying, where does this Schedule A says the things that are not subject to consideration for committee, but I'm struggling to see where it says what you can refer.
It's everything apart from what's included in Schedule A. So Schedule A are the applications that are delegated to the director, not subject to consideration for committee. By exception, anything that's not within Schedule A is open.
Okay. So is the flowchart an accurate reflection
Yes.
of that?
Yes.
So yes, because we've got an arrow to delegated decision. Yeah. Does that answer your question, Councillor Williams?
It does answer my question. And then just one other, obviously a lot more on this is going via the delegation panel, which is a meeting that's not public, that if you've called something in, you can't attend. Do we publish minutes?
You can make comments.
Now,
so
you can make comments if you're told about them, Chair.
The local members are advised about items coming to the delegation meeting.
I have several examples where I haven't been, Chair.
And I have asked for clarification on whether if it's said to be for information only, and I wanted clarification on whether if it's for information only, are local members entitled to make a representation to the delegation meeting, or
we're not.
I can clarify. I think there is now in this delegation scheme opportunity for ward members to attend.
Yes,
and
indeed,
represent.
absolutely.
I think officers can confirm that.
So yes, but this came up just recently because it was not apparent to the members who'd been informed whether or not they could attend or what. So I've asked for that to be clarified.
If I can clarify that on page 32. I was going to, if
we can just
that
take
part of the
this
question,
point
is that
about
all right,
whether they're invited or not.
The delegation panel has got a definition within on page 32, which does now state that upon request and with the chair or vice chair's agreement, any member or a member on their behalf in relation to an application within their ward can attend the panel to explain the reasoning for their calling in the proposal. So that is a change that we are proposing so that we can take on board that feedback and ward members can attend.
My question
Yes.
around notice. So, for example, today there is an application for something in my ward. It's come to planning committee. I know about it because I'm on planning committee, but I have not been told as the local member an item in your ward has come to planning committee today. So,
Microphone.
has it gone off? So it's about, nowhere in here can I see about notice and that process. And I think that if there's going to be more that's done in these meetings, that process needs to be worked on. Because even today, I've got an application in my ward, and as the local member, I've not been told that there's an application coming to committee today. So I don't think there's enough safeguarding and enough process in this.
I think it needs to be clarified that local members need to be informed of why they're being told that there's a delegation meeting and that something's coming, and they need to be, it needs to be explained in a standard letter in what way they may take part if they wish to.
Yes, because the fact we can attend is sort of irrelevant if we're not notified.
Yeah, and also you might not be able to attend, but you might want to send something in writing, which is perfectly fine. Yep, okay, we've got hands up all over the place.
Sorry,
first of all, Rebecca.
If I can come on back on that, I have spoken to the TSO team who send out the invites to the planning committees, because I wasn't aware that local ward members weren't invited when there were applications in the ward. So that is something that we're picking up as part of the process changes that sit behind this. So going forward, I know at the moment parishes, agent, anybody who's written in are advised of when the items on the agenda, but going forward I've asked to ensure that local ward members are also advised when an application's on the agenda. I think you also mentioned
And
about...
you mean the agenda for the delegation meeting?
No, I mean the agenda for the planning committee meeting.
Right.
Yeah.
Okay.
And in terms of the delegation meeting, that was when I referred to the new kind of definition of what the delegation panel is. But
we haven't agreed this yet. So.
Which is included in the papers. But I think you asked about whether notes are taken. So notes are taken at present of the delegation panel, and they are published on the website, and they are sent to the relevant ward member or parish council that call it in. That already happens, but that will continue if changes are made.
Right, okay. So we're in a process of change at the moment, but yes, certainly communication with local members is important. Sorry, I can't read. Lisa, Councillor Redrup.
Thank you, Chair. I've got two questions or points, please. One was about this page 24 flow chart updated and replaced, where it's had an extra box in the middle added for householder applications, where it says if it's the officer's opinion.
Sorry,
Councillor
Redrup. What page are you on?
Sorry, the supplement that we got
the
given.
supplement. Okay.
Yeah, sorry.
Yep.
And that flowchart that Councillor Williams was also asking about, where it says it's been added if it's of the officer's opinion that it should go to planning committee, as there are 5 or more representations to the application that cannot be overcome by condition. So that's been added, and we've asked if that's correct. We've been confirmed it is, but I am still concerned about that because if I can take you to the scheme of delegation, sorry, I'm struggling to find the page again. If we can read.
Page 21 is the summary of the recommended
Cheers.
changes.
Thank you. If we could read point 8.
Do you mean the bullet 8 or?
Sorry, not page 21, actually in the scheme of delegation. Sorry? I've just found
in the scheme of delegation itself?
Yeah, so page 34, where it says, number 8, where it says to determine, make a decision, respond, investigate or notify on behalf of the council in the exercise of its responsibilities.
Sorry,
sorry, I was trying to read it fast.
Sorry, do you mean, I can't even find a point 8, so. Page 34. Okay, right, we can all follow you.
My
We're on the
apologies.
same page. Let's just find it first. Okay, page 34, point 8. Right, to make a decision. Do you want to carry on?
Yeah, so this is the one that I think refers us to, this is the one that refers us to Schedule A and the delegation scheme for Schedule A items, which includes householder applications that are mostly delegated to the director, and we don't have call-in, but they're saying that it might go to committee if 5 or more representations are come. But if we carry on through that, it says, subject to any application made under paragraphs 11 to 15 always being required to be reported to planning committee. So, but within those paragraphs 11 to 15, it doesn't include this reference to if 5 or more representations are made, because that actually comes in point 10 that's excluded from this one.
Yes.
That's 10.2. So I just wondered if it could be checked if this actually was what's happening, and if we are looking at this under correct.
I have to say, what this highlights is my general feeling about this. I know it's late on in the day and people have worked hard on it, but actually I found this incredibly difficult to follow. I don't know if anybody else did. I don't know if I'm just being dim or what, but I found it incredibly difficult to work out when, as a local member, I could call in an application to delegation or request it. Because, for example, the point I made to Rebecca recently was, suppose you've got a householder application and they've only got 4 neighbours and all the neighbours object, it still wouldn't justify being called in. And yet you've only got 4 people who could call it in, unless you asked your local member as well and they happen to live somewhere else. So I just think, so we've got a list, okay.
Chair, can I?
Yeah, sorry, Stephen, do help us.
Can I just offer a couple of comments? I think the reason why the Publics Committee are unfamiliar with this document is because what we're doing is we're exporting effectively bits of the constitution of South Cambridgeshire District Council, which by necessity need to be legally drafted to withstand judicial review. We're exporting that to the Planning Committee. Now, I realise it's difficult in terms of working your way through this, in terms of legibility, because members may well not be familiar with routinely reading through the Constitution to determine the process. I think there's a really important point, and the flow diagrams are intended to try and assist, that we will take away to try and think about how can we communicate what is by necessity legally tight with very few gaps into something that is more easily digestible and understood, not only by communities but also by yourselves. In respect of the specific, so that's something for us to take away as we move this through, and subject to Civic Affairs approving this. Of course, this is a matter for the Council's constitution. If those changes are agreed by yourselves or supported by yourselves and made by Civic Affairs, the objective behind all of this, the recommendation that pivots this proposal, was to try and improve transparency and clarity. And so we want to work hard to try and find a way of making it clear. In respect to the specific point that's being made, or inquiry about paragraph 8 on page 34, the reference here is the referral automatically to Planning Committee. Jane's presentation highlighted those circumstances. So what, if you read paragraph 8, the second part, as it says, subject to any application made under paragraphs 11 to 15 always being required to report to the Planning Committee. Okay. Those, that wouldn't include householders unless they were an application by an officer of the council, which is an application by the council, which is point 12, sorry, a departure from your local plan, so significant. So what the scheme is trying to do is to reassure the community that, for example, if an officer or member applies for planning permission, it is automatically referred to committee. There is no delegation panel, there is no, you do not pass go, it goes to committee. Likewise, for a departure from the local plan, planning applications by the council, where there is a series of issues, or it's a kind of catch-all at 15, where there are complexities and issues of substance that mean that it shouldn't be debated at a delegation panel, it just needs to come to the committee. Those are the scenarios that, in a sense, don't pass go, they go straight to committee.
So are you saying, sorry, that effectively paragraphs 10.1 through to 15 go automatically to committee? No, or is it from 11 to 15?
It's from 11. Paragraph 11 onwards, and picking up the Council's point, paragraph 11 onwards are automatic referrals, and they're generally the same as you have in your current scheme of delegation. So there's nothing changing in that regard, and they're consistent with the Nolan principles in terms of officers and members' applications and council applications always going to committee so that the decisions are made publicly.
So 10.1 to 10.3, these are conditions which enable local members to request that something goes to committee. And so these, as it were, are requests, and it's okay with the caveat about, I suppose you've only got 4 objectors. And then the ones 1 to 9 are what category? These are the ones that automatically go by the nature of the application, or do not go, or I'm lost. You can see I am confused by this. What are 1 to 9? I think it's just very wordy, and if it's actually no different in many ways to what we had before, I think a simple clarification would be very helpful.
So 1 to 9 are those elements in which authority is delegated to the Director of Planning. Those are the components that are identified for pursuant to officers. But then further out, it says except in the circumstances. So 10.1 to 10.3 are the circumstances where there is a delegation panel. And then 11 onwards are automatic referrals to the planning committee.
Okay, so
Perhaps Rebecca
a
can clarify.
subheading to that effect would be helpful. Can I
just
take Rebecca's
clarify
point first?
on the any ward members or parish councils can request with an explanation of material reasons why any type of application apart from those listed in Schedule A be brought to delegation panel. So it does, when you're saying about 10.1 to 10.3, it isn't a specific type of, they have to hit those triggers. The parish council or the local ward member could request for an application to come to delegation panel, setting out their material planning reasons why, except for those applications that are listed in Schedule AA.
So that's A on page 39.
Yes.
Okay.
Does that make it clearer? So that it's not that the ward member or the parish has to hit a list of criteria to call an application to the delegation panel. It's more that there's a list of criteria for the application for automatic referral to the planning committee.
I think it would, the thing that came out to me from this was, I appreciate absolutely this is being drawn up in legal language, but I think for the average local member or parish council trying to work out whether they can refer something to committee or not, I think a simple explanation would be helpful.
Yes, I think the city committee have asked for the same, so a more easy to understand guidance note rather than the legal speak as such that has to be covered within it. That is something that other members have asked for, and I think that's something that
absolutely
we need
I think
to
that would be helpful.
develop.
Just one moment. Councillor Heather Williams.
Thank you. And so Councillor Redrup, I appreciate you're waiting, but can I just say, there's obviously not, this has not been easy to digest. I feel that the more we talk about this, actually, the more confusing some may be finding it. Civic Affairs doesn't actually meet until, well, it meets at the end of this month, but also in March. It's got to go to full council. We've got till May. Can I suggest we actually have a briefing and a workshop, because the guidance note might, at the moment it would feel, and particularly I'm thinking from public watching, that we don't really understand what we're deciding on as a whole, and that's not good decision making. So, and we could probably talk about this for another hour and still be in the same position.
So just bear in mind that all that we're being asked to do is to endorse this, to go to Civic Affairs and then Council, but we can caveat that and say, but we'd like some work to be done in between. The other thing is that this is something that's been worked on by the City Council as well, so we need to be mindful of that. Before I come back,
we can't endorse.
I appreciate what you're saying. I appreciate what you're saying, Councillor Williams. Can I just come back to Lisa Redrup?
Thank you, Chair, and thank you, Mr. Kelly, for your explanation. To me, that does now make sense, but I do wonder if it's possible to ask for a small amendment to that point 15 to include this point about if there's 5 or more representations, because at the moment I'm not sure.
Sorry, where did you want?
Oh, sorry, on page 36.
On page 36, point 15.
Yes.
What did you want to
so
add?
in Mr. Kelly's explanation of my question and how that could go to committee if there's 5 or more representations, was at this point 15 was where that was covered. I think that's right. Is that right, Mr. Kelly? No.
I'm being
Councillor
Redrup, I'm being told by our legal advisor that is covered at 10.2. So this is where it says, these are where local members can request something, or indeed anybody can request to go to the delegation panel, and it says, where 5 or more third-party representations on material planning grounds that cannot be resolved by way of a condition are received, and following consideration by the Joint Director of Planning and Economic Development at delegation panel, having consulted with the Chair and or Vice Chair of Planning Committee, the application is decided to be referred to planning committee for its determination, blah, blah, blah. So it can be, things can be referred, as I understand it, under that point.
I was meaning Schedule 2, the Schedule A ones.
Chair, I wonder if I can clarify.
Yes, could you?
Just slightly, stepping out slightly, on the point about confusion, the principle behind this process is that the City Council and South Cambs Councils constitutions will delegate everything to the planning committee. The planning committee then, as a matter of process, needs to delegate everything to officers and then list a series of exceptions in the circumstances where they are not delegated. Either conditional arrangements, which is as set out in 10.1 to 10.3, or paragraphs 11 to 15. The reason for doing that, rather than listing every single type of planning application that exists, is, as we know, as time changes, new types of application emerge into the ether. There can be a situation where the scheme of delegation is silent or does not cover those matters at all. So the principle that's operating here is the Constitution delegates to the planning committee decision-making. The planning committee then delegate to officers, and about 95% of decisions are made in all planning authorities by officers, and then introduces a series of conditions, which is what these conditions are that we're looking at here on pages 35 and 36, then introduces a series of conditions in which either, in our circumstance that we're discussing here, a delegation panel meets to consider whether the application should go to committee, or secondly, the application goes to committee automatically. So I think I'd encourage members not to get wrapped up in the detailed wording. There are constitutional lawyers drafting this for you, and for civic affairs, and for the final approval by council. But the objective here is to change the delegation to the committee. The committee then delegates everything to me and my officers, save for the circumstances identified. And it has to be done in that way, because the risk otherwise is that you miss things. So it's a default delegation rather than a specific set of every scenario delegated. The only material change from the situation that you experience at this moment in time is the exemptions from the delegation panel, but also the proposal that doesn't exist at this moment in time, that if more than 5 people raise objections, it goes to the delegation panel. So this is an extension of the role of the delegation panel to capture those scenarios where a number of people in the local community make representations. That doesn't currently exist, and as Jane has highlighted, the effect is that there will be more scrutiny of planning applications by the delegation panel than there is at this moment in time. And so the delegation panel and the process is increasing committee oversight through you, Chair, and the Vice Chair, of applications in South Cambridgeshire. I think absolutely we understand the point around how can we make this much clearer, because it is very complex in terms of the way the legal drafting happens, but it's simply that proposal that is the material change.
So you've helpfully pointed out, if I may just reiterate what you said, and I think this ought to be introduced as a paragraph at the beginning so that people understand it. Sorry, not in my words, but in correct words, because I'm sure I won't say it properly. But you've said that the principle is that everything should be delegated to planning committee, but then planning committee delegate to the director and officers, except under certain circumstances, either where that justifies being sent to delegation panel for consideration, or there are specific terms that determine that it should go to planning committee. If that kind of paragraph could be put in at the beginning, I think that might help everyone understand. But we've still got people who wish to speak. Councillor Richard Williams and Councillor Heather Williams. Did you want to speak in order? Sorry.
Okay.
Let's take Councillor Heather Williams first, because you put your hand up first. Okay, Councillor Richard Williams.
Great, thank you. I'm going to talk about something else, although I will preface it by saying I'm not actually happy to endorse this, so I'll put that on the record, so it won't be unanimous. When we looked at this, when we looked at one aspect of this back in August, I raised a number of concerns about the member planning good practice guidance, which is part of this, and I still have exactly the same concerns because it seems to be in very, very similar format. I would urge all members, and I would certainly urge Civic Affairs to really seriously look at what we are signing up to in this code of conduct and the impact that it would have. This code of conduct goes way beyond anything in the law.
Can you just take us to the page?
Yeah, I'm going to refer to pages 84 and 85. I'll come on to that in a second. This code of conduct goes way beyond the law on predetermination, bias, and apparent bias by introducing these concepts of personal and prejudicial interests, which...
Sorry.
I'll come to it in a second.
Sorry, just one moment. This is just guidance that informs the paper. It is not part of the change that we're considering. I had some concerns about that. Can we just take legal advice on that, please?
Chair, it is a Councillor Williams is right. It is a recommendation that the Code of Practice, Members' Good Practice, is endorsed and referred.
Okay, righto.
But it's not part of the scheme of delegation.
It's not part of the scheme of delegation.
But if I can just clarify, it's a good practice guide. It's not a code of conduct. The code of conduct isn't being changed.
But it relates back to the code of conduct because the code of conduct requires you to accord with the good practice guide. Anyway, if I could just come on with my points, whatever it is, okay?
Can I just before you do, sorry, can I understand? Sorry, please don't swear at me. I'm just trying to clarify.
My apologies, Chair.
Apology accepted. I'm just trying to clarify. If we are approving the changes in this paper, are we also approving the document that starts on page 83, or is that something that's already in existence and has already been approved?
The recommendations are to endorse this document as well.
And this document includes these other bits which are in different font and in different point size, and so that's the
so there's
the part on page 83, guide. The public speaking guide,
yes,
and the
good practice guide.
The Constitution. I mean, those are already agreed. The Constitution at page 67, which relates to JDCC, now JDMC, and 73. Are they all part of the same thing?
The Constitution extract at page 67 is an extract from the existing Constitution, and JDCC committee will be looking at that because there are some changes proposed to that.
But that is not something that we are.
We are endorsing the recommendation. South Cambs Planning Committee are being asked to endorse the recommendations on the changes to the scheme of delegation, the public speaking guide, and the members' good practice guide.
So, but not the Constitution bit. So the public speaking guide at page 77 is up for our consideration, and the good practice guide that Councillor Dr. Richard Williams wishes to speak, because there are a number of things in there that I am concerned about. Right, so this would be something that would be part of our endorsement. Do carry on, Councillor Dr.
Thank you, Chair, and apologies again for being snappy. I'll cut to the chase. Paragraph 3.12 on page 85. I am
3.12 on
3.12 on page 85. I am still very, very concerned about this, and we talked about this last August, and we talked about it in JDCC as well, where it says, as a member, there are things you should avoid if you have a disclosable pecuniary interest, fair enough. But it then goes on to say, or a personal interest, or a prejudicial interest. And these include the following. You should avoid representing ward or local views on a matter in which you have such an interest. It's fine for a pecuniary interest, that's accepted. But what about a personal and prejudicial interest, which are not categories that have any legal basis? They just seem to be made up in this document. It says, in these circumstances, it's appropriate to ask another ward councillor. Now, we said in August. That just doesn't translate to the reality of people like me who are in single-member wards. So we asked for this to be changed, and it hasn't been changed, and it's still there. And even, frankly, if you're in a multi-member ward, it's not really fair to say you must ask another, ward councillor. If you're, a Lib Dem councillor, you've got 2 Labour councillors in City, you might not want to ask one of them, because it might be a matter of political controversy, okay? That's just the reality we live in. So I don't think that is appropriate, and I don't think it's appropriate to have in this guidance document to say that members can't even represent ward or local views on matters which are described as personal or prejudicial interests. Personal interests are defined in paragraph 3.7 in very vague terms. It says a member will have a personal interest in a planning matter if the matter relates to an interest in respect of which they've given notice in their register of members' interests. If you're a member of parish council, you will have declared that in your register. So if the parish council objects to an application, this could be read to say, well, as a ward member, you're not even allowed to turn up and represent local views. I think we need to seriously think about what we're doing here.
In this case, let's give a fictitious example. I'm a local member in Milton, and let's create a fictitious sister who lives somewhere else in Milton, who's having a development next to them. I think that would come on, and there's something that we object to. I think that is a personal prejudicial interest, and I would seek to remove myself from that. So, are you thinking of another example that...
Well, I just gave you the example of the parish council. It says anything relates to is a vague term, relates to an interest on the members' register. I mean, that's very vague. It's very broad. That's my problem with this. And my other problem, my broader problem is it's equating personal prejudicial interests with pecuniary interests. There's a statutory basis for rules about disclosable pecuniary interests. It's in the Localism Act. That's absolutely fine. But under a section headed pecuniary interests, which starts at 310, it all actually puts personal and prejudicial interests on the same basis as prejudicial interests.
Perhaps we need some legal guidance on this. Thank you.
Well, I actually just wondered, whether, because this is going to civic affairs, whether it would be, obviously the monitoring officer is not here today, and it would be him who'd be able to advise on such things. But I think the scenario that you're also talking to is what Councillor Redrup, the interest that she disclosed at the beginning of the meeting, which was where she was a ward member, but she's decided not to speak as the ward member today. She's decided to actually take part in the committee, and you have got this dual role, you have got this dual-hatted thing. And I suppose it's from the public's perception point of view, how can you come to that meeting? You know, we use this quote about come to it with an open mind. It's demonstrating to the public that it's not a done deal behind the scenes because you're the ward member and you've been lobbied on such things, and then you're appearing at the committee. So that's just a real life helpful everyday scenario, because what we're doing here is making sure it's clear to the public that transparency. Now, this document does form part of the suite of documents that you're being asked to endorse. Obviously, if you're not happy endorsing it because of that element, it doesn't mean that you're given to have accepted it, and that can be raised at a future meeting, which is not a meeting that's going to go. This meeting can't go into the ramifications of code of conduct, etc., because that would be for civic affairs and detailed sort of explanation from the monitoring officer.
Yeah, if I can just make, I don't want to prolong this anymore because I think we talked a lot, but just to come back on that, I mean, I'm afraid I'm not happy to endorse it because I think that's a serious problem. But, you know, I am elected, like we're all elected. I'm elected to represent the Whittlesford ward, and I should be able to represent the Whittlesford ward. I shouldn't be prevented from representing the Whittlesford ward just because, you know, of something called a personal prejudicial. As I say, pecuniary is fine. But these personal prejudicial interests, these are totally made-up things. They don't have any basis in law. And I'm being told I can't represent my ward, which is what I'm elected to do, to represent my ward. Anyway, I'll leave it there, but I think I'm still not happy with it.
I mean, these rules are here basically to maintain the integrity of the system. So it's basically to show the ordinary member of the public that things are done in a correct and proper way. Therefore, a big exhaustive list about what qualifies as a personal interest, it has to be more nuanced. It has to be a case of deciding, because some members have different views on, should I declare this? Is that too tenuous? Otherwise, you could get into the minutiae of it, and it would be a document that would be rendered sort of useless, because each scenario could present different terms. Now, pecuniary is straightforward because you derive a financial benefit from that, so that is defined. But there are other things like, I'm a member of so-and-so's club, I'm friends with that person, I once did work for that person for a different company. So I think it's just to be able to have that safeguard.
I think, I'm sure members, including myself, have been in a situation where you felt that you really ought to be able to represent somebody and you can't, because either they're your neighbour or you sit on the parish council with them and it's a parish council application, or, because we live in communities, we're often part of communities, inevitably, and that's great. But that means that sometimes the very people that we want to represent, we find we're unable to do it because we're deemed to have an interest. And I think that's quite tricky. And that's when we all come to the monitoring officer and say, does this constitute a problem?
I mean, obviously, this is a quasi-judicial decision-making panel rather than, it's not for every member. It doesn't preclude you from being a member. You could be a member and decide not to sit on planning committee because you are faced with these conflicts.
Chair, can I just comment?
Let's take Mr. Kelly first.
Thank you. I mean, Councillor Williams is right in that the Localism Act, Section 28, doesn't include a definition that's prejudicial of what a prejudicial interest is. The section in this Code of Conduct isn't about a personal interest. It's a personal and prejudicial interest, or a pecuniary interest. So the Code of Practice, I'm sure we've derived this from either the Planning Advisory Service or the Local Government Association guidance. And it's right that if you have a prejudicial interest to open and transparent decision-making, you declare it. We can explore alternative wording, but in Section 28 of the Localism Act, under paragraph 2, it says, the relevant authority must secure that its code of conduct includes the provision the authority considers appropriate in respect of the registration and disclosure of A, pecuniary interests, absolutely clear that pecuniary interests are a matter, and B, interests other than pecuniary interest. Now, if a prejudicial interest exists for you as members of the planning committee in respect of a planning decision that you are about to make, you are failing under Section 28 if you disclose that, if you do not disclose that. Now, we can work with, and I know that case law is complex on this point about the extent of a prejudicial interest. We can work through the Code of Conduct to try and find a better definition to satisfy Councillor Williams, but it is clear that that interests are not just pecuniary. And I think what the guidance is trying to do, and the Code of Conduct in reasonable terms, is to identify where a personal and prejudicial interest exists, that it is declared. But I think we can happy to work with councils
can I just, there are a lot of people on the list who haven't had a chance to speak. I'm going to take you to the end, if I may.
Okay,
I'll come. Ask the other
point relevant.
ask the other members first. So, is it you?
It looks like me.
Yeah.
Thank you, Chair. Yes, a point of clarification, if I may. On page 21 of the printed version, I think we need to be quite clear that in relation to the triggers for this committee, if there's a request from a ward member and so these are not alternatives.
Third bullet, right?
The first, yes, the first of the third bullet. Yes, so it can be either of those. It can be, and I think that is clear elsewhere. On page 23, the triggers for what is currently the JDCC, will presumably be the JDMC, 5.9. I think that a ward or local member, which may arise where JDC area covers a parish or part of South Cambs, can also trigger this, and I hope that can be made clear. It seems clear on page 38, para 7, and also it's on page 74, but I think it would be best if that were clear. I have various other points, but frankly, we've gone on long enough, so I'll
Yes,
just mention
exactly.
those two.
Okay, there are some concerns. Okay, and Councillor Dr. Toomey Hawkins.
She may have
Did I
made
put
a
my
point
hand
earlier.
up?
Sorry?
Did I put my hand up?
Earlier.
Apparently not. Okay, all right then. Not
Okay,
if you didn't.
well, you've
Okay,
given me the
I have
opportunity.
you on my list. so-
Simple questions. Why the threshold of 5?
Sorry, say again.
Why the threshold of 5?
Yes, exactly. That was my point earlier. Why 5? Because you might, as I said, only have 4 people who are going to be affected by something. That doesn't mean to say those 4 people shouldn't be listened to. Rebecca, do you want to come back on that?
Yeah, I can come back on that. We looked at PAS best practice guidance, and actually the majority of local authorities that we looked at had a higher threshold. But given that we had no threshold at present, we're recommending a lower threshold than most other authorities have. There is obviously the recommendation that this is reviewed after 12 months, so that there is the opportunity to review that threshold. But it was on the basis of reviewing PAS best practice guidance, which is the planning advisory service, and also a number of other local planning authorities.
This is an additional ability compared to what we have at present. So it's an additional strength in bringing things to committee. I've got Stephen Kelly, but I think you've already spoken about the thing we were concerned about. Councillor Martin Khan.
I can't find it down here anywhere, but at one point I saw it referred to that for consultations, consultation for councillors should be in 28 days, and for others it was 14 or 21. I can't find it again now. Can I just clarify that is it 21 days for everybody?
I think it's 21 days for, you mean for comments about
Comments,
planning
yes.
application?
I just wanted to clarify.
I thought it was 21.
I don't know where I saw it. Somewhere
Rebecca?
I saw it for 28
Perhaps
days.
Rebecca can answer that one.
I can clarify it's 21 days when it's an application and 14 days when it's an amendment to an application.
Okay.
Right. And that
So
applies to everybody, including councillors.
Yes.
Yes.
Okay, that's clarified. Two, in terms, coming back to Councillor Richard Williams's point, in terms of what's a prejudicial application position, I understand the concern. And for instance, it refers to items declared on your register of interest. I'm a member of, for instance, the Wildlife Trust. Does that mean that every application which has some biodiversity interests I have to declare, or is it, you know, how tight is that? Is that concern? I had, for instance, I'm a member of Cambridge for Europe. I had an issue once in council about a motion where that was referred to as a prejudicial interest. Now, I just wanted to know, get some clarity of what that sort of means in real terms.
Is that back to Stephen or to legal? Yes, legal.
Can I, perhaps if I just comment on that?
Yeah,
I mean,
sure.
The courts are really clear, as is the local matter. It is a matter for members to determine whether they have a prejudicial interest in respect of a particular matter and the extent to that. But it's that principle which will be examined by the court if there is, for example, a claim of bias in a subsequent challenge to a decision. And I think that's why it's not possible to define that really closely. It could be a wide range of circumstances. But I think that's the purpose for members in those circumstances. That's a discussion you should have with the monitoring officer, and they can offer you advice, although ultimately it remains a matter for your judgment as individual members.
Right. Thank you very much, Stephen. I am mindful that I want to come back to Councillor Heather Williams and to Dr. Richard Williams. Did you want to come back first, Richard, because you were talking about the good practice guidance?
Thank you, Chair. Just appreciate it. Just a very quick point. I've already shared it with Mr. Kelly.
Sorry, just because you're making a quick point, please don't speak quickly.
Okay.
do
I'll make
your
a
time
quick
so we can
point
hear.
in a slow an
Thank you.
audible way.
Great.
I thank Mr. Kelly for his point, and I think that was really useful, and it gets to the nub of the problem I'm raising, which is the difference between disclosure. I think we would all agree we have to disclose if we have a personal or prejudicial interest, and not being able to speak at all. And my problem with 3.12 is it says that we can't speak at all if there's a personal interest. I agree we have to disclose it, but I think saying we can't speak at all on behalf of our ward, if there's any interest at all, goes way beyond what the Localism Act requires. That does require us to register it and disclose it. It doesn't say we can't speak on it. So I think that's my problem. I think it goes beyond what the Localism Act wants, and I would argue what's reasonable. We should disclose it, but we shouldn't be banned from speaking at all on behalf of our
I don't
ward.
think it says that, Richard. It doesn't say you shouldn't speak. It says
You should avoid representing ward or local views. It does.
okay. Well, that's what legal said. So
Excuse me, just to clarify though, I mean, I understand Councillor Williams's point now more clearly, and if there's a need for clarity on this, I think we can
Yes,
look
I
at this
think
paragraph. But the bottom bullet point on page 85
So you may address
says,
the
you may
meeting."
address the meeting that considers the application or other matter in the same way that members of the public may address the meeting. However, you should then withdraw from the meeting at the matter which is under consideration. You can
But
remain in the meeting room, and you should, and you do, if you do, you should sit in the public gallery. Now, I know circumstance, in fact, Councillor Heather Williams has declared this matter in
Yes.
respect of the other item, where she's going to do exactly that. But I
Yes.
think if there's clarity in, let's look at that. I understand that it's a little bit opaque in terms of that, and I think it would be helpful ahead of civic affairs, noting Councillor Williams's
Yes.
point, if we took that away and looked at it a little
I
bit
think that would
further.
be helpful, Stephen. Richard Pitt would like to speak.
Yeah, I think it's just, it goes back to this principle that you can't have the two competing agendas as being sitting on the committee, coming to it with an open mind, and having had access to information behind the scenes where the ward or the parish are taking a particular view. That basically fetters your discretion, but I can understand how, before it comes to civic affairs, there could be
Yes.
wording to clarify what, because it's not precluding members from doing it, it's not absolute bar, but you do have to reach a decision. Am I here as the arbiter of the decision making process?
Yes.
Because I think the two do conflict.
Yes, exactly. So you have to make a decision what capacity you're going to be at committee in. Can I, while we're on this point at page 83, 84, if this is going to go into a document, please can I ask that the paragraphs which are being extracted from the Code of Conduct at 2.1 and over the page from the City Council and the District Council conduct, can I just ask that they're increased in size because they're very small and very difficult to read. And likewise, so please can I ask that to be a recommendation if it does go forward, and I'm not saying it will, but can I ask that to be done? But the other thing is on page 63, in an effort to put north at the top of a portrait page, we've got a very, very peculiar distorted image of the area for North East Cambridge. And I object to this map strongly, and I would like it to be landscape the other way around. We're perfectly capable of turning our documents around and looking at, but if it fits better as landscape, I would prefer that image not to be so distorted. Right, back to Heather Williams.
Thank you, Chair. Just one thing on, as we're talking about report style, when we look at pages 68 and 67, we should be really clear that that is Cambridge City Council's constitution, not our constitution, because I've heard those page references be sort of brought up.
It's listed at the top of the page.
Yes, it's at the top of the page, but it's quite small, and then you get to ours, but it just says part 3. It doesn't actually say that that part is in South Cambridge District Councils. So I think it's not very clear when you're reading this document which constitution you're reading for. So this is going to be my sort of opinion. I think we've gone through clarification to death, to be quite honest. So my view is
we've gone through clarifications because people were seeking clarification, Councillor Williams.
Yes, but I'm just saying we've got, and actually, it completely proved my point that we should have deferred this item. We should have had a briefing and a workshop and actually understood this properly, rather than spending nearly an hour where we've still got issues, still got problems. And to be quite honest, it's still not clear around call-in and the wordings around call-in and where that can happen and where the local member is involved. It deals with delegation, it deals with these 5 representatives. I share the same issues. I think this is written with a very urban approach and does not actually take into consideration what happens in the smaller parishes, where people aren't so used to planning applications and where they're not necessarily as organised, and equally not in single member wards, which is a more rural situation, and there aren't multiple local members. The call-in is not clear. It should be set out, and it can be legally set out in its own right, and it's not. I understand the idea of, you know, delegating everything and calling things back, but it really does not sit well for me. The thing when I read this, and even from hearing the conversations that are going on, is very much about taking local voices out. I don't believe that is the intention, but I think that is the consequence of the way this is drafted, and actually why members who come at this in a different perspective, that is our role, are struggling with it, and why we have the issues that we do. So I'm not willing at all to endorse it. I would like it recorded in the minutes that I do not endorse this, because I think we're talking about integrity of the system, but actually, you know, these delegation meetings, if ward members can attend, which is something that I know myself and others asked for many, many years ago, then great, that's progress, but they're still behind closed door meetings. And I think automatic call-in, as many know, I think is much more appropriate. And equally, you know, it might be a householder permission, but it could still be very important to the people of that village. It's not about the whether it's 5 people or 3 people. 5 people in one of my villages is 25% of the village. There's only 20 houses. Yeah, it cannot be so arbitrarily done. And I think if something isn't right and our community wants us to hear it as their elected representatives, then we should be. We should not be. And I appreciate we're saying there's some workaround where officers might decide, but the wording in this, the conditional language in this, doesn't mean it will. There's so much conditional language that does not give me the certainty that when something needs to come to committee, it will, because we've got wording like should, and that can be. So I think the language is not enough to give me any form of reassurance either, and I think we will be not, you know, there's the legal element, but I think for residents, this is absolutely the wrong way to go. And if we need to be different from city, that's fine. Angela Rayner hasn't reorganised us yet. We can have our own sovereignty.
Thank you very much. Okay. Right, just one moment. I need to take some legal advice. Okay, so, as you will have heard from me, I'm not wildly happy about this document, partly, I think, because the collation of documents and has not been, it's not clear why some certain parts are in, and we've now had some of that explained. But I think there are some concerns about this. So, but what we're mindful of is that this is due to go to what is now called JDMC shortly, and it's due to go to Civic Affairs. Rebecca has said that we can issue a guidance document that explains the ways, the simple summary of the ways in which items can be called in. And what I'm concerned about is that we should not jeopardise the time frame for this, because it's going through a whole series of discussions. So my proposal is we proceed to a decision today, but with the understanding that Rebecca has undertaken to prepare a guidance document that clarifies the decision-making process. So we don't have any other people wishing to speak at present.
Can we have legal advice as to what actually assurances a guidance document would do? Would it have any standing at all?
Well, obviously, if members make a decision to endorse it today, then before it goes to Civic Affairs, it will be presented to Civic Affairs as though that has been endorsed. So, obviously, if members are against it, then...
Can we endorse it with a guidance document that we haven't seen yet?
No, well, no.
Exactly.
I think you've answered your own question.
But could a guidance document be relied upon?
I think you can... I mean, this is where members have got to put their faith in professional officers. Stephen will probably come back in a second, but this is why it's come to committee to discuss the details of it. So I think the explanation was it has to be done in a certain way because it forms part of the council's constitution. So it has to be in a certain format to frame looking at how the cascade, because councils are a creature of statute. They have to have everything enshrined in that, and that is their constitution. Now, this document, Stephen will say, everything is in there. It may not be user-friendly from the point of view of lay people, members, etc. And so if anything can be done to sort of point to where call-in and things like that, I think that could probably be clarified in terms of maybe having a heading saying member call-in or something like that. I can't obviously offer that yet, but I'll bring Stephen back in. But there has got to be, I think, a decision made because it's going to Civic Affairs on the 28th.
I'm not saying about the decision, to clarify, I'm saying this guidance note, if it was done, could it be relied upon to enforce the rules, or is it just simply a guidance note?
It's to make it more user-friendly to a reader. It can't change the word. The substance is actually there. And I would say, being someone who reads these all the time, it's fine. Obviously, you're not going to take a leap of faith necessarily on that. But if we bring probably Stephen back in, it would be helpful.
Hang on. Sorry. The legal advice, it still exists in this document as it's put in front of us. The guidance would simply be a guide through it. So it wouldn't need to carry any legal weight in its own right because it would just simply be an explanation.
If I could probably explain it as a way of, if you're at your desk and a member of the public contacts you, you could turn to this guidance and think, this scenario is cropped up. I think that, from a practical point of view, if that would assist, I think that's probably what you're after.
Yes, because I must say, as a local member, I found this tricky.
Sorry, can I ask a question? Maybe that might help. Members are not happy with endorsing. I wonder if we could note this.
Yes. Well,
I mean, I want to say thank you to the officers for what they've done. I mean, it's a lot of work that's gone into this. And, we've discussed quite a lot. There's concerns. But I think we can move forward if we note the report instead of endorsing the report. I don't know if that will help.
I would like
That way,
to
then
suggest,
going to civic affairs
I
can
would-
then go through the
Absolutely.
other
I would like to suggest that we, thank you very much for that suggestion, that we note the report and request a guidance note to be produced to make it easier for day-to-day decisions to be made by parish councils and local members.
Chair, can I
Okay, Stephen?
can I offer some clarification here?
Yeah, thank you.
The recommendation on page 16
It's to endorse.
has three elements. 2.1, which is to recommend and to endorse the following for approval at South
We're
Cambs
looking
Civic
at page
Affairs.
17,
Okay,
members.
page 16 and 17.
Yeah.
There are three items there. The first is the scheme of delegation that you have discussed. We've heard Councillor Williams and Dr. Richard Williams expressing a concern about the scheme of delegation, and Councillor Redrup and so forth. There is a second recommendation that the amended public speaking rights at Planning Committee be referred onwards. I've heard no comment on that, and we've heard and had a good discussion on the amended Members' Planning Good Practice Guide. I would suggest that the way forward is to take a vote on each of those items and to note, for us to note in the context of that, a commitment that I've given to Councillor Dr. Richard Williams on 3.12 of the Members' Good Practice Guide to clarify that.
Yes.
Now, in addition, it has been suggested that officers provide a guide which would be non-legally binding because it cannot be. The scheme of delegation is the legal authority for the decisions that as a committee you will make and officers we will make, and there can be no doubt about that. But that what is perhaps done is an individual vote on each of those three items is taken. We've heard comments in which there are concerns that the number, in fact the number we're introducing, there is no number at this moment in time for that default call into the scheme. So the additional control that the committee has, we've heard Councillor Heather Williams say that she's not supportive of that measure, but I suggest you take a vote on 1, 2 and 3 separately, with the caveat that on part 3, we have already undertaken as officers before this matter goes to Civic Affairs to review particularly paragraph 3.12, which Councillor Dr. Richard Williams has expressed a particular concern about. And that if that vote falls or it is not carried, then clearly we will need to bring the item back in some way, shape or form, or for planning committee's comments. And we'll have to work through a way of doing that.
Right, okay, so thank you very much, Stephen. So can I just summarise? What is your view of the change of the wording from endorse to note?
You can determine not to make any comment, you can determine to endorse it, or you can note it. But the point will be reported to Civic Affairs that the Planning Committee either endorsed it or didn't endorse it and noted it. But I think that if the Planning Committee doesn't endorse it, the matter is then for Civic Affairs and in due course for full council. But I would encourage you to refer it on to Civic Affairs, at least with, in the first instance, if you are willing as a committee to endorse it, you need to vote on whether you wish to endorse it.
Yeah, absolutely. So firstly, I'm minded to take this in 3 parts, as you suggested. Secondly, I'm minded to vote, well, actually probably first, I'm minded to vote on whether we choose to endorse or to note. Can I just have an indication from members whether you are happy to go ahead and make a vote on the basis of endorsing first, and I shall take the 3 parts separately, the scheme of delegation and the public speaking rights and the planning good practice guide, or whether you feel you just want to note. So the other thing is we need some amendments, as we've suggested, can we please have the point size of that section on page 83 enlarged so that it can be read more easily? And can we please have that map of the northeast Cambridge area on page 63 reorientated so that it's more readable? Okay. Right, okay. So,
Chair, can I just say, the recommendation in front of the committee is to endorse it.
So we need to do that
If
first.
that
No, don't worry,
fails,
that's fine. Yes, we've got that.
then it
Okay, right, so let's go and look at these with the recognition that Rebecca has said she will work towards producing a guidance, a simple working document, guidance document for parish councils and members to use. So can I propose I propose that we follow this recommendation, and I will read it out. It's recommended that the South Cambridgeshire District Council endorses the following for approval at the various city civic affairs committees before approval at each council. Firstly, the Greater Cambridge Shared Planning Service Scheme of Delegation, December 2024. So we have yes, and do we need to take this by vote? Yes. And do we have a seconder for that? Thank you, Councillor Fain. So can we vote on that first part, please? Aaron, would you take us to the vote? And we are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 in the room. Okay, so that's first part is 8 votes in favour, 3 votes against. So that is carried. Can I then ask if you endorse, in similar terms, the amended public speaking rights at Planning Committee? Sorry, are you ready to take that second vote again, Aaron? The amended public speaking rights are on pages 77 to 82. Okay, and nobody made a comment about that. So that's 11 in favour. That's carried. And the members' good practice guide, bearing in mind that Stephen Kelly said he would look at clarification around 3.12 and also that we're going to enlarge the point size. Are you ready to take that one? Yeah, I should be loading now. Thank you.
That's unanimous.
So we're unanimous on the good practice guide. Okay. Okay, all done. So that's 11, that's unanimously carried. Thank you very much indeed, members. I'm sorry that was such a complicated process. Yes, shall we have a 10-minute break?
Sorry, there's
Yep.
two other recommendations.
Recommendations. Where?
I think maybe just for completeness.
Okay.
Sorry, we just...
Do we need to vote on these? So can I just draw members' attention to page 17, paragraphs 2.2 and 2.3, which say that the committee delegates authority for minor amendments to the drafting to assist in providing clarity only to officers in consultation with the relevant executive councillor, and 2.3, that a review of the revised scheme of delegation be undertaken in 12 months' time and a report prepared to each committee for consideration and action. Can I ask for your affirmation of those?
I think probably just to agree.
Do we need a vote?
I think to be complete, because we've in
okay,
fact severed the
okay, we'll take 2.2 and 2.3 together. And if you could just indicate your vote on that, please. Thank you. Thank you, Aaron. One vote missing.
No, I voted.
Peterson?
It's up to saying it hasn't taken yours, so it's just, yeah, that is. It's gone now.
Okay, right, so that's 11. Lovely, thank you very much, members. Right, I propose a 10-minute break. So until, yes, what's 39, 49, so 10:02, please. Thank you very much. I apologise for the longer pause than anticipated. The next item on our agenda is item 6, which is for a provisional TPO at Coton Orchard, Cambridge Road, Coton. And it starts at page 97 of our agenda pack, and it's regarding a tree preservation order requested at Coton. Just before we start, can I just explain that prior to the, just some short time ago, we received an email from a Rob Sadler, who raised some points about the application, and that email has been circulated to members of the planning committee. I apologise to those I said, I thought it was in the public domain, but no, it had gone to planning committee members. And he was offering councillors the opportunity to inspect the strip of land or walk the busway line across Madingley Hill, now or at any time in the future. Please do not hesitate to get in touch. And he was raising the issue about the line across Madingley Hill of C2C, the Cambourne to Cambridge busway. However, that is the subject of a separate application, and I misunderstood when I first read that email, and I thought he was speaking as the landowner. And when I've gone and spoken to the landowner, she has made it clear that that did not come from her. And whilst I haven't asked whether she'd be happy for us to have a site visit, if we were minded to do that, my impression is, and this, forgive me, this is on a very brief discussion, my impression is that the landowner of Coton Orchard, which is what this application is about, would actually prefer it if we proceeded today. Would you like to indicate if that's what you wish? Yes, thank you. Nodding your head. So thank you. So members, I had indicated we might have considered a deferral in order to have a site visit. But on closer examination, that site visit related to C2C, not to this tree preservation order application. So expunge from your minds, if you will, all that discussion I had with you about possibly deferring, unless you still think it's worth doing that. So what I just want to establish is that what we're looking at today is this tree preservation order proposal for Coton Orchard. And unless anybody makes a different request, I'm proposing that we go through as we would have done before we had that request for the site visit. So, does anybody wish to suggest anything different? No. Okay, so it looks like we're going ahead as planned. So thank you very much, and thank you for your patience in my requests for further information from you. So, firstly, let's ask, so the application is to consider whether to serve a provisional tree preservation order within the parish of Coton for the protection of 12 Bramley apple trees. And our presenting officer is Adrian Sargent. Yes, he's here. Okay. So, over to you, Adrian. Thank you. And please do speak slowly and clearly to allow for the echo.
Good morning, councillors. I present to you the Planning Committee today for the consideration for serving a provisional TPO on 12 veteran apple trees in the location of Coton Orchard, Coton, as requested by the councillor through a TPO request. So, as an introduction, the two images you can see. Image one is give you a context of the apple trees in question. And image 2 is the 12 is a location plan identifying the 12 Bramley apple trees in question within the site of Coton Orchard. On the wider landscape to Coton and where the position of the veteran apple trees are, you can see the orange polygons highlight where the trees in question are. North of the actual enclosed orchard, you've got Coton Orchard Garden Centre itself, and then bordering the south of the enclosed orchard, you've got the village of Coton. It's understood there's no public rights of way into the enclosed orchard. The trees themselves, they are sheltered from obviously mature vegetation to that site, hedgerows, mature trees, and also other fruit trees, as you can see from the aerial photo. With that in mind, it limits their visibility from obviously public points of view, such as roads, public open spaces, and footpaths, and so on. Here we've got a selection of the Bramley apple trees from my site visit back in August last year. What you can see there is an example of the variety as such of their condition, their characteristics, their physiological condition, the structural condition, which has given them the veteran status. So the busway corridor, and in relation to the veteran trees, image 1, as you can see, is taken from GCP proposed plan of which trees are within the corridor between the two red lines. You've got T5 to T10. Essentially, I think it's 6 trees there, essentially, within the corridor. Overlaid on image 2, you can see that orange rectangle, if you like, which is to replicate where the busway will be having an impact on the apple trees. So to indicate there's a section there, it's not impacting all of the 12 trees. Considerations to a TPO request, firstly we need to consider the reasons behind it. We understand it's in relation to development of infrastructure, as in the Camborne to Cambridge busway. Recognising the Bramley apple trees age classification, we understand they've been given veteran status from arboricultural surveys and through the Woodland Trust tree inventory log records. Further to that, we've got my evaluation using the tempo assessment. That's tree evaluation method for provisional order. So in terms to the tempo results, it suggests that the trees merit a provisional TPO. However, a tempo is not the final decision maker for TPO, as legislation is the main directive when considering an order. Further to that, we've got legislation. As the council planning tree officer, it is important to adhere to legislative guidelines to determine if a TPO is suitable or not. This is reflected in the final TPO request report dated the 1st of November 2024. So, legislation continues, national planning guidelines, a local planning authority needs to consider if it's expedient in the interest of amenity to make a provision for a preservation of trees and woodlands in the area. When deciding whether an order is appropriate, authorities are advised to exercise their judgment in relation to expedient and amenity. So what does expedient mean in practice? So this is again further government guidelines. Although some trees and woodlands may merit protection on amenity grounds, it may not be expedient to make them the subject of an order. For example, it is unlikely to be necessary to make an order in respect of the trees which are under good arboricultural or silvicultural management. As to the Town and Country Planning Act, Tree Preservations, Regulations 2012, Regulation 14. So there are exemptions that apply to an order. Any permitted development where TPOs exist or permitted, or proposed, the planning decision itself will override the tree preservation order. Furthermore, there are tree management exemptions associated to an order related to fruit trees in respect to good horticultural practices. So, key factors towards officers' conclusions. So we've got, again, just to recap, is the reason for TPO in connection to development of infrastructure, tree age classification. We recognise that the trees have begun veteran status. The tempo score, it suggests that the 12 trees as a group are worthy, in a sense, or for consideration for a provisional order. However, tempo is an aid for tree officers. The final decision is based on legislation guidelines. Use of the land and management of the apple trees. So it's understood the veteran trees are under exceptional management as reflected across the wider site. And that's based on my site visit and doing research into this. The owner of Coton Orchard has provided information suggesting that the site is used on occasion by community groups, local community groups, and events on permission, which obviously gives access to viewing the apple trees in question. Legislation and central government guidelines, again, expedient in the interest of amenity and exemptions. By all accounts, the veteran apple trees are not under threat through ownership or their management. The very nature of the location restricts their visibility from public points, roads, footpaths, public open spaces. Although acknowledge that the site is used by community groups via invitation from the landowner. The planning system, TPOs can be overruled by the planning decision. So it's fundamental to understand that the TPO request is in response to development of infrastructure, which in its entirety is governed under the planning legislation, concluding that endeavours to protect the 12 apple trees through a TPO is deemed unsuitable as permission of development, if granted, would override any TPO. So to this end, officers' recommendations that planning committee decline issuing of the provisional TPO.
Thank you very much, Mr. Sargent. That's very helpful. Do members have any questions of clarification for the tree officer? Councillor Martin Khan.
It's an issue that's, there's been a lot of discussion on this, obviously, publicly, but something that's not been raised in terms of the protection of the 3 trees, basically, which will be affected by the proposed development.
Do you mean 6?
The 6 trees in the line, but as I understood it, is
some
probable
suggestion that 2 of them on the southern edge might not be included, but I think we have to consider.
The other one, there were 3 which were on the edges and might well be avoided with good management of the thing, as I understood it. But in any case, 3 or 6, whatever, the assumption is that they will be destroyed by the development. Just for context, I would like to know, it's always occurred to me that the trees are quite small relative to trees, and they might be able to be moved by a tree spade or such. Would that be a possibility? Would it be possible? Are they condemned fully by the thing, or could in fact they be preserved by some other management technique, such as a tree spade?
So yeah, in terms of, I think it's called compensation mitigation works within the GCP in terms of the veteran trees, that translocation is mentioned but it's got to be agreed with the landowner. Obviously, it's got in terms of the location. So it is covered off in a sense as a option.
Thank you. Councillor Fane.
Thank you, Chair. Sergeant, you referred to veteran trees, and there are, of course, various definitions of that. What I wasn't quite sure about is whether all 12 of the trees concerned would count for veteran status, and if not, perhaps you could just refer to diagram 2 again to show us which of the trees would be veteran status in your view.
Just bear with me and just refresh. There we go. We got there in the end. So, yes, definition of veteran trees, the National Planning Policy Framework, there's a definition in there of what a veteran tree is. There's characteristics such as decay, cavities, age-related, crown retention, historic pruning, and in consideration of the tree species themselves. The Woodland Trust have, I think, a more simplistic definition of what a veteran tree is, and so there's a slight difference there, but almost the same. And so to highlight, in the sense, in the Woodland Trust eyes, in the sense of the ancient tree infantry, is that all 12 trees there are classed as veteran trees. However, if you're looking at the GCP Arboricultural Report, I think it classes only a few of them as veteran and the others as notable, as in they are starting to show characteristics to become veteran trees. So in terms of in between the red line of the proposed busway, I think it's understood that 2 are veteran trees as to the GCP Arboricultural Report, which are the ones that sit on the towards the red line boundaries, if you like. Does that answer the question? Yeah, so we took a look at T9, T5, and I believe it does cover off as well T10, but I believe it's more so T9 and T5 that are classed as veteran.
Right, thank you. So Councillor Dr. Timmy Hawkins.
Thank you, Chair. Obviously, this is an emotive issue, but just going back to Councillor Dr. Khan's point.
Oh, sorry. Is this a question for clarification of the
Yes, it's a question. In terms of you mentioned translocation has been, or is one of the issues considered. Is that right?
So,
is the GCP looking at potentially doing that?
It's an option within the GCP mitigation works, as in compensation to veteran trees. So I believe it's just an option, as to others as well, about also including taking pruning shoots off and replanting and grafting and so forth of the trees in question. So, yeah.
It's the translocation. They will take it and move it somewhere else.
In terms of the practice.
Yes.
Sorry. Yeah, it is as simple as that. Yes. Yeah.
Okay, I think we just need to focus on the fact that that could happen separately, but what we're looking at here is the consideration of applying or not a tree preservation order. Do you want to come in?
Yeah, I think it's important, members, at all times with dealing with this application to bear in mind the GCP scheme is a material consideration for you, as if the TPO is made would be a material consideration for the Secretary of State. But the two are not related. So while the tree office has been helpful, it's the applicants, the GCP, who will be doing that mitigation if needed, etc. You can't have an influence on that. So obviously members have to kind of separate this from the busway scheme, determine it, bearing in mind the protections that would normally be afforded under a TPO, and subject to it being confirmed within 6 months, are not necessarily going to be there because of to coin a phrase, sort of the higher power. So it could be one of the exceptions that the tree officer mentioned, which is that works by a statutory undertaker, works by a government department, etc., would override the protection of the TPO. So I think we couldn't impose conditions that would bind on the Secretary of State. So if members could keep that at the forefront of their mind when determining it as part of the debate as well. Thanks.
Thank you very much for that clarification. So I can't see any further hands up for questions to the officer. So I just want to remind you about the order. Oh, sorry, Dr. Richard Williams, sorry.
Thank you, Chair. I did just have 2 questions for clarification, just to help get my head around this. So, just in terms of the Regulation 14 exceptions, would it be the case that a planning permission, were it granted for the busway, would negate the whole of the TPO on all 12 trees, or would it just negate it for the trees that would be affected by the bus route? Because I take from your slide that not all of them actually would be affected by that. And then my second question was, the way I read the reports is there are kind of 2 key reasons in the recommendation, I think, for recommending we decline. That's the amenity issue of it not being, accessible to the public, etc., and the planning, the potential transport works application. It would be really helpful to get a kind of idea of the weight that has been put on those 2 things when we're assessing amenity, which is what we need to do. Yes, so I don't know if it would be possible to get some idea of that. Thank you.
And in fact, if I can also ask, I was also going to ask, my understanding was that for a tree preservation order to be applied, it needs to be visible from the public realm. And these need to be trees that have a recognised public amenity. So perhaps you can clarify both those points, Adrian.
So the first question is related to, could you repeat the question for me, please?
It was if we put the TPO on 12,
yeah, sorry,
and only 6 are required.
Yeah, sorry. So as the TPO would be seen as the group as such, so the busway would be only affecting the 6 related.
So the TPO would remain for the ones that are unaffected.
I'd have to get sort of legal advice on that to get clarification, but.
Sorry, through you, Chair. Then, so the exception in paragraph 14, 6 is so far as such work is necessary to implement a planning permission.
Sorry, paragraph 14, where?
Of the this is the
okay,
Town and Country Planning Act 1990 as regards the tree. Yeah, the exceptions to this. So it has been summarised by the officer. So as such work is necessary to implement a planning permission other than an outline permission or without prejudice. Sorry, a permission granted by or under the Town and Country Planning General Permitted Development Order. So that is where the GCP works bite. So it's going to, for them, it will be the works that are necessary to implement that. So if they could implement it without doing that, then it wouldn't affect those trees. But if they can't institute their permission without the removal of those trees, then 14 bites.
They would be able to do that.
Yeah, it doesn't. I don't think it's over and above what they are permitted to do in line with the permission that is granted or not granted by the Secretary of State.
So the regulation says nothing in Regulation 13 shall prevent the cutting down, lopping or uprooting of a tree, in this case, to enable the statutory undertaker to carry out development permitted,
Sorry, it's not the statutory undertaker because it's expressly, it's
So
the
which
carrying out of planning permission. So it's subsection 7 of paragraph 14 of the.
So far as such works is necessary to implement a planning permission, other than outline planning permission without prejudice to paragraph blah blah blah, a permission granted by or under the town and country planning order, granted on an application under part 3, or deemed to have been granted. So it's that section.
So the permission gives the legal power, and the Transport and Works Act order is a bit like a compulsory purchase order. It has a suite of documents within it necessary to affect that permission. So it could be side roads orders, diversions of public rights of way, etc. But if that is not needed, it would not be reasonable to ignore the fact there's TPOs on the other trees that are not affected. So I don't think it precludes those other trees. I've just been passing notes. Would the TPO remain on the other 6 trees?
Yes.
My opinion, it would,
Yes.
because it's not necessarily needed for the implementation of the planning permission.
No, exactly. Exactly. So I think that answers your question, Dr. Williams. And the second one was the amenity issue, wasn't it? Whether it was in the public domain.
Yeah, the weight that's being put on amenity versus the planning application.
Who can advise us about the weight that might apply? Is that Adrian or Rebecca?
Again, it relates under the planning regulations, does it not? I mean, through the evaluation of the trees in terms of amenity, it's been recognised they have a level of amenity, but it again refers to the expediency of as well of serving, if it's necessary to serve a TPO. So in terms of in the context of are we talking about the busway in the sense?
No, we're not talking about the busway. We're talking about the trees.
Yes, yeah, I know, but I mean in relation to them.
But it's important not to confuse the issue.
No, quite.
So the question is, what amount of weight do we need to apply? I think that's a little unfair to ask the tree officer that, but Rebecca, perhaps can you guide us?
I think, I'm not sure what I've done to my mic. I think in terms of the assessment that we've made, the amenity of the trees isn't in question, and we've said that the amenity of the trees is at a level where they would be appropriate to serve a tree preservation order on. However, the weight of the expediency of serving that tree preservation order has been given more weight than
just hang on a minute, and now I'm going to come back to the legal officer who would like to speak about that. Thank you.
So it's a little bit of a law lecture today, but the definition, I think the important thing is the expediency of it. So we've seen that the criteria for amenity is probably met in the officer's report. So use of the word expedient, okay, there is case law on this, but not particularly helpful, but it suggests a broad balance or judgment is to be made by the decision maker. So I think in that context, it has to be, unfortunately, for the planning committee to decide whether expediency in the sense of the word, that it's necessary in case there was someone there with a chainsaw about to hack it down, or works that were being done, or the trees were being neglected, etc. That has to be looked at in the context of what at the moment are healthy trees, they're being managed, etc. Taking on board the effect of the TPO on the Transport and Works Act order as well. So members need to take a kind of holistic approach to, is this different to a normal TPO in someone's, in some land that people see?
Yes, so can I just throw a question out there? So the officer recommendation is that whilst the trees merit the TPO, because it could be overturned by the Transport and Works Act order for those 6 trees, the recommendation is not to do it. My question is, what is the problem with, if the committee wished to support a TPO, because the Transport and Works Act order would do the work that they wanted to anyway? So who's going to answer that one?
Well, I think you've made the point. It's within the members' gift to take a contrary view to
So
officers.
wouldn't it-
Expediency probably is about the having to go through the process. Ordinarily, it's to protect the tree.
Yeah,
Ultimately, that may not happen. So members should just be walking into it with open eyes.
No,
But that
sorry,
could
two
occur.
different things. We're looking at 12 trees that are being requested for the TPO. So, for example, I'm just going to lay out the two examples. I'm not going to say wait either way. I'm just saying this is what the committee could choose to do. They could say, yes, we agree with the officer report. The trees merit it, but it's not practical, let's say, to do it. So we won't issue a tree preservation order. And then the trees may or may not get used to put anything through. But the point is, the 12 trees would still be protected. The other option would be to say, no, we disagree with the officer recommendation and we want to have the TPO on 12 trees, and if the Transport and Works Act order comes through, then they will override it anyway. So, yes, perhaps Jane Green could give us some advice. Thank you.
Well, it's simply just to add to what you've been saying, members, you're absolutely within your rights to make a decision to protect them or not protect them, go for your 6 rather than your 12. We've talked about the Transport and Works Act, and obviously that's a consideration for you. The other two elements are the fact about how visible these are or not. That is a normal consideration. This is on private land, so that has been part of our consideration as officers. And then the other thing is, these trees are really well maintained, and they're not under risk in terms of neglect. So that's the balance that we as officers have had. It's been three elements, if you like. Yes, we've got the Transport and Works Act. Are the trees being neglected? No, they're on a really well-maintained orchard. And actually, although there is some access because people are being invited onto the site and there are community groups, but actually there's not general public access. So that's where we as officers have come from. But obviously, you're entirely within your rights, members, to make your own decisions as to what you wish to do. But that's the advice in front of you today.
Thank you. That's, as it were, answering on behalf of officers to queries to officers. Yeah. Right, I'm now going to open this up in the normal way to the officer to give. He's given his presentation. The order of speakers is firstly the objector to the application, objector to the decision, which is Anna Gaisley from Coton Orchard. Are you hoping to speak today? Yes. So do come forward to the microphone. And so this is Anna Gaisley from Coton Orchard Fruit Farm speaking against the officer recommendation, and you get 3 minutes to speak.
Good morning, members. Thank you for giving me a chance to speak. This is my first time in this forum, so I beg the members and the chair's indulgence if I don't adhere to protocol entirely.
We'll warn you as you get towards the end of your 3 minutes so that you can wind up.
Has my time started already?
Not yet, no.
Okay, well, if I could just get through a little point. I've got a statement from me, and then our deputy chair of the parish council who had come to speak, but because things went on a bit longer than she thought it would, has left me her statement. So this is Dr. Marilyn Treacy. So if I may, after I've said my bit, can I then go on to read?
I think if we have a statement from the parish council, I think we'll ask the officer to read it. Thank you very much.
Oh, okay, the officer will read that.
So just one moment. Yep. Okay.
Right. So that's Dr. Treacy's statement. And if I could just quickly add about the veteran.
No, that has to be part of your speech. So do you want to make a comments about your? You have 3 minutes to speak, and if you want to talk about the trees, it has to be within that 3 minutes. Okay.
Okay, so good morning, or actually good afternoon now, members of the committee. My name is Anna Gaisley, and my family owns Coton Orchard, where the 12 Bramley apple trees under consideration for this provisional tree preservation order are located. While I did not submit the application, I fully support the TPO due to the tree's significant historical, ecological, and environmental value. The tempo assessment of these trees scored a 16, indicating they definitely merit a tree preservation order under the guidelines. These trees are recognised as veteran and noble and are in fact all 12 listed as ancient trees in the Woodland Trust Ancient Tree Inventory and have been the subject of conservation-focused management for decades. As the current custodian of this site, I can confirm that we have no issues adhering to the requirements of a TPO, nor would we invoke exemptions for fruit production to override the protection it provides. The orchard is under a covenant with the National Trust, so we have operated under similar restrictions without difficulty. I would like to address the concern that the TPO alone cannot protect the trees if the Transport and Works Act order for the Camborne to Cambridge busway is granted. Firstly, the implication that the TWAO is inevitable is not accurate. There is a diverse and organised coalition led by Cambridge past, present and future actively challenging the proposal, which remains highly contentious. Groups such as the Woodland Trust, Wildlife Trust, experts and local campaign organisations have raised serious environmental and fiscal concerns. Moreover, CPPF has presented a viable in-highway alternative to the GCP routing through Coton Orchard, demonstrating that granting of a Transport Works Act order is far from a done deal. Currently, 23,300 people have signed a petition opposing the development and advocating for alternative routes that would preserve this important site. Secondly, while it is true that a TPO alone cannot guarantee the tree's survival, it is a vital tool in the arsenal for protecting them. To refuse to protect something simply because it may still face risk is illogical. The loss of these trees would have a significant impact on both the local environment and biodiversity at a global level. These trees support a delicate ecosystem, including species listed as globally threatened. Removing them would contribute to the erosion of biodiversity and undermine the ecological health of the region. The argument that the public must have direct sight of the trees to benefit them fundamentally misses the point. These trees provide benefits that extend beyond visibility. They enhance biodiversity, support pollinators critical to food security, and provide habitats for migratory species that connect the region to ecosystems worldwide. Their value lies not just in their visibility, but in the life they sustain and the environmental stability they help maintain. In conclusion, I urge the committee to approve the TPO on its merits. Protecting these trees would demonstrate the Council's commitment to safeguarding vital natural and cultural resources. A TPO may not be the only solution, but it is a critical step towards ensuring these trees are preserved for generations to come. Thank you.
Thank you, Miss Gaisley. Members, I just need to point out that the matters that Miss Gaisley has mentioned to do with the Camborne to Cambridge busway, you need to just, that is not relevant to this application. We are looking about the trees in their own right, their own merit and their own value as an amenity and trees that might wish to be, we might wish to consider preserving in their own right. Okay, thank you very much. Right, so, no, sorry, I'm sorry, you've spoken. The next speaker, I'm sorry, Mrs. Gay, sorry, I don't know if you're Miss or Mrs., but thank you very much for your speech. Good to hear what you have to say. We then have the applicant, so Councillor Heather Williams. I believe in this regard you're speaking as Heather Williams rather than as councillor. No, but I mean, you're not speaking as local member. I think you're speaking as the applicant. I'm just making that distinction.
Chair.
Thank you.
Chair.
Oh, sorry. I forgot to ask if members had any questions of Ms. Gaisley. I apologise.
Sure, I have to retake the seat.
Do you want to, sorry, would you like to come back and then members can ask you a question and you'll have the microphone available. Sorry, Councillor Khan.
There's been some discussion about translocation, and if not knowing what the decision will be on the busway, if the busway is given permission, would you be objecting to translocation onto of the trees that would be affected onto your property? Just as context.
To answer your question, and thank you for raising the question and giving me a chance to answer, is because it's not that we would object, I definitely wouldn't object, it's that these trees, because they're ancient, the hollowing of the tree itself makes them very fragile. One of them is the second largest ever recorded in the British Isles, And these 12 core trees have a very complex network of rooting systems in the soil, connected by mycorrhizal fungi, that you can't just scoop one out and sever all those connections, lift it up and translocate it somewhere else. So it's not our willingness to allow that, it's the fact that these are ancient ladies that have stood and witnessed history. They can't just be scooped up and put somewhere else. They would just die.
Okay, thank you. I can't see any other questions for Ms. Gazy, so thank you very much indeed for answering that. Okay, so now to Heather Williams. So you have 3 minutes and you're speaking as the applicant. Thank you.
Thank you, Chair. Thank you, members. A lot of what's been said in this application as on both sides has been well-meaning and well thought, and I understand why the officers have done what they've done. But I do think, as I said earlier, members, and as one of our officers pointed out, have the opportunity to make a different decision. And I would urge members to do that today, to go against the officer recommendation. The tree that was referred to earlier is the champion tree, second largest in the United Kingdom. And a lot of debate seems to be around the future and expediency, and we've already had it established that there is an amenity and the tempo assessment and everything else. And I think it comes back to the question of why we sat here as councillors today, and what does our actions mean for our district as a whole, and for the locality and for the residents' future as well as existing. And for myself, I think the idea of not giving TPOs because in the future something may happen would warrant never giving out a TPO for anything. It would warrant never giving trees protection because what if X, Y and Z happened? Now, yes, there are some real imminent threats out there, but they are not decided yet. They are not in stone. And this is about the trees. Yes, there's the busway going on, but there's also East-West Rail. There's so many things. We have no idea what the future holds. And equally, if any of these projects happen, the impact that it will have on ownership. Yes, the current owners do a fantastic job, but as has been said, they are the current custodians. We don't know where the future will hold in 10, 15 years' time, but I would hope that we as councillors could say that we did everything we could to protect these ancient trees and the wildlife that stems and biodiversity that stems from it. We speak so much as councillors about the importance of biodiversity, ecology, of trees, tree coverage. In fact, we've got a report that's come through another committee recently on tree coverage. This, I understand it may feel counterintuitive to some given what's out there, but they do not have permission yet. And I think that the best thing, the way we could all look ourselves in the mirror, is if we give permission for this TPO, and if we ensure that we do our bit, which is what we're elected to do, to protect these trees. What happens in the future, what other authorities do, or governments or anything like that, that's down to them. But today, it is a decision as to whether or not you want to protect those trees.
Thank you very much. Okay. Does anybody have any questions for Councillor Williams? No. Okay. So the next speaker then is, would have been, do we still have that paperwork? Can I just, we have this script from Councillor Dr. Marilyn Treacy, who's Coton Parish Council. Now, what I would have asked her if she had been here was, did she have the authority of her parish council to speak on their behalf? And I haven't had a chance to ask her that. I didn't realise she was leaving. Also, the document that we've received has a watermark of draft through it. So my legal advisor is saying we don't think we can accept it. Do you want to speak?
Yes, I think it's as the chair said. Ordinarily, the representative is asked if they have authority to speak on behalf of the parish. we can't ask that, but also more concern to me is that we'd be potentially reading the words which are not her final intended words, because there's a watermark
She did leave it with us, though.
draft. I didn't.
Well, she left it with the with
Right,
Anna.
okay.
Gazer.
Well, it's
So I
it's
think
your discretion, Chair, if you want to.
Okay, I'm going to. Also, she says here that she is Deputy Chair of Coton Parish Council, so I'm hoping she has their authority. I will read this, but obviously there won't be any opportunity to ask us any questions. So, my name is Dr. Marilyn Treacy. I'm here today in my role as Deputy Chair of Coton Parish Council and a long-time resident of Coton. I would like to encourage the committee to support our residents and approve this tree preservation order for the 12 Bramley apple trees at Coton Orchard, which hold enormous value to our community. If these trees are worthy of a TPO, it should be granted. These trees are far more than part of an orchard. They represent a shared history and connection with the village. These veteran apple trees are part of an arboricultural unit, and the impact on any of the individual trees will detract from the cohort as a whole, which is why it is so important we preserve them. The trees stand as a legacy of Coton Orchard's long heritage, with ties to founding families such as Rayners. Peter Rayner was born in the orchard, and his family still reside in the orchard in Coton today. Many current residents have fond childhood memories of picking apples and spending time under the canopy of these trees, sharing stories and traditions that span generations. Beyond their cultural significance, these trees are an integral part of our environment. As noted by the South Cambs District Council tree officer, the orchard plays a consistent, and she quotes, a consistent role in community engagement and conservation, end quote. It has provided a space for learning and connection for schools, conservation groups and volunteers, enriching lives and fostering a deep appreciation of nature. The officer report raises doubts about whether the loss of these trees would negatively impact public enjoyment. Let me assure you that it absolutely would. These trees are a vital part of our shared landscape and contribute to the biodiversity of the area, providing habitats for endangered and migratory species. Their impact is not limited to those who can see them. Their presence supports life across the ecosystem. The benefits they provide to pollinators, wildlife, and even food security extend far beyond the immediate surroundings. It has also been suggested that the lack of a public footpath limits public benefit. This is simply not the case. Allotment holders, scientists, and volunteers have access to the orchard to collect data for research or harvest fruit for the village produce stall and also nearby food hubs. The trees are part of a larger working landscape that continues to support the community in meaningful ways. Coton Parish Council is actively working alongside Cambridge Past, Present and Future and other organisations to challenge the Transport and Works Act order. And she goes on to make the point about you cannot assume that this will go ahead. I'm sorry, I'll read it, but we need to, it's not, right. Coton Parish Council is actively working alongside Cambridge Past, Present and Future and other organisations to challenge the Transport and Works Act order for the Camborne to Cambridge busway. You cannot assume the outcome of the inevitable public inquiry into the application for compulsory purchase of covenanted land. Over 23,000 people have signed a petition opposing the construction of this controversial scheme and calling for an alternative route that would protect irreplaceable sites like Coton Orchard and the fields on Madingley Hill. Approving this TPO is an essential step in protecting these trees and the wider environment they support. It will ensure their value is recognised and that efforts can continue to safeguard this important part of Coton's heritage and ecology. I urge the committee to consider the facts in front of them today, not prejudge the result of the C2C public inquiry and grant the TPO. Thank you. Right, and finally, the last speaker that we have is Councillor Michael Atkins. Thank you for waiting patiently online, Councillor Atkins. Are you there?
Yes, thank you.
Okay. Far away, you have 3 minutes as local member.
Thank you, Chair. I would also
We
like
can't
to
hear
urge...
you very well. Can you speak closer to your microphone or turn your volume
Sorry.
up? That's
Yeah.
better.
Thank you, Chair. Is that better?
Yes, it is. Thank you.
Thank you. I'd like to urge the committee to approve this tree protection order. I think it's clear from the officer's report and from the other representations you've heard today that these trees have significant amenity value to the community. I'd also emphasise one point which I think hasn't been fully made yet, which is also, in addition to their own characteristics, that these are quite rare specimens, given the decline of traditional fruit orchards, both in the county and indeed across the country. These trees also help underpin a wide range of local wildlife and biodiversity, and I would also add they contribute, I think, to the rural setting of this greenbelt area, and are, as have been noted, are a site for community events and other members of the local population. Now, whilst the officers have noted that this protection could be overridden by a development consent order, it does strike me that if these trees have value, as have been said, then it's reasonable to grant them protection. And I think it would serve as a useful marker to be fed into what we expect to be a forthcoming public inquiry on the busway. And I think an important point, Chair, that you established that many of these trees would likely retain their protection and the protection order even if the busway is approved in the future. So I think these are kind of good reasons to approve the tree protection order in this case. And I'd just like to add, I'm very grateful to officers for their work in assessing these trees and coming out and visiting the site. And their work is very much appreciated, even if we respectfully disagree with the conclusion that they've ultimately recommended to you. Thank you very much.
Thank you very much, Councillor Atkins. Does anybody have any questions for Councillor Atkins? Nope. Okay, right. Thank you very much. So we can open the matter for member debate. Yes. Why don't you, Councillor Fane?
Thank you, Chair. I'll start off this debate then. I want to make it clear that I am looking at this purely on the merits of the trees. I think it is easy to be distracted by other factors. If there were to be a public inquiry and subsequently a Secretary of State decision on a Transport and Works Act, that is entirely a separate matter, and as it happens, the Secretary of State's decision would override this in respect of the trees concerned, whether that is 3 or 6. The second thing is, it's unusual to protect fruit trees through a TPO application because a tree works application would be required each time pruning is taken. That's paragraph 1.3 on page 98. It's worth remembering that were these trees to be brought into cultivation and such operations to be needed, then they would in any case be exempt from the restrictions of a TPO, as is made clear later in the report. The third thing I'd reference is that we have heard talk not just about the 12 trees. There is some question as to whether they are all veteran status or some veteran status. It depends on the definition and who's making the declaration, and the officer has guided us on those factors. Similarly, it is suggested that one of them is a champion tree, and that may well be the case. That's not specifically referred to, I think, in TPO legislation, and we have to consider these 12 trees on their merits. And it seems quite clear to me, bearing in mind that as the Vice Chair of the Parish Council said, these trees are of enormous value to our community, and the TPO is to be awarded on the basis of, in the interests of amenity, that if you look at the test on page 129, I think it is, yes, which is the tree evaluation method for preservation orders, the tempo that was referred to, the decision, as a group, they qualify for a provisional TPO. That, to me, is quite clear guidance. I have no reason to think otherwise, and disregarding the distractions that I referred to earlier on, it's quite clear to me that we should, against advice, grant this provisional TPO on all trees, because we have no option to do it on a smaller number.
Thank you. Right, I can't, oh, Councillor Dr. Richard Williams.
Thank you very much, Chair. Just to say, couldn't agree more with what Councillor Fain has just said. As Councillor Fain has pointed out, the trees themselves, they merit protection. We've established that the TPO would remain, even if the busway were to go ahead, the TPO would remain on the unaffected trees. And I think just on the point of expediency, I would say yes, it is expedient to make this order because there is a risk to the other trees. Just setting aside the trees that would be in the way of the busway, there is a risk to those other trees as well because they could be damaged in construction of the busway, and serving a TPO would be a way of protecting those other trees should it go ahead. So I think on that basis, there is a strong case to say it is expedient to make this application both on the merit of the trees themselves, and actually even if we were to take into account the Transport Works Act, it's still expedient to do it because there would be a risk to the trees that are not in the busway. So it should be served, in my view.
Thank you. Okay, Councillor Sandford.
Thank you, Chair. With all due respect to Adrian Sargent, who's obviously done a lot of work on this application, there seems to be a non sequitur between his conclusion that the trees merit a TPO and the recommendation to refuse. And the thing that seems to be between the two is that Transport Works order. We've already told clearly by legal that the possible route of the Camborne and Cambridge busway is irrelevant to this application. So I will be supporting the TPO, and I would also remind this council that we claim to be green to our core. So I encourage my fellow members to bear that in mind as they cast their votes. Thank you.
I see no others.
Thank you.
Martin Khan.
Councillor Khan.
I'm a bit torn. I understand the arguments presented by the officers. The trees are currently well maintained. That's not accepted. So they're not at risk. Ignoring the proposed busway, they're not at risk to do with it at present. So normally we, certainly on emergency TPOs, we look at whether they're at risk. It's clearly been put forward as a means of obstructing the busway, but it also would allow their importance to be taken account in any public inquiry. So that's an important consideration. At the same, and it might, for instance, if it's decided that the balance is in favour of the busway, put more pressure on translocation on the trees that would be affected, which would be, to me, a consideration. They would then be at risk. But at the same time, I'm also concerned, looking purely at the trees that they are now, they are well maintained, they're well managed, people have public access to it. Do they, even though they may meet the requirements, are they at risk? So I am a bit torn. I think possibly I will wait and see what other arguments put forward before I make my decision.
Thank you, Councillor Khan. Sorry, just one moment, please. Right, my observations about this are that we need to be looking at the trees on their own merits and the justification for issuing a TPO on their own merits as veteran trees. In fact, it notes just noted in the report, 2 of them are veteran trees. They're not all 12 veteran trees. But also the fact that these are, the reason people serve a tree preservation order is to recognise their amenity value. So this is if they're in the public eye, that they offer a view from the street, from public space, but also that they have an inherent value. Sorry, excuse me, I'm being distracted. Thank you. So my feeling is that we should simply look at these as a group of trees, whether they deserve to be a protection order, regardless of what happens to that in future. And as Councillor Fain and the officer has kindly pointed out, what I would say is people have said they're well maintained. The photographs I've seen indicate that they probably were well maintained in the past when they were actively part of the orchard. But it's not my impression that they're being actively maintained now. They're veteran trees, so they're just existing under their own steam, and trees don't need to be pruned much when they're old. They achieve a maximum size, and then they almost reach an equilibrium, as it were, with a little bit of maintenance. So the point being was that if on page 112, in the conclusion, the officer says that if TPO status were granted, that would impose controls over the future management of these trees. That's simply that people have to ask us for permission to do certain works, which is not onerous. It's just, yes, that's perfectly reasonable given what you want to do. It just means that people can't go and take great branches off without good regard, and it has to come to the tree officer to seek permission. That's not a problem. That's what happens with all trees that have TPOs. I think we need to concentrate on the trees in their own right. What happens afterwards is a completely separate issue, and it will not be influenced by whether these trees have a tree preservation order or not. So, my feeling is that around the room, it seems, there are views that maybe these trees need to be considered in their own right, rather than as subject to a subsequent planning application. So I will just remind us of the process that we would have to follow if we do anything other than what the officer is recommending. So the officer recommendation on, sorry, Councillor Hawkins, would you like to speak? We're just going to go through the process. Okay, sorry, do speak if you'd like.
Thank you. I've heard everything that's been said, but then I need to ask the question, why is this here in front of us in the first place? Why is the TPO being requested? It's because those trees are subject to potentially being taken down for the busway. We keep being told to ignore the busway. Why we are being asked to put a TPO on? It's a circular discussion here, right? If it wasn't for the busway going through there, this application would not be before us today. That's all I'm going to say.
At delegation meeting, I believe the decision was because there was a considerable degree of public engagement about it. Or did it come anyway? No, it didn't come. Okay, right. Right. So can I just remind members of what we would have to do, right? If we need to go to the recommendation, and that recommendation at paragraph 9.1 on page 102 of our agenda is that the Planning Committee decline issuing of a provisional TPO for the reasons outlined in this report, and that dated 1st of November 2024, which is the appendix. So we can vote on that, and if members do not agree with that, in other words, they vote against the wish that the recommendation to decline, then we would need to take a motion to vote for. So we would have to take a motion to serve a TPO. So we will have to do that step by step. Well, I know it's complicated. That's why I was describing it first. We have to vote on this recommendation first, which is to decline the TPO. Right? So if that passes, we will decline the TPO. If, however, that fails, we will then have to take a motion to serve the TPO. Am I right?
That's fine.
Rise first.
I mean, I think I might, and then Rebecca might as well, but obviously the recommendation, if members vote on this proposition firstly, and members decide to go against the officer recommendation, then that just fails to decline, and so therefore to do something active and actually make the TPO, member will need to propose, a member will have to second, and then that will be to actually create the document, which is the provisional TPO for 6 months, and then subject to that being then confirmed.
Exactly. Yeah. Right. This is why this process is quite complicated when the recommendation is for refusal. Do you want to summarise?
I can clarify the officer recommendation, which will be what the vote is taken on. So officer recommendation is that Planning Committee decline the issuing of the provisional TPO for the reasons that are set out in the report, which have been debated, and also for that report that's appended, Appendix 1, which is dated the 1st of November 2024.
So we need a seconder for this recommendation to decline. We haven't got a seconder yet. I've just been advised we need a seconder for it.
Somebody needs to move and second.
Yes, okay. So we need somebody to, well, the officer has recommended.
I would have said that's in the report, so that's just taken as being the recommendation. And if anyone's doing anything contrary to that, that's where then the proposal and seconder comes in. So I would take the vote on.
Would anybody like to, just since there's some difference of view here, would anybody like to recommend the recommendation as at number 9? Is that Councillor Fane proposing?
No, I am proposing that we move to a vote on the officer recommendation.
Yes, and I'm just trying to establish whether we need a seconder for it.
Yeah, you do now.
You do? Okay, so we do. We have a seconder for it. So thank you, Councillor Hawkins. Right. So let's move to a vote on the officer recommendation to decline. I will just say, members, that if you wish to decline this TPO recommendation, sorry, if you want to agree with the officer and decline, you press green, okay? If you don't agree with the officer and you think we should be doing something different, then you press red. We should have 10. 6, 7, here we are. So that's 2 in favour, 7 against, and 1 abstention. So that falls. So now we need anyone to make a recommendation to serve the TPO. Would anybody like? So Councillor Richard Williams, do you have a seconder? Is that fair, Councillor Fane? So Councillor Peter Fane is seconding. So Erin, can you run us a vote for serving the TPO? And forgive me, I'm the provisional TPO. And with your discretion, I will say that if you wish to serve the TPO, you vote green. Just because 2 negatives is impossible.
That should be coming through now.
Okay, right. So 6, 7, 8, 9, 10. So that is 7 in favour, 1 against, and 2 abstaining. So that is carried. Thank you very much, members, for that complicated vote. Lovely. Thank you. Right. That's all right. Members, I'm mindful that we've got a lot of people here to talk about the Coton application, but it is 1 o'clock. So would members like to take a 10-minute break and then come back rather than have a whole great long lunch break?
I think we should.
Is that okay, 10 minutes? Or would you prefer to take longer and have a bit longer for lunch?
I suggest we deal with the public speakers before lunch, which we can do.
Yes, okay. That's true. Right. But we can't stop in the middle.
Well, as long as you haven't started an application.
Well, no, that's what I'm saying. Sorry.
So we don't know how long this might take for Combatant, and from what I can see, it could end up being a long one. So let's have lunch.
Would members be prepared to have a 20-minute lunch break? Is that okay?
Yeah, that's fine.
Yep, okay. So that brings us to 1:20 back in the room. Oh, 1:30. 1:30 back in the room, please. So we are on item 7 of our agenda on Wednesday the 15th of January. We are looking at land at Branch Road in Comberton. And this is a hybrid planning application, which I will leave it to the officer to describe in more detail. This is from Endurance Estates, and it's going to be presented by Katie Christodoulides. Thank you, Katie.
Thanks, Chair. Right, so we've got a planning application at land at Branch Road in Comberton, and it's a hybrid planning application for the construction of an integrated retirement community, IRC, of up to 200 extra care units with ancillary communal and care facilities and green space, and it consists of a full planning application for 24 close care units and 32 extra care units. The clubhouse, means of access, landscaping, open space and all other associated works and infrastructure, and an outline planning application, all matters reserved except access, for up to 144 extra care units, use class C2, with ancillary communal and public open space, landscaping, solar generation, battery storage and all other associated works and infrastructure. In terms of verbal updates, there was a written update report which was sent to members since the committee report. And since the committee report was published, 4 neighbour objection representations have been received, which members have received a copy of. No new material planning considerations have been raised other than what has been raised previously and already addressed in the committee report. The applicant has submitted a summary of proposals document, which is dated January 2025, which members have also received a copy of. And in the written update report, to note, there is also addition of an additional reason for refusal, number 6, on unsustainable location in the countryside. To note also, paragraph 10.280 states that the lead local flood authority objects. This is a typo and they don't object to the proposal. Paragraph 10.97 of the committee report states that the NHS benefit is moderate. This should be limited as per paragraph 10.88. Paragraph 10.95 states significant weight is attributed to the need for older persons housing. This is correct. Also, just to note that 3 appeals have been added as appendices to the report for information only on appeals in Cambridgeshire for C2, C3 use in the Greenbelt. These demonstrate the different types of C2 use. Every app is assessed and considered on its own merits, but however, appeals can be material considerations. So the site consists of 15.34 hectares, comprising of 2 parcels of land. You can see it clearer on this satellite image. There's the first parcel and there's the second parcel. The main parcel of land forms an arable field which abuts Comberton Village Development Framework along its southern and eastern boundaries. To the southwest of the site lies sport pitches and the Meridian Primary School. Along the western boundary of the site lies woodland and residential development beyond. To the north lies Branch Road, which is just here where the cursor is, which is a single track road. The site slopes downwards, downhill from north to south towards the village of Comberton. The second parcel of land which forms the site lies to the west of Comberton Recreation Ground, comprises of an area of traditional orchard and a stretch of land which encompasses an informal footpath between Comberton Recreation Ground and Green End. You'll see also, it's clear on this bit, that there's blue land here which links the 2 sites. So site constraints, and then also just an existing photograph here. The site lies outside of the Comberton Village Development Frameworks, within the open countryside in the Greenbelt. It lies within Flood Zone 1, which is low risk, and the land comprises of agricultural arable land, which is classed as grade 2, very good. You can see here, which shows the 2 sites in red, and then the dotted dashed black line, which shows the village framework. So just a couple of existing photographs here.
where the red arrow shows where the photograph is taken from and looking towards. So this is taken from Branch Road, looking towards down the site. This is taken from the valley. So the red arrow here showing the site. The existing photograph from Hillfield Road. This is the informal footpath from Green End, which is looking again towards the site, the formal footpath here. Then photograph looking towards the valley, Hillfield Road. And then just the surrounding context, which shows Branch Road here, looking towards Long Road. There's illustrative master plan, which was submitted as one of the documents. So you've got the clubhouse, which is here, which you can see on the cursor there. So the clubhouse will have restaurant, cafe, bar, gym, studio, pool, meeting rooms and consulting space, with the first and second floor having 24 close care units. Alongside this will be 32 extra care units, which will be cited here. That's part of the full application. And then as part of the outline application, which is up here, we'll deliver 144 extra care units. The proposal will seek to deliver a net zero carbon scheme for operational energy. It will take a fabric first approach, and building fabric exceeds building regulations Part L 2021. Mechanical ventilation with heat recovery, air source heat pumps and ground source heat pumps for heating and hot water, solar PV for battery storage. They seek to commit to a maximum water consumption of 70 litres per day and 4 BREEAM credits against the Watt 01 standard. The proposal will result in a biodiversity net gain of 34.57% for habitat units, 63.50% for hedgerow units and 16.69% for water course units. Alongside this, the applicant is willing to enter into a Section 106 agreement in which substantial obligations will be secured for the development. These are detailed within paragraph 20.263 of the committee report. So this shows the extent of the hybrid application, with the red shading showing the extent of the full planning application, which is for the 24 close care units and 32 extra care units, which will be use class C2, the clubhouse, means of access, landscaping, open space and all other associated works and infrastructure. And the blue shading, which is the extent of the outline planning application, with all matters reserved, except access for up to 144 extra care units, use class C2, with ancillary communal and public open space, landscaping, solar generation, battery storage and associated works and infrastructure. So this Paris plan, which shows the land use plan, so the grey area is the development area, the dark green is the green infrastructure, light green here, which is the grasslands, lime green, which is the area for allotments, orchard, grassland and communal open space, and the light blue, which is for solar generation. So this plan kind of access and movement plan, which shows the main access which will go into the site along here. So maximum heights plan. So the development would comprise of a mix of 4 scales of buildings, which would consist of 1 and 2 stories, which would be up to 8.5 metres, and that's shown in the light blue on the edges here. Would comprise of 1 and 2 story, which will be up to 11.5 in the purple here. So 1 to 3 stories, which will be up to 12.5 metres in the yellow, it's in the centre here, and then 3 stories, which will be up to 15 metres in pink. The proposed landscape plan here. So access is part of the full planning application and would be taken from Branch Road into the site, with the widening of Branch Road to 5.5 metres in width to allow large vehicle and car to pass. The proposal would include permissive footpaths which would link the site to Green End, Jubilee Wood and Harbour Avenue. For cycle parking for the full application for 24 close care units and 32 extra care units, the clubhouse, 34 cycle parking spaces proposed, 10 for the staff, 16 spaces for residents alongside mobility scooter storage, 8 visitor spaces for the clubhouse. For the full application, 64 car parking spaces proposed, 39 spaces for residents and 25 for visitors and employees of the clubhouse. Transport assessment team agree with the proposed level of cycle and car parking provision. So just got a number of elevations and floor plans. This kind of shows the elevations and floor plans in a minute for the clubhouse, which is cited here. Floor plans, ground and floor, a second and roof. So the apartment BO1, which is the floor plans and elevations, and then it's marked red here on the site plan. This is the apartment building BO2, floor plans and elevations. Cottage style building CO1, cottage O2, and O3. Bungalows O4 and O5, bungalow 6. And then this shows kind of close-up of the full planning application with the clubhouse here, which is for the 24 close care units, which will be cited here, and then the 32 extra care units in C2. So I've got some images here from the landscape visual impact assessment, and the 3 photographs show, the top one shows existing, the second one shows year 1, and then the last one shows year 15 viewpoints. And this is taken, again the arrow shows where it's taken from. This is taken from Branch Road, so existing, and then you can see year 1 of the development, and then year 2 following, year 15 following landscaping. So this is one that's taken from Normandy Close as viewpoint 2. So again, existing year 1 and year 15. And then Normandy Close here, viewpoint 2. It's taken from Comberton Recreation Ground. So again, existing year 1 and year 15. And you see the red arrow which shows we've got the development here. So that's taken from Long Road, and then the site being in here. And then finally this one taken from Comberton Road, the B1046. And there's existing in year 1 here. And I've got 2 CGIs which shows the clubhouse square. So this is the clubhouse here that you can see, the landscaping. And then a CGI, a view of the cottage cluster. So paragraph 153 of the MPPF states that inappropriate development is by definition harmful to the green belt and should not be approved except in very special circumstances. Paragraphs 154 and 155 of the MPF define development that should not be regarded as inappropriate development in the green belt. The proposal for an integrated retirement village of up to 200 extra care units would not align with any of these definitions, would therefore comprise of inappropriate development. As a result of this, it is therefore necessary to consider whether the development for an integrated retirement village of up to 200 extra care units results in any further harm in addition to that caused by inappropriateness, then also to consider the justification put forward in support of the proposal and the extent to which these matters amount to very special circumstances. In addition to the harm by reason of inappropriateness, the proposal would have substantial detrimental impact on the openness of the greenbelt, conflicting with the purposes of the greenbelt, and would, by the introduction of a significant amount of built form, would fail to reflect or respect the rural characteristics of Comberton or respond to the site's countryside location. The proposal for its siting and location would introduce an urban and substantial form of development which would result in significant visual intrusion to the landscape. The applicant has put forward a list of very special circumstances, the first 5 which I've got here on the screen, which are detailed, along with the weightings which are given by officers. So the first one being meeting an identified unmet need for older persons accommodation, which officers have considered its weight should be given in terms of very significant. The freeing up and release of existing housing stock back into the market, officers considered limited weight. Delivery of a net zero carbon in operational energy, officers consider significant weight should be given to this. Number 4, high quality design and provision of services and facilities available for use by the wider community, officers consider limited weight. Number 5, water efficiency measures exceeding adopted policies, limited weight should be given to that. And then the final 5, number 6, social infrastructure contributions, limited weight to be attributed to that. Number 7, economic benefits, including job creation, additional spending in the local economy, moderate weight to be given. Number 8, green infrastructure and biodiversity net gain, including the restoration of traditional orchards, allotments and high quality areas of publicly accessible open space, moderate weight. Number 9, reducing the burden on the NHS and primary care services, provision of on-site clinical treatments, limited weight. And then number 10, improvements, upgrades to footpaths and securing of improved, more accessible, permissive footpaths within the site, limited weight. So recent NPPF changes in December 2004 has resulted in the new definition of grey belt. Under Annex 2 glossary of the NPPF, grey belt is, as stated, is for the purpose of plan making and decision making. Grey belt is defined as land in the green belt comprising previously developed land and or any other land that in either case does not strongly contribute to any of the purposes A, B or D in paragraph 143 of the NPPF. So the site is not previously developed, it's greenfield agricultural land. Officers consider that the land strongly contributes to the greenbelt purpose, paragraph 143A, to check the unrestricted sprawl of large built-up areas, the unrestricted sprawl of Comberton, and officers consider the site is not considered to fall within the definition of grey belt. Paragraph 153 of the NPPF states that when considering any planning application, local planning authority should ensure that substantial weight is given to any harm to the greenbelt. Very special circumstances will not exist unless the potential harm to the greenbelt by reason of inappropriateness and any other harm resulting from the proposal clearly outweighed in other considerations. As which the proposal is recommended for refusal. So the different material planning considerations. And then the and then lastly the planning officer recommendation for refusal with the key approval and material considerations and the key refusal material considerations. The application is therefore recommended for refusal.
Please, thank you. Okay, members, do you have any questions of clarification for Ms Christodoulidis? Thank you, Councillor Fane.
Thank you, Chair. As I understand it, there are effectively 3 linked proposals, and I just wanted clarification of the numbers, that we have 200 extra care units, 24 close care, 32 extra care, and up to 144 extra care units in the outline application. Do we add those up and get a total of 400, or some of those are the same numbers? What total numbers are we talking about?
200 units.
And also, could I clarify, so just to reiterate that point, this is an application for 200 units, of which a full application applies to 24 plus 32 units, and an outline application covers the remaining 144. And could I clarify that extra care and close care are definitions of the applicant? The actual case class, as far as we are concerned, they are all just C2. Any other? So yes, and Councillor Martin Khan. And
I just want to confirm what I assume to be the case is that we have to approve both the outline and the full together, or not at all. We can't approve part of it.
Correct. Correct. Yeah. And Councillor Garvey.
I just wondered whether, when you say something is limited or moderate weight, which comes first? Which is the more sort of severe or more important ones?
Moderate is more than limited.
Okay. Thank you.
Simon, did you want to clarify about? Members, we've got a revised update for you, which you won't have seen before. So what I propose is that Simon circulates the paperwork so that we can, and we just take 5 minutes to read it, so that everybody's got the same information. Thank you. It's come from the officers.
A question from the gallery chair.
Could we have a copy in the gallery as well? Okay. So, members, just to clarify what this covers. It covers the original amendments to the report, but then it adds reasons onto the recommendation, which, if you like, I can read, but members will read it themselves.
I was just going to clarify, Katie has referred to this update report in her presentation, but wasn't aware that the final update report hadn't been circulated yesterday. Apologies.
Members, if we can just take now you've got the paperwork, you can just take 5 minutes to read it. Yeah, yes. Yes, I think we've got a copy going up to anybody in the mezzanine, but if the one copy could go to the members' gallery. That was why I was going to read it. But I'm going to give members a chance to read it privately first. So if we could all just be quiet so members can read for a moment. Have all members read that now? I'm just going to read it so that anybody at the back who hasn't had a chance to have sight of this knows what it is these additions are. So this is under recommendation 11, which is, hang on a minute, let's just see. This is a recommendation at point 11 of our report, which is 189, I think. Yes, page 189, where we've got the recommendation. So for the benefit of members of the public, it currently gives reasons for refusal, which are enumerated as 1 to 5, and this adds a further reason for refusal, which is item 6, and it is: the site lies outside of the development framework boundary of Comberton and is located on rural agricultural land in the open countryside and green belt. The proposed development would be contrary to policy S7 of the South Cambridgeshire Local Plan 2018 as a matter of principle. The proposal forms development outside of a development framework boundary that does not fall within any of the exceptions cited by policy S7, nor would the development be supported in principle by other policies in the plan. The development would therefore result in encroachment into the open countryside and a form of unsustainable development that is not compatible with its location. The proposal is therefore contrary to policies S2, S3, S6, S7, S9 and TI2 of the South Cambridgeshire Local Plan 2018 that seek to prioritise the development of new homes as part of a spatial and sustainable development strategy that protects the countryside from encroachment and to help guard against incremental growth in unsustainable locations, and the National Planning Policy Framework 2024 in respect of achieving sustainable development and conserving and enhancing the natural environment, and decisions should avoid the development of isolated homes in the countryside. Okay, so we all have that information, not either in front of us or in front of shared and so on. What's happened to my pen? Thank you. That's cool. Oh, here we are. So, right. Have anybody any questions for the case officer? Thank you. Councillor Fane.
Yes, if I may, I wonder what weight we should put. You've kindly circulated some inspector's findings, and the Inspector Clerk, in the case of the retirement care village, so page 349, drew particular attention to the forecasts of an ageing population within the approved local plan for South Cambridge. By the year 2024, there would be a shortfall of 331 in the district, and then refers to the Jessamy Venables report, which I don't think is disputed, showing that by the year 2024, there would be a gross need for 770 elderly care home beds, the same term as is used by the applicants here, within the market area, and a shortfall of 118, rising to 342. I mean, we have the comments of the housing officer, but what weight should we place on that assessment of the figures?
Yeah, so we've given very substantial to the weighting of that in terms of unmet need for older persons accommodation.
Very substantial weight. Sorry, I just wanted to clarify that we have appended to the officer report, we have these 3 appeal decisions. The first that Councillor Fane has referred to at page 341 refers to a decision on appeal at Stapleford. The second one starts at page 365 and is again a decision on appeal at Bottisham. And the third one is an appeal, a decision on appeal on page 395, which relates to a decision at Girton. And what I had asked officers is, in what light have those been appended to the report? Because, as you know, members, we are reminded that each application should be considered on its own merits. And so I wanted to understand in what context these appeal decisions were being put before us. And I was advised that, yes, we make decisions on an application's own merit, but we need to demonstrate that we are being consistent in our decision making. I note, however, these are not decisions that we have made, but they have been made by planning inspectors. So just that's why they're there. And also the very extensive comments, both at the first response from Competent Parish Council, which we come to shortly, and the second response, which added to their previous comments. So we've got a very comprehensive set of reports. Any further questions for the officer? Councillor Heather Williams.
Just on your point around appeals, Chair, just to be clear, we shouldn't be taking a decision based on every application we ever decide on, there's a risk of appeal. So we shouldn't be taking into consideration, it's not a case of these are here, so yes, consistency, but that should be across the board. It doesn't matter if there's appeals or not. It could be, with what you've just said, sort of suggested that we need to be concerned about appeal, but we shouldn't. We should just do as we see fit as members, in my view.
That was the point I was clarifying, that we make decisions on the merits of the individual application, and I was simply clarifying why the officer had put them in. But would you like to make a comment, officer?
Yeah, it might be helpful. So there's no precedent in planning terms, as there is in other legislation. However, authorities have to act reasonably in the circumstances. So appeal decisions are material planning considerations in that a lot of the same principles have been assessed by government inspectors, and unless they are legally challenged, are deemed to be correct on the facts of that particular case. As you've said, you also look at the individual aspects of this case, and it might be that there's areas that you differentiate between those. No two applications are the same, so you're correct in that way. There does have to be, while there's no precedent, you do have to be consistent. If you don't, then you're at risk of acting unreasonably, and there could be appeals on that with costs orders. Again, you shouldn't be scared to make a contrary decision, but you have to be conscious of these appeal decisions. But I think the case officer will probably speak to how the circumstances with those particular applications were different to this one.
Okay, thank you. Yes, Councillor. Sorry, Rebecca Smith.
Well, I've been promoted. Just wanted to.
I think it's been demoted in that case. So do carry on.
I just wanted to clarify that we've included those recent appeal decisions because they are recent and they are for different C2, C3 uses within our area and also within the wider Cambridgeshire area. However, as Richard said, each application on its own merits, but these appeal decisions could be considered as material considerations. However, just to point out, they were for different types of C2 use to what we have today.
Yeah. And the other thing I wanted to highlight to members is that very helpful assessment that Ms Christy Delides has put in her report at page 159 from 10.44 to 10.93. Ms Christy Delides has put the officer assessment of the reasons that the applicant gave to justify very special circumstances and concluded in each one how much weight we should add to those reasons, which she has helpfully summarised elsewhere. Okay, any other questions of clarification? No, okay. So, let us move on to our speakers. And I'm mindful that we have people who need to leave, so it would be good if we could get onto them before they have to leave. So the first person to speak is an objector, who is Claire, and I think it's Michelle or Mitchell. Could you say? And if you come to this. What's your name, Michelle? Yes. Lovely, thank you. So you are speaking as an objector to the application. Could you clarify, are you a resident in Comberton?
I am a resident in Comberton. I am also the Vice Chair of the Parish Council.
But you're not speaking for the Parish Council, you're
No.
speaking as... Okay, lovely. So Claire, you have 3 minutes and we'll warn you as you get to the end of it. So do please make your point. Thank you.
Good afternoon. I'm Claire Michel, Vice Chair of the Comberton Parish Council, speaking as member of the public and objecting to this planning application. I also fully support the remarks that Jessica Marshall will make in a minute and have additional observation. Firstly, on sewage. Sewage is critical concern for Comberton residents who have endured flooding and sewage overflow for many years. During heavy rainfall, not only do our roads flood with surface water, but foul water also surges up from manhole covers. This water invades homes, causing toilets to back up and flooding downstairs bathrooms through shower drains. The new development will add significant foul water, worsening the situation. Anglian Water claims that the system can handle it, but in 2023, Haslingfield sewage works overflowed for 2,935 hours, proving the system is already overburdened. Despite discussing this matter with the applicant, we see no proposal to mitigate the impact of the proposed development. I'd like to address also the topic of transport. Currently, Branch Road is a quiet route frequently used for circular walks around the village and connecting to permissive paths leading to Hardwick and Cotton. The initial planning application included a new shared path for pedestrians and cyclists, but this has been removed due to limited width. The new development will significantly increase traffic and the widening of the road will remove the verge, so current residents will lose this peaceful walking route and new residents will not have any walking route north of the development. In fact, the pavement on the Spine Road stops at the allotment. Also, the distances to village amenities indicated in the planning application are incorrect, and despite raising this issue, have not been corrected. The actual distances to essential services are much greater than stated. For example, the GP surgery is 500 meters away, not 100 meters. The nearest village shop will be 1.1 kilometers away from the closest unit. All direct routes to the village amenities pass through the recreation ground, which is closed at dusk, unlit, and lacks surface paths. This makes it impractical and unsafe route for residents. Again, despite extensive discussions, we have not managed to reach an agreement with the applicant on the topic of paths. Given the high distances to village amenities, residents will likely use their cars. There is little, if any, information on the proposed transport service. Finally, the nearest bus stop is approximately 400 meters away. As a result, we expect a significant increase in traffic in the village, contradicting sustainability claims and further emphasizing that the location of this development is inadequate. In conclusion, the planning application fails to address the critical issues of sewage management and transport infrastructure. It poses significant risk to the quality of life for current and future residents of Comberton, and I urge the Council to reject this application. Thank you for your attention.
Thank you very much for being so concise. Thank you, Ms. Michelle. Does anybody have any questions for Ms. Michelle? No. Right. Thank you very much indeed. So our next speaker is Ellen Pearce, who is Head of Planning at Inspired Villages, speaking on behalf of the applicant. So, welcome, Ms. Pearce. You have 3 minutes, so do make a start when you're ready.
Thank you. Good afternoon, members. I'm Ellen Pearce, here on behalf of Inspire Villages, the proposed operator for this integrated retirement community. We are working with the applicant Endurance Estates. Inspire Villages currently supports over 1,400 residents across 9 operational communities nationwide with 24/7 on-site staff. There is a significant evidence need for older persons housing, both nationally and within your district, specifically for extra care accommodation, which this proposal will positively contribute towards. The government has also recently acknowledged a national social care crisis. Your officers agree there is a need which exceeds the number of specialist homes proposed in this scheme. We calculate a current shortfall of at least 447 market extra care units, worsening by 2040 to a shortfall of 690. These estimates are considered conservative. There are very limited housing options for your residents as they grow older. This means either they stay in unsuitable homes, increasing the risk of falls and becoming socially isolated, or they may have to go into a care home, but that should only be an option of last resort. Alternatively, they must move away from their existing community to find something suitable for their needs. The proposal before you addresses these issues by providing an attractive alternative for older people in your district, specialist accommodation with personalised care and support adapting to residents' changing needs over time. Whilst we acknowledge that this site is within the Greenbelt, there are a number of benefits that together represent very special circumstances and should now be viewed in the context of the new NPPF. Under the new NPPF, this site can be considered grey belt, and South Cambridgeshire are unable to demonstrate a 5-year housing land supply, triggering the tilted balance. The proposals provide a number of benefits constituted very special circumstances. In particular, we would highlight that your officers had given very substantial weight to meeting the need for specialist accommodation for older people, which alone has been found to represent very special circumstances elsewhere in the country. Further, the proposed development significantly exceeds policy on carbon reduction and water efficiency, as well as biodiversity net gain. And finally, Section 106 contributions will exceed £2.2 million, delivering once-in-a-generation benefits to the village of Comberton, alongside infrastructure improvements and other economic and social benefits. These benefits are only enabled through the development of this site, and this figure does not include savings to the NHS that integrated retirement communities have been independently evidenced to achieve. Comberton is a minor rural centre, the second highest in your settlement hierarchy. The benefits of the proposal before you clearly represent very special circumstances and significantly outweigh any harm identified. We therefore ask members to approve this application. Thank you for your time.
Thank you very much, Ms Pearce. Does anybody have any questions? Yes, thank you. Heather Williams.
I may have misheard, Chair, but through yourself, did you say we've lost our 5-year land supply? Is that what you referred to? I heard, that's what it sounded like, but...
So let's ask Ms Pearce.
Yes, so we submitted a letter to officers prior to this committee which set out a position on why we have identified under the new NPPF that we do not consider there to be a 5-year housing land supply in this district any longer.
Thank you. I think Rebecca Smith will respond to that.
Yes, I can confirm that the applicants or agents submitted a letter over the weekend where they raised concerns about our 5-year housing land supply. Apologies. However, I would advise committee that our latest housing trajectory report from April 2024 has been published, and we will be publishing an updated housing strategy report in April 2025. We are currently reviewing the implications of the new NPPF and the National Planning Practice Guidance, which includes updates to the standard method, which will be incorporated in an update report. As yet, the Council hasn't reached any conclusions in light of the NPPF updates or the updates to I would, however, advise the updates to the NPPF induce qualitative, try and get my words out right, components to the tilted balance, which is set out in paragraph 11D. Those are namely directing development to a sustainable location and making effective use of land, securing well-designed places and providing affordable homes. So when we note the qualitative, I got it right this time, qualitative criteria, even where a tilted balance applies in respect to the 5-year housing land supply, the reasons for refusal set out by officers go to the heart of that assessment and directly engage with those matters. That includes the former development, there's a reason refusal relating to the former development, and also an unsustainable location. So it's officers' view that nothing in that latest claim would result in officers recommending the application positively.
Okay, and for clarity, under the current NPPF or the previous one, we currently have a 5-year land supply. Yes, exactly. That's what my understanding was.
So the new MPPF introduces a new standard method for calculating the 5-year housing land supply. It only came out in December. We will publish our updated figure in our April 2025 housing strategy report.
Thank you. Right. I just wanted to ask Miss Pearce, right, you've identified a need for housing for older people. That is quite a large number. So I'm just asking if you are accepting that this would actually attract people from a much wider locality than just the environs of Comberton. Have you any idea what sort of area you would be drawing people from who might wish to come and live in this accommodation?
Sorry, I don't think we said that we would. Could you repeat the question?
Well, given that you're suggesting 200 extra care units and in total, clearly there are not 200 people in Comberton who need that accommodation. So have you done any assessment of over what area you might be drawing people from to come and live in this location?
So the need is calculated on a district-wide level. So the need figures that I gave previously are based on the district. And that's the calculation that's made is on a district-wide level because it relates to other services that are provided, such as adult social care services and NHS. And that's why the need is calculated on a district-wide basis in line with that.
So this would, in that case, then almost certainly increase the amount of traffic coming into Comberton if it was people visiting elderly relatives who've now moved here. Do you see what I mean? Have you done an assessment of the increase in traffic that is likely to be engendered by this new application?
So transport assessment was produced, which was submitted with the application, which looks into trip rates. But in terms of need, like I said, it's on a district-wide basis in terms of the people that are in need of this type of accommodation. The older people themselves that would move in was based on that need assessment on a district-wide level.
Okay, thank you
Does
very
that
much.
answer the question?
Thank you. Any other questions? So, Councillor Dr. Toomey Hawkins.
Thank you, Chair. I'd like to refer to, I think it's paragraph 9 on page 158, talking about reducing the burden on the NHS and primary care services and provision of on-site clinical treatment facilities. I'm sorry, but can you explain exactly how you will be achieving that with this?
So it's page 158, paragraph 9, isn't it, Councillor Hawkins, that you're referring to?
So how does your proposal actually achieve that with this clinical space that you're providing?
So it's a combination of factors, not only the residents themselves who move in and have reduced need for health and social care by the fact that they're living in suitable accommodation that meets their needs and they have care and support on site to meet that need. It's a combination of that individual benefit to those residents and the wider implications of that, and then the clinical space sits alongside that. So part of that saving is calculated as a result of the people who live in the accommodation needing less support because they've got that on site and they're living in suitable accommodation to meet their needs that change over time.
What is the clinical space?
The clinical space is a part of the clubhouse building, which is designed to NHS standards and offered to the GP as part of the Section 106 agreement that would be made for free of charge. So it would be built by us, kitted out by us, and offered to them at a peppercorn rent for them to use as they wish. And then if they did not choose to use that, it could be used for other medical uses, all open to the public. So that is what the clinical space comprises.
Sorry, Chair, can I come back? And have you discussed this with the GP surgery? And do you have an agreement with them?
We do not have an agreement with the GP surgery.
Thank you.
And I should point out the comments that the GP surgery has provided to us on page 150, paragraph 9.4, where they have said that it's the fourth bullet from the bottom, without the guarantee of the clinical space being provided, the surgery questions the weight that can be afforded to the element of the clinical space as a very special circumstance to permit the development on greenbelt land, and they itemise all their concerns about the additional weight on the local GP surgery at that point. But thank you very much.
Thank you, Chair. That's why I asked the question, because I noted that response.
Exactly. Thank you very much for drawing that to our attention. Thank you. Any other questions for Ms. Pearce? No? Okay.
Thank you.
I don't think so. Were there any? No. Okay. So, oh, sorry, Heather Williams. You go ahead. That's fine.
Thank you. Through yourself, Chair.
Just before you go, there's a further question. Sorry for my delay.
So through the report, grant you, there's a lot of objections from various different people, but just on the point there, we've got an objection from the GP practice. We've also got an objection from the Health Development Officer and also from the Housing Strategy, which refers to the capacity of the GP surgeries and everything else. I mean, capacity and health provision is probably where the main objections have come for. So how is it proposed to deal with that? And I'm very confused, Chair, as to why the applicant is sort of presenting us with this project that is meant to be really good for people's health when everybody related to health is objecting.
Do you wish to respond to that, Ms. Pearce?
I would just point out that there is, in the heads of terms, which are listed on page 183, in addition to the clinical space on site that we've mentioned, there is also, if you look to page 184, the third point down, it also references NHS healthcare contribution in addition to the voluntary clinical space that we'd look to provide as well. So there's a combination of both mitigation that's been required by the NHS plus on-site facility that we'll be providing and the individual benefits to residents that move in. That's the answer. That's the only way I can respond to that question.
Okay, thank you very much. Could you just, while I'm thinking about it, on the site, sorry, do you want to carry on? Sorry.
So to be clear, you're going to provide these rooms and facilities, but obviously you need people. Otherwise, the room you've almost admitted yourself is next to useless and have to be changed to something else. Is that correct?
No, so the way that the Section 186 is currently drafted, it was under negotiation until this point, was that it would have a flexible option for the GP to be offered that room. If they choose to accept it, it would be given to them on a peppercorn rent at a later date. If they choose not to accept it, it would be used for other medical uses, which could be a private service if the GP did not want it. That would be open to the wider community. So that's the way the clinical space would work and that we've had secured in other districts.
Okay, so while you're there, the other thing I wanted to ask was about on the site visit, it became apparent that many of the people who might be in the village might wish to access the existing GP surgery if there was space for them, although that's in question in the GP's response, but they might access across the recreation ground. And the parish council made it clear that that recreation ground isn't unlit and closed at dusk, and also that there is currently no footpath across it. So I'm just, how did you envisage that working? I mean, did you have just a broad sense of how that would work as an access to the site?
Again, I would point to the heads of terms at page 183 to 186, which details significant footpath improvements that would be secured via that Section 6, which includes improvements to that footpath that you've mentioned.
Okay, yes. Councillor Fane.
Yes, if I may, Chair. It was suggested to us earlier that there have been serious flooding, including sewage flooding issues in the village, and it was suggested that the applicant has no proposals to mitigate this. Would you agree with that assessment?
I would just again point to your own officer's report, which does look at page 174 to 175, which looks at water management and flood risk in terms of how that would be mitigated, and no comments and no objections from the lead local flood authority and the Environment Agency.
Thank you.
Thank you very much. Councillor Khan.
The proposed development is approached basically from outside the village, from Branch Road, rather than from the existing built-up area. What was your reason for that? What were the constraining factors that determined that you adopted that approach?
That's the only access available is from Branch Road.
Yes. Okay.
But vehicular access, I should clarify, rather than pedestrian.
I was talking about vehicular access.
Right. Okay. Thank you. So let's move on. Thank you very much indeed for responding to those questions, Ms. Pearce. Thank you. So the next speaker is Councillor Jessica Marshall from Comberton Parish Council. So can I ask, while you're gathering your wits, do you have the permission of your authorisation of your parish council to speak on this matter? Lovely, thank you very much. So you have 3 minutes and we'll give you a warning if it looks as if you're liable to overrun. Okay.
Thank you, is that better? Thank you. Good afternoon, I'm Jessica Marshall, the planning lead for Comberton Parish Council. We object to this planning application. We recognise that there is a need nationally for good provision for people with extra care needs, and we would always welcome people into our village. We have endeavoured to work with the applicant to address our concerns, however, we still have significant concerns remaining. The application is for a development located outside the village development framework. It is sited on Greenbelt land. It forms part of a north-south corridor of countryside space through the middle of Comberton, which is recognised as an important green lung through the village. The site is next to the Jubilee Woods, part of the recreation ground in Comberton, which forms a rural character for the village and a sense of open, undeveloped space. The main walking routes across the recreation ground to the site will not be safe, even with new paths, and they are not suitable for people of a C2 class demographic. This area of Comberton provides wildlife a route through the long village. It has been shown to be particularly important for species such as grey partridge and barbastelle bats through many village surveys and village ecology reports. We believe that the applicant's ecology reports did not adequately identify the impact to some of the species involved, the lack of detail regarding lighting, which would especially affect the sensitive species which use this corridor. The applicant has not performed an alternative site assessment, and the need for a retirement village of this type is conflicting with the housing strategy in which the preference is for dispersed, smaller retirement provision or purpose-built on new sites where there can be more suitable amenities, such as Bourne Airfield. In addition, the Health Development Officer and Housing Strategy Officer query the Class C2 references in the application, and the design elements do not highlight how these needs are met. For example, inclusion of open water, confusing landscape, and design of many of the units. There are no affordable homes within the application. The design of the application is out of keeping with the village of Comberton, and the building designs are very urban in nature against the backdrop of a very rural landscape. It includes a 76-metre-long building with a height of over 15 metres, which will be strongly visible from the village amenity of the recreation ground, and we feel that this is inappropriate in terms of size and scale. Comberton PC have worked with the applicant, the GP partners, the ICB and other local GP surgeries who have needed to expand to accommodate increasing patient numbers. And the summary is that the local health service have agreed that they will not be able to use the clinical space within the development because of the many logistical problems with this and the need for it to be fully registered. Therefore, the impact on an already full GP surgery practice will be large. Constraints exist at the GP surgery for expansion, and the Section 106 money requested is based on an average person rather than a C2 class person, and is not sufficient for any expansion. In fact, it's 5 times less than the GP surgery have suggested, meaning the surgery would not be able to accommodate these higher need patients, and there is a real risk that the GP practice would need to close their books to any new patients. There is significant strong local objection to this application, with over 200 objections from local residents. We strongly feel the harm from this development cannot be overcome, and it has not been shown to have very special circumstances. Thank you for your attention.
Thank you very much. Right, so do members have any questions for Jessica Marshall? Councillor Dr. Timmy Hawkins.
Thank you, Chair, and through you. Thanks for your comments. In terms of the 106 contribution in the heads of terms, I think if I heard you correctly, you said the doctor's surgery was suggesting 5 times that figure of £166,000. Am I correct?
That is correct. The GP surgery have undertaken quite a lot of effort into looking at how they could possibly expand and what would be needed to do this. And they have discussed this with the applicant. I've been present in those meetings. The GP surgery have put in their response the figure that they feel might be able to help them expand, not in terms of staff members, but in terms of physical space. The ICB is tied because they have to use a formula based on an average person, and therefore there is a big discrepancy in the two numbers.
Thank you.
So that's £10 to the chair's charity, to the legal officer. Thank you. Any other questions for Ms. Marshall? And again, do you want to come back?
Sorry, me again if I can come back.
Yes, that's fine.
Flooding. Sorry, Chair, but I'm quite aware of the problems that Comberton has had over the years in terms of flooding, especially near Swains Lane and that area. Now, the lead local flood authority, for some reason, don't seem to be aware of that, or they are aware. I'm not sure. I think I read that.
So Anglian Water have put in their response that they are aware of the issue of sewage flooding in the village. The lead local flood authority, I believe, have been assessing the sort of the surface water and how that is provided for on the site. Within Comberton, we have mixed drainage systems, so we have surface water and foul water, which is combined within the centre, and Comberton, as it runs downhill, it's the area of the conservation area within Swains Lane, and then the main road, Barton Road, which regularly floods sewage out into the pavements, into the ditches and into people's houses.
And if I may, sorry, Chair,
you go ahead.
The applicants are aware of this? Did they actually talk to you or anyone else about what they might do?
So I believe the applicants have responded to our comments on this. We made comments on this within our first response to their application, and they have pointed out that Anglian Water have said that they do provide a service to Comberton, and that is as far as the applicants have been commenting on this issue.
Paragraph 7.11, Anglian Water apparently have no objection, saying foul water drainage from this development is in the catchment of Haslingfield Water Recycling Centre. That will have available capacity for these flows, despite what we've heard from the residents. This is their assertion. However, they do say they are aware of concerns raised regarding flooding in Comberton and request that the applicant consult Anglian Water through a pre-development inquiry in order to define a suitable point of connection, and preferred methods of surface water disposal would be to a sustainable drainage system, and request condition in regard to strategic foul water strategy. They can be sure we would have
sorry,
that.
Chair, if I may, I understand that Anglian Water is a private company. They have, they're mandated to provide the service. However, they don't always admit to problems that exist, and they don't always solve those problems. In fact, sometimes it gets worse. I've been there, done that, got T-shirts and caps and everything else.
Yes, and at 7.49, we have the lead local flood authority. No, just a moment. The lead local flood authority refers to no objection. The surface water from the proposed development can be managed through the use of SUDs restricting surface water discharge to suitable rates. I wonder if they've seen the photographs that the village submitted as part of their representations. Right, have we any further questions for Jessica Marshall? I had a general thought, but I'll come back to it in debate, I think. Thank you very much, Ms Marshall. Oh, sorry, sorry, before you go. Debate, okay. No, that's fine. Okay, that's fine. Thank you very much, Ms Marshall. No, it's just that Chair needs 16 pairs of eyes. So, Councillor Michael Atkins is the local member, and I think you were hoping to take part, and I'm sure, Councillor Atkins, you'll have some gems of wisdom for us about flooding, but do go ahead. You have 3 minutes to speak on whatever matter you wish.
Promises. Just to clarify, I'm one of 3 local members rather than the exclusive.
One of 3
but I am
local
speaking
members.
today.
Sorry, and if you'd be so good as to hold your microphone a bit closer as you did last time,
yes.
that would be most helpful. Thank you.
Thank you, Chair. Lovely to see everyone again. I'd like to urge the committee to reject this proposal in line with the officer recommendation. You will appreciate my difficulty in speaking on such a significant application in a short time. There are a very large number of objections from local residents, both in Comberton and nearby and affected villages. And I'm very grateful to those residents who've submitted concerns and I endorse their concerns, and they have been well highlighted by previous speakers. I would like to focus on the drier but important issue of the sort of policy and strategy implications of this development. I understand that this council already has, as part of the local plan, a strategy for providing sufficient sheltered housing for the local population, which is to provide it across a range of significant new developments. The application today represents a diametrically opposite approach of concentrating such housing in a single site. So without getting into the debate as to which approach is better, my first argument is I think it's inappropriate to disregard the careful and democratic development of the local plan in favour of a somewhat speculative application from a private landowner. Furthermore, in my opinion, the choice of site exacerbates the potential weaknesses of a retirement community approach and diminishes the potential benefits. It's reasonable to assume the residents of this village will have an above average need for public services, such as health and transport. But because this development is on the periphery of the existing village and a considerable distance from the village centre, this concentrated additional need will be challenging to meet, as highlighted by the GP service, the ambulance service, and the concerns raised about transport and use of local narrow roads not designed for such traffic. Similarly, the potential benefits for the existing community are also hamstrung by the distance to the current village, such as providing shopping or entertainment. It's simply too far from the existing residents. Now, I would also note that the promoters of this application have indicated that they did not consider any other sites as part of their planning. So I think we can reasonably infer that the genesis of this application was in seeking to develop this particular site rather than searching for an optimal solution to the challenge of sheltered housing, which is a real challenge. So to conclude, I think even if we do briefly set aside the obvious contraventions of our green belt and other related policies, I'd argue that this site would still be an inappropriate location for development of this nature because it concentrates a population with significant need for public services in a location where it is difficult to service those needs. And I think, to my eyes, that's clearly inferior to our existing policy and strategy of dispersed sheltered housing in major developments that are underway and in the works. And those developments will, for example, be very well serviced by design by public transport in particular. Those are the remarks that I'd like to make, and again, just to emphasise the concerns made by the residents and mentioned earlier, which I don't have time to go into in full detail myself. Thank you very much.
Thank you very much, Councillor Atkins. Does anyone have a question for Councillor Atkins? No, thank you very much, Councillor Atkins. That's great. And indeed, I can think of other applications where alternative site assessment has been done. maybe we'll come to them in the debate. So we're open for debate, members. While I'm talking about it, I will just mention another site that we have looked at as a committee relates to the what's it called? The Arthur Rank Hospice, which moved out from Brookfields Avenue to the site near the Babraham Park and Ride. And in that case, which thinking about it might have been considered by JDCC, but certainly I've been part of that consideration. At that location, a very extensive survey was done of alternative sites in order to justify the overriding need and appropriateness for that site in the Greenbelt. So just another thought there, members. So would anybody like to start off our debate? So, Councillor Heather Williams.
Thank you, Chair. Now, we've had other applications that have, I believe we call it age-restricted housing now. And yeah, there is need, but often there's a sort of small amount of need in a variety of places and a variety of geographies, because you don't also want to take people at that point of their lives out of their current support network, because if you do that, if you essentially club everybody together, Chair, I do believe Councillor Hawkins is signalling she would like to be added on a list somewhere. Hopefully that is helpful, Councillor Hawkins. That you then put more of a burden on local services, because there aren't those natural sort of family links and family support. One thing this application has done for me is actually, it's the most amount of objections I think I've ever seen across such a broad spectrum. So just to list the officers: ecology officer, health development officer, housing strategy, landscape officer, policy officer, urban design officer, tree officer. Then we have a raft of parish councils that object, a huge amount of third-party objections, and even the local doctor surgery, who I would give significant weight to in this form of application, because again we have to look at the amenities for the residents that would be living here if it was given permission. So reading that and hearing the applicant, and I hear what they say about there being need in the district, but just because there's a district-wide need doesn't mean that you should start building on the Greenbelt. I don't think special circumstances have been demonstrated as to why this site needs to be built on. I think there is a complete and utter, I hear what you're saying, flooding, sorry, completely, but we don't have an objection to the Lead Flooding Authority, and as much as that frustrates us, and Anglian Water are a particular frustration, I've got chair of one of my parishes here, and he'll know just how frustrating Anglian Water is. I don't think, to be honest, that is needed in order to refuse this application. I think the officers have provided us a raft of reasons for a refusal, and I absolutely see no way at all why we should overturn this recommendation from officers. And as members know, I'm not somebody that shies away from overturning officers' recommendations. I think they'll be quite shocked that I'm in agreement with them, probably. But on this one, it's perhaps Councillor Hawkins is as well. We like to be rebels at times, Councillor Hawkins. I know you do. But on this one, it's very clear-cut for me. I'm afraid back to the drawing board to the applicants.
Thank you. Would anybody else like to? Thank you, Martin Khan.
I tend to try and approach these sorts of applications on the key issues. There are a lot of issues in terms of this, but the key issues that that really affect this application are the need for aged care and elderly care. Now, of these, this is quite a large development for that on a scale which would make a big contribution. However, quite a lot of the application is actually at the lower end of need for support, which people will probably also have cars, largely like a private development, but with a bit of additional care. So it's perhaps not the same as the type of care for which there is a real shortage. But that is an important, significant item, and that, as we've been advised, it has considerable weight. Against the intrusion into the green belt and the countryside and the extension, and the scale of the extension, and the sustainability of that location. Now, this development is on the edge, it's outside the development framework, but on the edge adjoining the existing development. But it's not integrated into that development. The access to it is long-winded. It goes around Branch Lane. Because it's the majority of people will be the lower end of care, as proposed. So there'll be a lot of people in cars who will be forced to go a very long way around to get to local services. Now, that seems to be rather unsustainable to me, form of development. It is not, the access to the adjoining settlement is basically by foot for people who are supposed to be elderly and therefore not necessarily terribly mobile. So it's going to be really not well integrated in functional terms with the adjoining development, even though it adjoins the existing settlement. So it intrudes, it's of a scale which intrudes also with the outline phase quite a way outside the existing settlement. And to me, that's a very strong reason for refusal. It's against our policies on that ground, which doesn't seem to be mitigated by the other aspects of it. So accepting the ecological terms, which could possibly sorted out by conditions and a plant management plan, the same perhaps with the control of sewage flooding. If there's you could perhaps design a system to control that. But the other issues are key issues, and they seem to be unresolvable issues because of the nature of the development. And so my general feeling is that the officer's recommendation is absolutely correct and we should refuse it.
Thank you very much. Councillor Khan, Councillor Sandford. Sorry, could I just take Councillor Toomey Hawkins first? Sorry, you raised your request first. Yep. I'll come to you next, Councillor Sandford.
Right, thank you, Chair. Yes, obviously we need to look at this application on material grounds. But it is, I mean, I couldn't have said it better than Councillor Atkins did earlier on, which is that, you know, it's an application in an inappropriate place. They did not seek any alternative locations for this. You know, you're putting, I don't know, hundreds of people who have significant needs on the edge of a village. In fact, if I can quote part of, I think it was Comberton Parish Council's response. Oh, and before I forget, well done, Comberton Parish Council. I mean, the work that must have gone into your response. Well done. You know, their health assessment shows that the percentage of population above 65 years is higher in Comberton at 25% than the national figure of 18%. Right, so that's 1 in 4 of the village already is above 65. I'm nearly there, by the way. And then by the time this proposed development comes on board, it'll go to 32% in Comberton. That's nearly 1 in 3 will be over 65. Goodness me, can you imagine that? So that in itself, and we do know the older we get, the more we need in health care. I pride myself on being fit, but I'm seeing the doctor more often now than I used to do when I was younger. And we all understand that. So this supposed clinical space that has been spoken about, I just don't see how that, you know, will help in meeting the needs, the significant health needs of, you know, the people in that age group. And the fact that we have, as has been pointed out, we have objections. The housing strategy, housing people actually are objecting to this. Now, they should know. They are the ones who are the professionals, and they're objecting, you know, saying that this is not, you know, the right provision in the right place. They question the merit of the scheme that adjoins the village rather than being well integrated into the community. Capacity of the GP, exclusivity of the facilities on the site. You know, there's a whole range here. And the health development officer objects. in some respects, it seems to me that the applicant hasn't listened. And, you know, engagement, people know, I always promote applicants to engage with the local communities and listen. You listen and you take into account what they're telling you, and you look at what's available there and what needs to be provided. I'm sorry, but this application falls far short of what I would have expected to see from this applicant. I will be voting against this.
Okay, thank you very much. Right, I'll have a word now. Oh, sorry, Councillor Sandford first.
Thank you, Chair. According to Google, the current population of Comberton is 2,200, and as Councillor Hawkins already pointed out, a significant number of those are already over 65. Add another 300 seniors, you're talking about a village that's 30, 40, 50% over 65, is creating a senior ghetto. I think we know that the facilities in Comberton, public transport, the buses are pretty erratic. There's a village shop, but it's a long, long way from the site. That's before we even look at the harm to the green belt. So I'd agree with the others that this is an inappropriate application in the wrong place. We definitely need to be looking at smaller facilities closer to the villages around the district, not dumping everyone onto one smallish village. That's not the way to go, as Councillor Atkins pointed out, so thank you.
Thank you, Councillor Sandford. You know, I find this very telling that, as others have said, but from our statutory consultees, we've got 9 objections. This is really significant. And when you see housing strategy objecting, as Councillor Hawkins has raised, you know, that's really serious. They remain concerned with the proposal as the scheme is not specific to the needs of the local village of Comberton, why it needs to be in this location. Provision should be dispersed across the district, which the applicant pointed out was what it was trying to serve, rather than intensified in one location, and unclear why such provision for older people cannot be accommodated within a new development which is being planned and developed in that way. We also on site noted the contribution that that area of green space makes to the village of Comberton, and also to the rural walking routes around the village. Also, the, what are they called? The visual depictions of what it would look like proposed a very urban form, LVIAs are they? That proposed a very urban and very tall form of not only the actual clubhouse, but the associated blocks B1, BO1 and BO2, or whatever they were, right into the, you know, very close to the existing residential area, and yet not in keeping with it at all. And also, I don't know whether you noticed it, but one of the design features which I found really quite unkind given the location was the very tall pitched roofs and the very tall chimneys. I don't know whether any of those chimneys were going to be functional, but they just look very big and very tall in what is otherwise a very modestly, a village which has a modest street scene and quite, you know, normally 2-storey houses. So for all the other reasons that others have said, which I'm not going to reiterate, but are absolutely what I agree with, it looks to me as if we are heading towards a decision here, members. So if anybody else wishes to make any comments, and I'll come to the officers for a summary. Okay, so Rebecca, just to be aware, our recommendation is on page 189 at page 11, which is for refusal, and Rebecca can take us through the detail of that. Subject
additional number 6 on the update.
Oh, subject to the number 6 on the update. which we were
done my
given
job
and
for
read
me.
through just before. Okay.
You've
yep.
done my job for me, that's all I was going to say.
Okay.
So officer recommendation is for refusal. There are 5 reasons for refusal set out in the report at section 11, page 189, 190, plus the additional reason for refusal 6, which has been circulated as part of the update report. Thank you, Chair.
Lovely. Thank you very much. So, shall we go to... Sorry. Yep, I'm just doing it. Honestly, give us a chance, folks. Right, so we're going to the recommendation. That's why we've just gone to the recommendation. We're going to go to a vote, please. Thank you. I'll second it, if necessary. Thank you. Right, Erin, could you take us to it's open. So, if you agree with the recommendation of refusal, please press green. Okay? And we are down to 1, 2, 3, 4, 5, 6, 7, 8, 9. We should have 9 votes in total. Has anybody not voted? No, everybody thinks they have, so just bear with us. 8. Okay. So we're unanimously in favour of refusal. Thank you very much to the officers, and thank you very much to all the people of Comberton Parish Council, not only for your extremely comprehensive responses to the application, but also for attending today and for giving your views so succinctly. Very much appreciate that. Thank you. Can we have a pause, folks? Yes. Can we have 5 minutes pause? It's 3:01. Can we come back at 3, 5, 10? Something of that ilk. Thank you, members. Right, so we are now on to agenda item 8, which is on page 421 of our agenda, and it relates to erection of one self-built dwelling at land west of Pound Green. We had a site visit on the 8th of January, and the presenting officer is going to be John McAteer. So thank you, John. Would you like to do your presentation?
Thank you, Chair, and good afternoon, councillors. I'll just start my presentation. As Chair said, this is for the erection of a single self-build dwelling at land to the west of 39 Pound Green in the village of Gildon Morden. This has been called into committee by the delegation panel because it is for a self-build dwelling outside of the Gildon Morden village development framework and within the conservation area, with objections recorded from the local parish council and nearby residents. I've got a local location plan here. We can see Pound Green here on the right, and number 39. And we've got the site area here with access shown onto Pound Lane here.
While you're on that, are you going to, sorry to interrupt, are you going to demonstrate the village framework and the conservation area? Or can you show us on that diagram?
It's on this one here, I believe.
Okay, super duper, thank you.
So that's our location plan. And the site in question outlined in red. So the site history, the site lies within the conservation area and is outside of the development framework and is 0.1 hectares in size. A barn to the west has been approved for residential conversion under that application reference. We can see this one here. And a barn to the south has also been approved for residential conversion, which is down here. I believe the works on that have already completed. This has established precedent for an access driveway to potentially serve 3 residential units on the site. We can see that here. So I realise it's not a particularly big image, but down there you can see the pink line there is the outline of the conservation area, and the dotted line is the development framework. So it exists in a kind of pocket outside the development framework of the village. Issues raised. The conservation team has objected on grounds that the self-build would represent an intensification of the site, which would impact the open nature of the land within the conservation area. We've had no objections from Highways, no objection from the Environmental Health team, the Definitive Maps team or Sustainability, but they have requested informatives. No objection received from Ecology. The local parish council has objected on grounds of overdevelopment of the area in a similar way to conservation. We've had 11 neighbour objections received, raising concerns regarding the overdevelopment of the site, the harm to the conservation area, the damage to the openness of the countryside, and potential impacts upon drainage, parking and access in the local area. So I've just listed the informatives which would be added in the event of an approval. The Definitive Maps team have requested the following informatives: obstruction with building materials. This is regarding the public footpath. Access during development, surface alterations, boundary maintenance responsibilities, no obstruction of a public right-of-way, dominant rights of pedestrians, maintenance of the footpath liabilities, and also the temporary closure of a public right-of-way will require a temporary traffic regulation order. Sustainability have requested a design standard of water informative, and informatives requested by the Environmental Health team will be applied at the technical details stage instead. So the material considerations of a planning in principle application are the location, the use of the land, and the amount of development are the only material considerations. All other issues can be dealt with at stage 2 with a technical details consent application. So location, use of land, and amount of development. While within the countryside, the application site is located immediately adjacent to and opposite land in the development framework. There are residential properties located to the east, south and west. It's considered that the site is within walking distance of Gildon Morden Village Centre, its services and amenities. We've already seen the 2 agricultural barns on the site that have permission for residential conversion. The land has not been in agricultural use for many years and would no longer be suitable given those adjacent domestic dwellings. A single self-built dwelling is proposed, which would be a minor addition to the site and in a small way address the shortfall of self-builds in the area. So this is the planning balance as officers see it. For material considerations in favour of approval, it's for the provision of that self-built dwelling. In favour of refusal, it is outside the development framework. It could be described as an encroachment, and it does represent a minor loss of agricultural land. Officers are recommending approval. Thank you.
Thank you very much, Mr. McAteer. I just wanted to observe that we've got a very full description of the report from the Definitive Maps team, which say no objection, but please could you add these informatives, which you've summarised, but I'm just saying we do need to make sure that they're added to the list of informatives, which currently only list 1, 2, 3, but we need all the informatives from 6.5 to 6.9 in your report,
of course,
to be added in. The other one I wanted to be absolutely clear about was that if you could go back to your slide 2, I think it was, where it showed the map showing, it's the one after that. That one, yes. So the village footpath runs from the road called Pound Green to the east of this site, and it runs, broadly speaking, east-west to the point where the gateway is to this site, and then it runs up through the site towards the meadow at the top, at the north end. And I just wanted to be absolutely clear that we've made provision to ensure that that footpath remains either open, ideally, during the construction, or if that is not actually possible, which I think it should be possible, that there's a proper diversion put in during the build. And I think that's covered.
I believe the informatives
do. 6.7. I think that's.
I believe the informatives do cover that, and the application for the western conversion also has those informatives.
Okay, lovely. So we're absolutely sure the footpath is going to be protected. Councillor Hawkins.
So it's just a point of clarification. You were talking about a path, but it would have been helpful to have the cursor showing where the path.
Yes, exactly. I was slightly surprised the footpath was not actually depicted on this map. So, John, would you like to show us? It's actually quite clear on Google Maps, if you wanted to look on.
So there's one along here and one that moves through the site.
Well, no, not quite. Forgive me. There's one, if I may just. You can see it as a. I'm not very good at. Is this your cursor? Right. Yeah. Okay. There's a path that goes through the core of the site down to here, and there's a path that goes over here and then across to Pound Green Road. Here, it runs in front of houses. So it runs east-west to where the cursor is, back to the corner where we access the site, and then north up through the site to that meadow. Sorry about that. Thank you very much, John. Right, any other questions of clarification for the case officer? Councillor Heather Williams.
Thank you, Chair. It's just around the highways response, which I find very bizarre. But when we then look at the informative, so highways ask for a series of different things, but then in the informatives, we have to just get the Bible out.
Paragraph 6.3. Thank you. Do go ahead.
So we have that, but then when it comes to informatives, we don't really have a reflection. Well, we have that with the indicative maps officer. We don't sort of see, we just have, the council confirms that it is not assessed the acceptability of the access as part of the permission in principle. And we refer to the county highways, but it's not in the informative of what they requested for it to be. So I'm just wondering why. And also, because sometimes there are differences when we consult highways about the actual site and the point at which they're assessing the access, because we get into this complication of where it is adopted roads and not adopted roads. So just on the map, could you just show us where the access point has been assessed?
Well, I think The key point is that these are conditions that would be applied at the second stage. The highways officer has mentioned conditions to be added, but that's not going on the PIP, the planning in principle. That will be later. All this is assessing is whether or not a driveway there can be approved in principle. So I don't have any details to show what that would look like, and I don't have any details to condition at this point in time.
Yes.
Perhaps I wasn't clear. I wasn't talking about conditions, I was talking about informatives. Where we have the request from the definitive maps officer, it's then been reflected in informatives. We don't have that same replication on the highways. For example, about the provision of appropriate pedestrian visibility space, they've all been listed. There's nothing to stop that being an informative, because we can't, according to this, it's unconditional approval, so there's no condition whatsoever.
Yeah,
but it was about on the map where is the point that highways have made the assessment.
So just,
I was going to say, if I can just come back on that, highways have made an assessment, but there isn't an access point on the map. So we can make an assumption about where highways have made an assessment from, but access isn't included as part of this application. So highways have, from their response, made an assessment and requested some conditions. However, I can see that it would be helpful to include details as informatives rather than just a reference to the letter. So we can expand on the informative that refers to the letter to include the detail instead.
and certainly I'd support that, but the other thing is to remember, members, that a planning in principle application only looks at these issues, which are illustrated, itemised on page 41, which is the location, the land use, and the amount of development. And if this is approved at this stage, then everything else, including access, scale, etc., all get looked at the technical application stage. But I'm very happy that we should give the detail of the informatives in this approval, if that's what we wish to give. Okay, thank you very much. Councillor Garvey.
I note that there's a public right-of-way they're going through the site, and I just wondered whether there was any provision to recite it, or...
No, we're talking about it being maintained, which is what the definitive maps team comment was that we've just been discussing about the public right-of-way. In 6.5, we're saying that the things that they requested to be informatives should be included in the recommendation. Did you want to come back on that, Heather? Rebecca.
Promoted again. I'm not sure which Heather I am. Yeah, that's what I was thinking. Just to clarify that if there is any proposal to amend the public right-of-way, that would be done under the technical detail stage and would be an application to the definitive maps team rather than it's not being considered as part of this application.
And it refers at 6.9, the first bullet says, the footpath must remain open and unobstructed at all times. So that includes built during construction. Okay, right. So that's questions to the officer. Debate. Anybody like speakers? Oh, speakers, sorry, yes, yes. Good idea. Right, okay. Sorry. Right. Neil Brady, are you there? Do you want to come forward? So you are objecting to the application, Mr. Brady? So, Mr. Brady, I believe you're speaking as a private resident. Okay. And you have 3 minutes. Do turn your microphone on. Don't worry, it's not timed against that. But so you have 3 minutes, and I'll give you a heads up just as you're heading towards the end of it. So, do carry on.
Thank you. I'm representing the views of the people that live along Pound Green, and it's immediately to the west of 39 Pound Green, where I live. So, planning law requires, as you know, that applications are decided primarily by the development plan, unless material considerations suggest otherwise. But this application breaches every relevant policy pertaining to it in the development plan, as the planning officer indicates in his report. And I've commented on this in detail in the application website. The planning officer wrote to the applicant's agent on the 10th of October saying, I'm of the opinion that the LPA cannot support this proposal. The conservation team have objected, as have a number of neighbouring occupiers and the local parish council. I'm not convinced that a new property on this site can be supported. This application would erect an entirely new property outside of the development framework without sufficient justification. The applicant then changed the application to a self-build, and by the 18th of November, the planning officer wrote back saying, I can confirm I've written my report up in favour of an approval. As I interpret the legislation, the application can be accepted. Well, the planning officer has changed his opinion because of the singular change to self-build designation of this site. Despite the significant weight he had given previously to the material objections he had raised in his previous email, and this seems inconsistent. Now, in the planning officer's report, he goes on at length about the statutory comments that do not object, but he leaves the substantive objection raised by the conservation team until last. And he then quotes only from their most recent comments, but omits to quote their first comment on the 25th of September, which roundly rejected the proposal because of the substantial harm to the conservation area, and it was against local plan NH14, and paragraph 208 of the MPFF applied in terms of damage to the conservation area. All of that is missing. And moreover, this is compounded at paragraph 10.8, when he says incorrectly the site is not in the conservation area, although he's now corrected that, when it plainly is, and it's worthy, therefore, of legal protection. See his section 2.1 where he says it is. He then attaches no planning weight at all to this statutory objection. The self-build proposal. This would reduce the district's self-build deficit by less than 1/4 of 1%.
Are you drawing to a close, Mr. Brady?
I am. I'm in my last paragraph. And as such, that self-build is not a material circumstance deserving of significant weight in the decision.
Thank you. I'm going to call a halt there. You've had 3 minutes. Thank you. Does anybody have any questions to ask Mr. Brady? I'd like you to read your last paragraph.
You'd like to read it?
Yes.
Yes. Thank you. The application doesn't comply with housing policy requirements. It's in the wrong place, and there's uncertainty about its status as a self-build unit under Section 9 of the Housing and Planning Act 2016, Section 1A2. This is confirmed by findings in the recent planning inspector's reports that the planning officer quotes, particularly the ones referenced in paragraph 1029. And if you read them, you would see at findings in the one ending 5585 the importance of the development plan rather than self-build in such decisions such as this. So there's no summary, there's no substantial weight, there should be no substantial weight given to this self-build. It's a creeping encroachment on a settled line between the framework boundary and the countryside, which policies explicitly repudiate. And I ask that you refuse permission.
Thank you very much, Mr. Brady. Has anybody else any questions for Mr. Brady? No? Okay. Oh, Councillor Dr. Toomey Hawkins.
Thank you, Chair. Thank you, Mr. Brady. And through you, Chair. The site already has two buildings that will be residential, is that correct?
There are barns which have been allowed to be developed under the rural exemptions in the planning system. They are, that kind of development is allowed in the countryside where you're replacing. This is for a new build. That's the difference.
Okay.
For those of us who were on the site visit on the 8th, there is no previous building at this.
Yeah, no, sorry, that's what I'm just trying to establish that there already is established residential use on the site. In which case, applying our own weight for self-build, which is what we do need. We have a requirement for self-build.
I think the observation that Mr. Brady made was that previously the application was a standard application, and it was the officer recommended that he could not that he couldn't support it. So the applicant changed it. I'm saying this is what Mr. Brady said to us. The applicant changed it to a self-build, at which point the officers changed their view and said it was supportable. So did you want to pick up on that, Councillor Hawkins? Okay. Did you want to make a comment on that, Rebecca, because it rather suggests a change?
Yeah, I can make a comment on that. There's reference to it on page 431 or 10.16 of the officer report, which does set out that there is an in-principle objection to the erection of dwellings in that location because there is no local or national planning policy to support it. So that would have been officer's stance if it was not a self-build application, if it was standalone residential development. However, we do have a shortfall in self-build as detailed in the next few sections of the report, and there are material, we consider that shortfall to be a material consideration that warrants departure from that policy.
Yeah. Okay, thank you very much. Right, okay, so thank you very much, Mr. Brady, and thank you very much for representing the views of the people on Pound Green. So we'll next come to Tom Kilvert, who's the agent for the applicant Brown and Company, Property and Business Consultant LLP. So, Mr. Kilvert. So you've got 3 minutes. So we look forward to hearing what you say. Thank you.
Thank you, Chair, and members of the Planning Committee, for allowing me to speak on behalf of my client, Mr. Brown, concerning his permission and principal application for one self-built dwelling, which has officer recommendation for approval. Permission and principal is a fast-track route to speed up the planning process, with the principal development considered at the first stage, and then technical matters such as detailed design to be assessed at the second stage. Regarding the principal development, it is acknowledged that the site is located outside the village's development framework. Notwithstanding this, the site is in a sustainable location, less than 200 metres from the village primary school. The development would not encroach into the open countryside, as it would be immediately adjacent to the development framework on 3 sides, and it would be an infill development between number 39 Pound Lane and the 2 recent residential consents referred to as Barns 1 and 2. These 2 residential consents have shifted the built form further north, albeit the village framework boundary has not been updated to reflect this. The site has a residential context and is more related to village than the open countryside. As such, the scheme accords with the principles of policy S7. Moreover, as you've heard, the application is for a self-built dwelling, and as acknowledged in the officer report, the council has a significant shortfall of 418 self-build / custom-build plots, and this has been the case for some time now. This significant shortfall has been further intensified in a number of, identified in a number of recent appeal decisions. As such, as set out by the officer, substantial weight should be given delivery of self-build plot in this sustainable location. As I mentioned, detailed design will be provided at the technical stage, enabling the council to control over the design of a building. It is envisioned that a traditional barn-style residential property would be appropriate in this location, given the proximity of barns 1 and 2. So thank you, members. Your request to support this application in line with your officer's recommendation for approval. Thank you very much.
Thank you very much, Mr. Kilbert. Does anybody have any questions for Mr. Kilbert? No? Okay, Councillor Williams. Thank you.
Thank you, Chair. Through yourself, given the response from the Cambridgeshire County Council and their requests, and we are looking at the location of the development, do you think there's any way, particularly the pedestrian access, that you'd ever be able to comply with that? Comply with it?
So is that for the pedestrian link through?
In that location and for their requests?
Yes, that's something we'd take on any of those views put forward when putting together detailed designs. But that's a matter for the next stage of the process. There is that driveway that is being developed as part of the barn 1 and 2 proposal. So it's something we will look at, but it's not something we've had to assess at this stage, if that makes sense.
Indeed, I wanted to ask a related question, which is that when we were on the site visit, we saw the site with the one property that's been developed, the second that has permission for development, and the site of this application. Subsequently, I looked on Google Maps to see the route of the footpath, because whilst we were on site, we could see there were pedestrian informal routes going. I know it is a formal footpath, but on the ground, it looked to me relatively informal up to the meadow at the top. What I hadn't appreciated was that there was actually a footpath that ran from the southern corner of this site eastwards to Pound Green. And indeed, when you look on Google Maps, you can see the access to that, and you can see the finger post to that, running past the 2 cottages at 31 and 33 Pound Green. But when you look back at the photographs that have been submitted as part of the application, that footpath at that site appears to be somewhat overgrown. I didn't walk it myself on the site visit. So could you clarify for me, is that footpath currently accessible from Pound Green through this site?
That's not something I'm aware of. I can't comment on that.
I wondered if it was overgrown.
Possibly could be the case, yes, but it falls outside the application site boundary.
Is it outside the boundary or inside the boundary?
So you're talking about near the gate? Is that what you're referring to?
Well, it's marked on the county mapping, and it goes from, as it were, the right-hand side of the site gate, eastwards, between 2 hedges, to the road called Pound Green, and it has a finger post on it.
Outside the site.
So it's shown on Google Mapping, it's shown on county mapping as a footpath, it's shown on the photographs, which show a finger post pointing up the hill to the meadow in the application paperwork. But it wasn't obvious to me when we were there on site. So I just wondered, is that footpath, which goes past the front of the cottages 31 and 33 Pound Green, is that accessible at present? So, no, but yes. So the footpath. Could you show us with your cursor, Rebecca? So the footpath runs south of the. So can you see on Pound Green? There's 31 and 33 next to the E of green. There's 31 and 33. No, there. across the front of those cottages, there is a footpath that runs between hedges down to there, and it appears to be outside the blue line boundary. But what I was asking is, it wasn't clear to me until that's been illustrated here that the footpath runs outside the property rather than over the property, which wasn't clear to me before. So it is outside the blue line. Right, okay, that's fine. However, the one that runs north does run across the property. Okay. So, any further questions for Mr. Kilbert? Martin Kahn.
So I simply wanted to ask and I wanted to confirm with Rebecca of this case. In terms of a footpath, if it is obstructed at present, that's a really irrelevant matter. The question is whether the footpath, if the footpath's on the definitive map, it mustn't be newly obstructed. Am I correct in that?
That's what it says in the report, yeah. Yes. Let's have our legal officer speak.
Okay, yeah. Yeah, the County Council are the responsible body for ensuring the public's right to pass and repass along public highways. So if it's a footpath, bridleway, and it's on a definitive map, then there's a duty for the landowner to maintain that unobstructed. If it is obstructed, then the county will take the appropriate enforcement.
And for clarity, the reason I was asking where it is because from the imagery, it's not entirely obvious whether it actually runs inside of this site's hedge or outside, but you've clarified that it's outside, so that's fine. Right, no further questions for Mr. Kilbert? Right, okay, thank you very much, Mr. Kilbert, that's helpful. Okay, can I just ask, is Councillor Ken Locke, the chair of Guildon Morden Parish Council here? Thank you. I think he's coming forward. Thank you very much, Mr. Locke. Thank you for attending. Can I just check to confirm that you have the authority of your parish council to speak on this matter? Do turn your microphone on.
Yeah, just the right-hand button. Yeah,
the right-hand button on the... That's it. Sorry, can I just confirm you have the authority of your parish council?
I have got the authority, yes.
Lovely, thank you very much.
I'm a long-term resident of Guildon Morden, and as you said, I'm chair of the parish council.
That's great, thank you very much. So you have 3 minutes, Mr. Locke.
Okay,
thank you for being patient with us. And I'll let you know as you're getting close to your 3 minutes.
Okay, thank you. The parish council voted unanimously to object to this application for the reasons that have been shown up there for overdevelopment of the area. We have taken into account other developments that are going on in Pound Green at the moment, and I'll come back to that. There's a couple of points I wanted to make first. The site is described as land to the west of 39 Pound Green. 39 Pound Green would have a shared boundary with this proposed site, and yet on the neighbours' notification, they weren't notified. The properties either side of number 39 were, and together with that, there's another property which is called Meadowview, which is one of the barns. They weren't notified either, but they obviously got to hear about it in that they've actually sent in an objection, and you've heard from the gentleman recently who represented 39, but it was only by hearsay or word of mouth that he got to hear about it. The parish council was concerned that it is an overdevelopment. If I can just remind people, if they probably may not be aware, but Pound Green, it's all Pound Green. I think the officer referred to it as Pound Lane. It's all Pound Green. There's Pound Green main road, which joins the High Street to Dubsnell Road, and there's Pound Green, which is a cul-de-sac, which is a single track road with a blind bend close to the main road. When you get to the site, if you've had the site visit, you'll see when that single track road ends, it goes into what is nothing more than a farm track. And up that farm track, there are three barns, or two barns rather, and a stable block, which are currently, well, one is being, they had permission, all had permission under permitted development rights. The one at the furthest end, the construction work will start in March, and the one closer to the main road is in progress, and the stable block, I don't know when that will start. But there's three new houses, or residences rather, that will come into play fairly shortly, which will add to the traffic in Pound Green.
Sorry, Mr. Locke, that is the indication of the 3 minutes, but I'm going to let you speak as long as you constrain your time, if you can, please.
Thank you. So that was one of the major considerations that the parish council took into account. It is a dangerous road anyway, Pound Green, insofar as traffic meets other traffic head on, and frequently one has to reverse out. And with the number of supermarket delivery vans and one thing or another, it's an accident waiting to happen when they reverse into the main road. And that was something that was taken into account by the parish council, unaware that access is not taken into account with permission in principle. But as far as that is concerned, the permission in principle, I heard what you say, that highways are no comment, but I wondered why highways, in fact, are involved in this stage.
I'm going to call a halt there, because you've had your 3 minutes, but I'm going to ask you some questions that give you a bit more time. So, I would like to ask you, you're referring to a stable block, but I'm aware on the map there is a stable block to the northwest of this site, but I think it's outside the blue line boundary for this development.
Yes,
so I wanted to check with you. On site, as I described before, we saw on the site of this actual application, we saw off to the right-hand side, to the east, we saw a small dwelling that has already been given permission and developed.
That's Meadowview.
We saw, and that was on the site of an existing building, we saw the barn on the left, which has also been given permission, and we saw the site on the right-hand side of this site, which is where this development is proposed. So can I just ask you to clarify in what way you think this one additional dwelling would represent overdevelopment? Because overdevelopment is a very broad descriptor, and I want you to explain to us why you think this one extra house is overdevelopment on this site, please.
I do understand that. The other developments that are carrying on at the moment had permitted development rights, and insofar as that there's nothing the parish council can do to object to that, but really enough is enough. And when it came down to it, the discussion we had, they said, okay, well, this last barn that you referred to, that you saw, which was in fact demolished on Monday, that will be the end of all those properties up there which will have permitted development rights. And the parish council said, well, enough is enough, and we don't want new builds.
So the point being, the barn on the left was the last that had permitted development rights, whereas this would be a new build in what is a conservation area and outside the development framework.
Exactly.
Thank you very much. So, members, do you have any other questions for Mr. Locke? Yes? Oh, no. Okay. Right. No, I can't see any. So thank you very much, Mr. Locke, for answering my questions. Thank you. Okay, so members, we've heard from all the representatives. We have, currently we've got a recommendation of approval for this permission in principle, which is looking at location, land use, and amount of development only. Any further detail will come under the technical details, which would be submitted to us later if this were given approval, in much the same way that if this were an outline approval, we would then bring reserved matters back to committee. So this is looking at this application in terms of its location, land use, and amount of development. Does anybody want to speak in the debate? So, Councillor Heather Williams.
Thank you, Chair. Obviously, I'm very familiar with the site as it's in my ward. I think Guildham Morden has seen a lot of development in recent years for a village of its size, and actually welcomed a lot of development. But this, I think, is very different to what's before. I mean, it's in the conservation area. I'm trying to find the best way to explain it for anybody that hasn't been on site. It's a very narrow track that goes up, and you would be really surprised when you go up there, actually, at the amount of houses there. And I think the use of existing buildings for conversion is something that we do want to see. We do want to see those buildings brought back into use, and that has been done. But when you start putting new buildings and new development into places like Pound Green, I think you will then start to alter the character, and you also start to alter that conservation area. And we do have an objection. If you can draw members, I'm just trying to, I don't know why it's flicking around like crazy today, and so I'm trying to go between paper. So, Chair, you might get paragraph 6.17, so that's page 428 for me. The urban design and conservation team, they do object. The whole point of conservation areas is to conserve and to enhance where possible. But once we start building on those areas, then they are lost. They are gone. And I think that's very different to what's previously happened on site, which is the repurposing of buildings, which I do support. I think that on this site, the officer's original recommendation was very clear. It would be refusal for a new build. The only thing that means that it's recommended for approval is that self-build element. Absolutely everything else, if we took the word self-build out of it, it would be completely a refusal, and it probably wouldn't actually even be before us because that would have just been dealt with. So when we look at that in case of the location and the land use and where it is, one self-build in that conservation area is not going to make or break the land supply issues of self-builds. I think that it's been very hard for a lot of us as members to sit here on planning committee, and I'm looking around the room, and many of us have had them in our wards, and you know, some I've supported, some I haven't, but I don't think we've had such a conservation area, that to off the top of my head. Councillor Hawkins may have a better memory than me. But I do think that is something different in this instance. I think if it was not a conservation area, then it possibly would be a different discussion, and I would have to suck that up as a local member, I think. But I think the conservation is there. We have a duty to conserve our conservation areas, and I am minded to support our, it's jumped around again, our urban design and conservation team's objection, and I think I would urge members to do the same. It is a balancing act, and it is a difficult one. I appreciate that. But one self-build, that's not going to make or break the issue here. And so I don't think that it's the tilted balance of self-build really should be fully applied in this case. That's my 2 pennies worth, Chair.
Thank you very much. I just wanted to point out to members that we did have a similar request for self-build, which was in, I think, Melbourne, and it was outside the development framework, inside the conservation area. So it was actually very similar to this. And as I recall, we approved it. Okay, so just...
Chair, that was for more. That wasn't just a single one.
No,
that's
right.
my...
It was for, I think, 2 or 3 houses.
Yeah, but it was significantly contributing more to the problem. This is one building.
I understand what you're saying. Right. So, Councillor Martin Carr.
The fact that it was the applicant first put in for a new build and then changed to a self-build is not really relevant in terms of, you may consider it you may not like that, but we have to deal with the applications before us. And the applicant is entitled to make change to a more acceptable solution if he wants to. So I ignore that aspect of it completely. I look at the site, and we went out on the site visit. The site is actually surrounded on 3 sides by the development framework. It's not sort of and it appears to be an old farmyard, which therefore would have had buildings, and probably more buildings than there are one at present. If it had been an industrial thing, it would be brownfield land. As it's a farm land, it doesn't count, it counts as agricultural land, but it's perhaps, in logical terms, a bit of a misnomer. So the question, so I find the fact, I don't really find that it's extending effectively the built-up area because of that, because of the particular geography of the site. The arguments about highways, this is an implicit in principle. If we want to insist that people can come out of it forward so that they have good visibility, that's something we deal with at the later stage, and it's not something that we would consider now. In terms of the overdevelopment of the site, and the Conservation Officer comments, I take a rather different view. I feel that the site is already, has a history of buildings, is already effectively built up, even if it wasn't residential, and that if a proper design could be built, it could fit in quite well. It's a matter of scale, size, design, and that's not something we consider at this stage. So the question is whether you could build an acceptable development, not whether the actual development that we have now is acceptable. But the fact that you have a self-build does change the thing, because we have a shortage, and we have found from previous experience that is a big factor when it's considered. So there is some context, even if it's not a precedent, about this specific application. So my personal view is that the case for the development is sufficiently strong that the intrusion is perhaps not need not necessarily be as bad as the Conservation Officer concerned, but obviously we have to take, at the later stage, the details of the design would be an important issue if we approved it, and will be a critical matter because it's in a conservation area. The assumption that because you have development in a conservation area, it's going to be deleterious is quite often accepted. I don't accept it. I think you can have new development which is attractive and intrusive and would improve the conservation area. You could have development which harms it. So it's up to us, I would feel it's up to us at a later stage to ensure that it's a satisfactory development. But in terms of principle, I would generally be in favour of this.
Thank you, Councillor Khan. Does anybody else wish to speak on this? Councillor Dr. Toomey Hawkins.
Thank you, Chair. I mean, I understand where Councillor Heather Williams is coming from. Yes, it's conservation, but at the same time, the previous speaker again made the valid point that it's an area that already has a residential establishment. Hence my question to one of the previous speakers. It's a balance, really, and of course we know we have self-build shortage. And I'm going to use a phrase that we've all heard a lot: every little helps.
Sorry?
Every little helps. I know it's one, but it's one less than we'll have to look for. Frankly, unless we actually, as a council, find a piece of land somewhere and create self-build plots, it might take a while for us to actually catch up, unless, you know, the rules change, government might change it, who knows? But the situation we have now is, provided there's no significant harm, then there's no reason why we can't look at this more positively. And for me, at this point in time, the benefit outweighs the harm.
Thank you very much.
Thank you.
Councillor Fain.
Thank you, Chair. I really don't need to add anything to the comments that have just been made by Councillors Khan and Councillor Toomey Hawkins. I entirely support both of them on the points they've made.
Okay. And I wanted to say that it was very useful to do the site visit and also to hear the representations of the people today. And whilst this is outside the village development framework and inside the conservation area, it is nevertheless, it does have development on the west, the south and the east of it already. And actually, I think the point that I think this site is it's already got permission for 2 properties, one of which has already been built. And I don't think this additional 3rd property would add a significant detriment to this piece of land. And in fact, it might balance the development, and I don't think it would be problematic, and it would add 1 more house. Also, I don't think, it's interesting, Councillor Khan has mentioned this, I do not think a dwelling in this location would be detrimental to the conservation area, particularly if it was a nicely developed, a nicely designed building. So I think the principles that the officer has used to recommend approval, they chime with me. So let's move then, if we're all through. Did you want to come back in before we sum up?
Yeah, just in response to what's been said, if we look at paragraph 6.2 of our own report from our own officer at this council, it does say a further dwelling, even in a barn style, would be an intensification of the site which would detrimentally impact on the remaining open nature of this piece of land within the conservation area. I would just ask members to really bear that sentence from our own officer in mind before proceeding to the vote.
Thank you very much. Sorry, 6.20 you're referring to.
Page 428.
Yes. So let's just read that. It's correct that once barn 1 is converted and a new driveway formed, that this site would change again. However, as I stated in my previous comments, a further dwelling, even in a barn style, sorry, barn 1 being the one that's already got permission, a further dwelling, even in a barn style, would be an intensification of the site, which would detrimentally impact on the remaining open nature of this piece of land within the conservation area. Okay, so we've heard that view. I am proposing that we go to the vote, if anybody... sorry, Rebecca, do you want to give us a summary of where we are?
Thank you, Chair. Officer recommendation is set out on page 438, section 12. Recommendation to approve unconditionally. There are 3 informatives in the report. However, we're suggesting the addition of the public right-of-way informatives that John detailed on his slide, and are within the report, and the expansion of informative number 2 to refer to the details that highways would expect to be included as part of the technical details application. Thank you.
Thank you very much, Rebecca. So with those amendments, let's go to the vote then. Erin, could you?
That's just loading now.
Thank you very much. Do we need a seconder for that, or is it taken as recommendation of the report?
If you are members are assured of what they're voting on. So I think that's
We've
fine.
clarified. Yeah, okay, good. Right, so members. So we are 8, 8. So that's everybody who's voted. That's 7 in favour and 1 against. So that is carried. Thank you very much, members. Thank you, those who've attended from Guild and Morden. Appreciate your contributions. Thank you very much indeed. And we hope that when this comes to the technical detail stage, we can make this development as acceptable as possible. Thank you. Thank you very much. So members, let's move on to item 9, which is, have we got Phoebe Carter somewhere close by? Great, okay. So item 9 is 24-02619/outline. It's for, the site is at Avon Fields, which is land at Hayden Way. We're on page 441 of our agenda, and it's in Over and Willingham. It's an outline planning application with all matters reserved access for the erection of up to 4 custom-built dwellings. Right, okay, so we've got Phoebe Carter who is presenting to us. I'll just run through a few things while she's setting up. So it's come to the committee because it raises special planning policy or other considerations. We had a site visit on the 8th of January, and the key issues are that the land is outside the development framework for Willingham. But it's a self-build need, and the other key issue is character and appearance, although this is an outline with all matters except access reserved. And the recommendation is approval, subject to conditions, and a unilateral undertaking, which perhaps, Phoebe, you would explain as part of your recommendation what the unilateral undertaking refers to.
Thank you, Chair. Good afternoon. This, as Chair set out, is for outline planning application with all matters reserved.
Sorry, please remember this room echoes and the people online won't be able to. So please give yourself time to speak clearly. Thank you. Sorry, please, would you let the officer proceed? Thank you.
Apologies. Outline planning application with all matters reserved except access for the erection of up to 4 custom-built dwellings. Please note that an amendment report was sent to members yesterday updating the wording of condition 8 to an archaeology condition. Unfortunately, and apologies, there was a duplication of the sustainability condition instead of the archaeology condition initially, and the wording of the informatives were not attached to this report either, so they have been added. So this site is located off Hayden Way, which is shown in red here, and the applicants also own this barn in here, which is currently got permission for B1 and B8 use, so it's now Class E, and B8, which is for storage. Conditions were attached onto this barn, restricting the hours of use, so officers don't consider that any works within this barn would impact any future occupants. And they also own the land to the west of the site, which includes a barn located where my pointer is here, which I'll also point out later. This barn has prior approval for the change of use from an agricultural barn to a residential dwelling, and the access from it runs through this proposed site. There's Over Road to the north of the site here, which Hayden Way comes off. Bus stops are located on this road, and there is a small range of shops developed in this Highgate location here, and there is development that runs along Over Road. To the east of the site in here, where my pointer is a road called Hereford Way, which comprises of 64 dwellings that has recently been built out. To the north and the south of the site are both agricultural fields. So this is the aerial view of the site. In here is Hereford Way, which is not shown as being built out, but it has been. This is the storage barn at the current time, and this is the site in here. It's currently a brownfield site that's used for storage for the builder's yard. There is quite a defined hedgerow to the north and the south of the site, which protects a lot of wider views, and this has been recommended to be retained. This is just to indicate the constraints of the site. You'll note to the northeast is the development framework boundary, which is located approximately 20 metres from the entrance to the site. The junction here with Hereford Way and Hayden Way is the end of the public highway. There is this very small section in here which forms part of the entrance of a public bridle way. The site already has rights of access over this site, and the red line does extend to the extent of the public highway. The access has been included within the outline planning permission, and conditions have been attached regarding the maintenance and upkeep of this, as well as to ensure that the falls and levels don't drain onto the public highway. You'll note also on the constraints plan that whilst this doesn't fall within flood zone, the site falls within flood zone 1, which is the lowest fluvial risk, there is surface water flooding on the site. A flood risk assessment was submitted in support of the application, which has been reviewed by the lead local flood authority, who have no objections subject to conditions. Here are a couple of site photographs. This is the barn in current use, which will be retained. And then you can see the defined hedgerows to the north and south of the site. A biodiversity assessment has been submitted. They are not required to meet the 10% biodiversity net gain because this is a custom build site. However, there is scope for biodiversity enhancements, and as set out within the report, there is going to be a hedgerow and also grassland uplift on the site, and the ecologists are satisfied with it. As this is an outline application, the proposed, this is an indicative site layout. All of the 4 custom build plots have, are shown currently as having sufficient floor space and garden space, and a condition has been attached to ensure that this is achieved. They are shown on the indicative site layout as with a maximum of plot 2 and plot 4 as 1.5 stories to prevent the wider views from the landscape and from the countryside. We have conditioned that it will not be more than 1.5 stories for any of the dwellings. The hedgerows to the north and the south do protect the for the development from wider views. Officers do note that there would be countryside harm through encroachment. However, it is considered to be minimal given the existing use of the site and the hedgerows preventing much of the wider views. This is a concept street scene that has been provided. Materials of the proposed dwellings have been conditioned. And this is a concept block plan that has been provided as well, just for illustration purposes. An objection to the application was received by Wellingham Parish Council. No further objections to the scheme has been received by third parties or from consultees. In regards to the planning balance, the proposal is outside of the framework and would be contrary to the spatial strategy, and weighing against the proposal to a lesser extent is the degree of sustainability and would result in limited localised harm to the character and appearance of the countryside. The benefits of the scheme: the application would approve the provision of up to 4 custom-built dwellings, which would help meet a substantial identified shortfall in the area, which attracts significant weight in favour of the application. It is also considered to be located in a reasonably sustainable location and would result in only minimal harm to its surroundings. The officer recommendation is for approval subject to unilateral undertaking and conditions. In regards to the unilateral undertaking, this has been agreed with legal to ensure that the dwellings outside of the framework are custom build and meet the custom and self-build requirements. Thank you, Chair.
Thank you, Ms. Carter. I just want to, if you would kindly go back in your presentation, you might want to do it on the other mode, because I wanted you to go back to the slide immediately prior to your site photos, excuse me, which showed the flood risk. So this shows us the flood risk of the site facing north, and what we can see is that there's a very faint underlying layer of grey which shows a strip right through the site at the western half, which is pale grey, and then there's a darker layer on top of that which is like a mid-grey, and then there's a very dark blue line, which is, that's it, that. So I just wanted, could you please to explain to us, as I recall, these illustrations of potential flood risk, they relate to 1 in 100 years, 1 in 50 years, 1 in 20 years, something like that. Can you just remind us what those flood risk areas mean?
So, as you said, the different areas are relating to the severity of surface water flooding and the risks. The darkest area will be 1 in 30 years. The mid-colour, sort of where I'm pointing, there will be 1 in 100 years, and this is likely to be 1 in 200 years.
Thank you very much. That's helpful. Now, so bear in mind, members, that is that way round. It's correctly orientated for the compass. So can you go then to your slides which showed the, well, for example, this one. So this is the correct way round for the compass, because north is at the top of this diagram. So those previous flood risk areas, to my rough memory, would appear to go over plots 4 and 3 to the west of the site. But as you pointed out, they were mainly 1 in 200, mainly 1 in 100, with a 1 in 30 only, I think, on plot 4. And your concept block plan has been depicted the other way round. In other words, this is now looking south at the top of the page. So actually, the plot 4, the one we thought, and 3 are the ones on the right-hand side of this diagram. So we just need to be aware of that flood risk. And whether that level of flood risk is deemed to be acceptable, and the lead local flood authority has said there's no objection. So presumably they feel there might be some way of conditioning it to be built at a certain level above the current ground level in order to mitigate that risk. Am I understanding that correctly?
Yes, they have submitted a flood risk assessment which encompasses lots of different ways of building. So it would include flood resilient build, floor levels, but it will also take into account permeable paving, the drainage strategies. It's not just a single thing that the flood risk assessment will assess. It will assess it against the standards, but it will take into account not just the build quality, but also how soft landscaping will come into play, how permeable paving instead of for the access instead of hard standing. And so it's not just one aspect they look at. It is a range of
information that is brought forward that will lead to the conclusions that were drawn by the Lead Local Flood Authority, and the condition has conditioned the flood risk assessment. So if anything changes, then they would have to amend the condition or bring back that to be reassessed by the Lead Local Flood Authority.
So, and we saw when we were on site that there is a ditch that runs down what is effectively the right-hand side of this diagram, the west side of the site. But the other thing that slightly bothers me is whether development on this site would have the effect of increasing the risk of flooding elsewhere. And I suspect the answer to that is no, because anything displaced would go south and west and into the ditch or south of this site, and it wouldn't increase the risk, for example, in Hereford Way, for example.
This will have been assessed as part of the flood risk assessment. Yeah. I'm not in a position that I can make that judgment.
Okay, thank you very much. Has anybody else got any questions for the case officer?
Don't see any.
No, I don't. Okay, so debate then. Oh, sorry, here we go. Yeah, here we are. It's quite predictable, isn't it? I'm going to forget all about everything. Right, okay, so we haven't got any objectors, but we've got Lewis Collins, who is the agent for the applicant, Partners in Planning and Architecture Limited. So I believe you're online, Mr. Collins.
I am indeed. Can you hear me?
Okay, so you've got 3 minutes, Mr. Collins. Thank you.
Perfect. Thank you, Chair, and good afternoon, members. My understanding is the main reason this application has been referred to committee is due to the objections submitted by the Parish Council and Councillor Handley. Therefore, I'd like to take this opportunity to respond to the concerns raised. Firstly, the Parish Council are correct that the site is outside the development framework of Willingham. However, the officer's report sets out that the site is in a relatively sustainable location for residential development and that the proposed development would have minimal impact on the character and appearance of the area. All other material considerations have been addressed and there are no objections from specialist consultees or neighbours. It is therefore concluded in this instance that the benefits of the proposal, primarily provision of 4 custom-built plots, would outweigh the conflict with the development framework in this instance. Secondly, the Parish Council have raised concern that this development would set a precedent for others to build on the open space south of the village envelope and Northstowe. This brownfield site is adjacent to existing and permitted residential development and would make no notable encroachment on the countryside which separates Willingham and Northstowe. Any future development proposals on land between Willingham and Northstowe would be assessed on their own merits. Thirdly, the Parish Council have raised concerns regarding surface water flood risk. The Environment Agency flood maps identify a risk of shallow ponding in low spots in the western part of the site. The proposed development will incorporate a new surface water drainage system that will address the risk by taking rainfall landing on the site into an attenuation system before discharging into the adjacent watercourse at a restricted rate. As you've just discussed, the Lead Local Flood Authority were consulted and raised no objection. The final point made by the parish relates to them not being consulted on an application in 2019. This matter has no relevance to the determination of this application. In summary, this is a clear case where the benefits of the proposed development outweigh the conflict with the development plan, and therefore permission should be granted as recommended by your officers. Thank you, Chair.
Thank you very much, Mr. Collins. Does anybody have any questions for Mr. Collins? No? Okay, so thank you very much, Mr. Collins. Oh, sorry, Councillor Hawkins, do go ahead.
Yeah, thank you, Mr. Collins, and through you, Chair. Obviously, there's issue of surface water flooding in the area. Is that not a concern for whatever it is you might, that could be built on there?
No, so as the case officer set out, we submitted a flood risk assessment as part of the application that was carried out by suitably qualified flood risk engineers, and they've concluded that an attenuation system could be put in place which collects the rainwater and discharges it into the watercourse at a restricted rate, so it would pass all the necessary tests to be an improvement on the existing drainage situation for 4 dwellings to be constructed sufficiently. I think they've also included on there, the officers have recommended increase in the finished floor levels of the 4 dwellings to 300 millimetres above ground level, which I think it's a precautionary measure, but we're happy to agree to that condition.
Thank you.
On that point, I just wanted to ask, given that the site, as I clarified with the officer at the beginning, does have a risk of flooding in those areas, can you just clarify whether, my observation was that the most likely source of the flooding is actually the ditch adjacent to the site. And I just wondered, you know, if the ditch is full, then the attenuation ponds are not going to be able to discharge into it, are they? I just wondered if you had any thoughts on that.
Without being a specialist, not overly. I think the flood risk assessment identifies low spots, and I suspect some of the overflow of the ditch is an issue. I think what the lead local flood authority will be looking at is they'll compare the existing situation and compare the proposed drainage solution put forward in the calculations and come to a decision on whether we are improving the current drainage situation and not having any risk on other sites. So we're satisfied that the flood risk assessment demonstrates that, and obviously the lead local flood authority are as well.
Thank you very much. Okay, are there any other questions for Mr. Collins? No. Okay, so thank you very much, Mr. Collins. Thank you for answering our questions. So the next speaker is Neil Harris of Willingham Parish Council. Are you online? Or is he not here? We don't have him. We don't have him. Okay, so sorry, we cannot take representations when people are not here and haven't submitted them. So, yes, I was going to say we do have Councillor Handley online. Councillor Handley, we've got your the summary of your statement at 8.1 in our agenda. Did you want to, which is on page 447, saying, I'll just read it for you, Councillor Handley has made representation objecting to the application in support of the comments received by the Parish Council and has recommended the application is taken to committee. Did you want to add anything further, Councillor Handley?
Yeah, thank you. Can you hear me?
Yes, we can.
Oh, great. Yeah, thank you for allowing me to speak. Got a lot of work going on in my house, which has made it quite difficult for me to concentrate today. But yes, I'd like to ask the committee to reflect if the officer's recommended or recommendation here gives the local plan sufficient weight. The application falls outside of the village framework. It's a minor rural centre, and in my opinion, if we want the public and parish councils to take the local plan seriously, we need to be careful. Hereford Way was built outside of the framework on appeal during the time when we weren't able to demonstrate a 5-year housing land supply, and I'm not sure that a plan to build 4 self-build, custom-build units is sufficient to outweigh the harm of punching another hole in the village framework and encouraging further into the countryside. And I just ask the committee to consider that during their discussions. I understand that the planning authority has an obligation to meet, the need for self-build properties, but I'd just like the committee to consider whether they think that in this case excessive weight has been placed on the need for a relatively small number of custom build units. And I draw your attention to the summary of benefits on page 462. The justification of the officer's recommendation for custom build units is actually mentioned twice. Now, my second point, very quickly, is about flooding. As the parish council's pointed out, Willingham has a serious problem with surface water flooding. In recent years, there have been serious sewage contaminated flooding in parts of the village, and one incident caused the closure of the primary school. The underlying problem for this is capacity. It's not been addressed by the authorities so far, by Anglian Water, and this is the reason that the parish council has resolved not to support any further development in Willingham until it is resolved. Okay, this is a relatively small development of custom build units, maybe won't make a very big difference to the planning authority's numbers, but I would ask the committee to think whether the officer's judgment on balance are right in this occasion. Given that the proposal is to build outside of the village framework into the countryside, and without really due consideration of the serious concerns that the village has over sewage treatment capacity in Willingham. Thank you.
Thank you very much, Councillor Handley. Do members have any questions for Councillor Handley? In which case, Councillor Handley, I will just thank you for giving us the local flavour, shall we say, of the problems of flooding that you have in the area. Do you know anecdotally whether this site itself has been very much subject to flooding in the past or recently?
And no, I think you've got the flood risk map. I think as much as anything, the parish council's concerns are to do with capacity, adding to an already overstretched system. The flooding we've seen dotted around the village in the last few years, you mentioned earlier, once in 100-year event, once in 50-year event. Seemingly we're getting, the village of Willingham is getting extreme events more frequently than they ever have before. And until the problems of capacity, sewage contaminated floodwater on the green and on the roads in the centre of the village is not fun for anyone. It's not just water, it's sewage contaminated water, and it really needs to be addressed if this village is going to be able to, you're going to be able to build sustainably in the future.
Thank you very much, Councillor Handley. Councillor Hawkins.
Thank you, Chair. Sorry, Councillor Handley. In terms of the issues that you've raised, and I hear you very, very loudly, the responsible authorities are the Lead Local Flood Authority and Anglian Water. Is the parish council actually engaging with them to try and resolve these issues?
They are certainly trying to. They've had Anglian Water and representatives. They invited them to one of their parish council meetings about a year ago, but as far as I know, there's no progress been made. That we still have that risk.
Right. Thank you.
Thank you very much. I'm just trying to find the comment from Anglian Water, which must be around 444, something like that. Oh, interesting. No comment from Anglian Water. There's Lead Local Flood Authority, but nothing from Anglian Water. Right. Okay, thank you very much indeed,
Okay.
Councillor
Thank
Handley.
you.
That's helpful. Right, Councillor Dr. Timmy Hawkins. We're into debate now.
Councillor Handley made a point about the local plan and frameworks. But the issue is, we are in a situation where we have to depart from the local plan policy sometimes. And if members will look back, a lot of the self-builds we've had applications come through, a lot of them have been outside the village framework. So unless there is something that we can look at in the policy that says we can't depart from it, it seems to me we'll have to keep looking at these issues as they come on their own merits, whether they are within the framework or outside the village framework. And as I said before, the previous one, these things are coming in small numbers, and we don't have a choice but to look at them, those small numbers, and add them up, and hopefully at some point in time we'll get to a stage where we're not, short of allocations for self-build as the government requires. Let's also bear in mind the new MPPF. We're supposed to be building 1.5 million homes in this parliament. Okay. What are we supposed to do?
Yes.
There's merits, yes, and as far as I can tell from this one, with all the things that we've looked at and the points that have been raised, I think the balance is that the benefit of having 4 more outweighs the potential harm. Thank you.
Yes, and also one of the things I wanted to point out was that one of the reasons that Willingham Parish Council gave for objecting was that this would set a precedent. And I wanted to be clear that any decision we make on this does not set a precedent. We, as we've said, at all the other applications, each application is looked at on its own merits. I can see Councillor Sandford and Councillor Heather Williams. So, Councillor Sandford.
Yeah, thank you, Chair. Several references have been made to this being outside the village envelope, and then it sort of moved on to building in the open countryside. Those of us that took the site visit will know this is basically a dumping yard. There's like a shipping container, piles of builders' materials. You saw some of that in the office's photos. So whether or not it was granted permission as a builder's yard, that is in effect what it is. We should treat it as a brownfield site, not as open countryside. Thank you.
Yeah, very good point. Thank you, Councillor Sandford. Councillor Heather Williams.
Thank you. I have to say, I hear the word self-build and I just feel so depressing now. At this, it really is. I mean, we work hard on policies, we work hard for village frameworks, and then we hear, the word self-build or custom build. At least we're getting a variation. We've got a custom build, and then it's just all that work goes out the window. It feels like. On this site, what I will say is at least it does feel like brownfield land. There isn't those conservation area. There isn't any objections other than from the parish council, and I have complete empathy with the comments that Councillor Bill Hanley has made. Entirely, it's a depressing situation, but I can't see a way other than approval for this one. Sorry, I feel so deflated. We've sat here for hours and it just feels really deflated at this point. And yeah, probably need to go to a vote, Chair.
Before we do that, there's some other people who've registered to speak. Thank you very much. So, Councillor Khan.
To come on what Councillor Williams has said.
If I can just make the point, we keep a list of who've put their hands up. So it's not very helpful for members to suggest we go to a vote, because you'll know that once a member has suggested we go to a vote, we should. I am taking Chair's authority to allow the people who registered to speak and are on our list to speak. So please don't do that in a way that...
I didn't make a motion, if that helps you, Chair, but
No,
the amount of times that's been said wrong on the list and nothing said at all.
Councillor Khan's turn to speak. Thank you.
Okay, thank you very much. This development is, as been commented, on brownfield land, clearly brownfield land. It has green pasture to north of it, so in a sense it appears a bit to be in the countryside, but to the west of it there is approval to convert a building, and to the south of it, which perhaps is even more relevant, the piggery has been, apparently has permission to conversion to a traveller site, with a large number, quite a large number of the dwellings, effectively mobile dwellings, are on that site. So it's not really this open countryside and open countryside, and this one is very much affected by development all around it. And the existing site is developed in the sense that it's a brownfield land, it's used as a store, so that's development land. So when we have to consider, there is a pressure for self-build. We have to consider the sites that come before us and have some idea of priority, and where there is a site like this, which has other reasons what you might think that it is appropriate to develop, even though it's outside the built development framework, it seems to me that the case, we're going to have the case for allowing development is pretty strong. I think the issues relating to flooding are at a later stage, when detailed development comes in, the developer will have to demonstrate that the effective provision is provided, but it doesn't seem to me that that is impossible. So I think I jump in favour of this application, approving the application.
Thank you. Before we go any further, can I just check, we already had on our update from the case officer a clarification that 2 of the conditions actually duplicated each other. I think that was 8 and 18. I just wanted to clarify, if I may, condition 22, which relates to shall not be occupied until the approved phase 3 remediation strategy has been implemented in full. And that looked rather like, but possibly slightly different, to condition 13, which says the development shall not be occupied until a phase 4 verification validation report demonstrating full compliance with the approved phase 3 remediation strategy has been submitted. So are those the same or different?
No, they're different. There are 5 standard conditions for contaminated land that you go through different phases depending on contamination and whether they need to do the next phase or not. So no, those are different.
That's lovely. Okay, thank you very much. So any other comment? No, let's go to the recommendation then, which is on page 462, paragraph 11, which is to approve subject to the planning conditions. Do you want to take us through, Rebecca?
Yeah, so as you've said, the recommendations on page 462, 11.1, to approve subject to the planning conditions set out in the report with the amendment to condition 8 as set out in the update report and the addition of some further informatives that are also set out in the update report.
Thank you, Chair. Thank you very much. Okay, so members, let's go to the vote on that recommendation. Aaron. Thank you. So we should be 1, 2, 3, 4, 5, 6, 7, 8. Yep. Okay, so that's unanimous approval. Okay, members, thank you very much. That's approved. Right. Thank you very much for your patience, members. We're now moving on to item 10, which is appeals. Rebecca, will you be taking us through this, or was it just if anybody had any questions?
I'll take the mood of the room. If anybody's got any questions, just to let me know. I was just going to draw attention to the fact for once, we actually have 13 decisions and only 1 appeal received. So the list of outstanding decisions being awaited from PINS is reducing. Of the 13 decisions, 10 were dismissed, 3 were overturned and the appeal was allowed, permission being granted, 2 of which were delegated. 1, interestingly, was a permission in principle, and then there was one that was a committee refusal that has been overturned and allowed for 9 self-build plots. If anyone's got any questions.
But also, okay, so Dr. Timmy Hawkins,
Sorry, is this the one that's at the top of the hill in...
Sorry, which one are we talking
Sorry,
about?
the 2302966 outline. Land of Liden Hill.
Which section are we looking at? Are we looking at decisions notified?
Decisions, appeals,
so appendix 1.
Notified. Page 477.
Okay. Appeals received?
No. The one on the top. Land of Liden Hill,
okay.
Orwell.
Yep. So this is appeal
That
allowed.
was, I think that was one that we refused in committee.
Yes.
But it's been allowed.
If you bear with me, I'll just get you a location plan.
The narrative is refusal of planning permission by committee decision.
Yep, I remember
and then appeal was allowed.
Correct.
9 self-built plots with access and associated infrastructure.
This is the pressure that we're under, isn't it?
Yep, exactly. So I think Rebecca is going to provide us with some information.
That was the site location
Was that
plan.
one? Yes.
Yes.
Yeah.
So that's been allowed?
It's been allowed.
Yeah.
Okay. Was there anything else you wanted to ask about that?
It's just that, we've been talking about self-build and, the pressure that we're feeling. We refused that and PINS has overturned it.
So at least we've got 9 more plots off our list. Okay, so other questions then. I just wanted to thank the officers for the work that they have done relating on page 475 and 476 relating to Grassy Corner Caravan Park, which has been going for a very long time. There was an appeal against the enforcement notice which has been dismissed, for which not only I, as Chair of Planning Committee, but also myself as local member to this site, I'm very relieved about, but also the residents in Fen Ditton, who are right across the river from this, are also pleased that this has been addressed. So thank you very much to the officers, and I observe a real heft going into this work at present of compliance, and we really appreciate. I'd like to convey back to our officers our appreciation for what they're doing with regard to this. Okay, members, that's fine. I don't think anybody's asked for any other questions, so I'm going to bring Planning Committee to a close at 4:46. Thank you very much. Would you like to take us offline?